as newly elected leaders settle into the business of governance. The plenary session of the Law Week of the Premier Branch offer a distinct opportunity for the legal profession to take its rightful place in the interrogation of these all-important issues and proffer practical solutions, not just for governments at all levels, but all other stakeholders in the Nigerian nation. There is an assemblage of distinguished panelists which cuts across the bar, the bench, captains of industries, and experts in economic management, monetary and fiscal policies. The Law Week committee members have worked tirelessly in the last few months to present us a combination of activities which have intricately woven the spiritual with the intellectual, the academic, the social, and the recreational into a knowledge-packed, fun-filled week. It is a hybrid conference which allows virtual and in-person attendance. I urge every member of the Premier Branch, our learned friends in other branches of the Nigerian Bar Association, and indeed other well-meaning professionals and patriotic Nigerians to take advantage of the unique opportunity that this Law Week presents, to create time to break from their normal daily routines and enjoy a uniquely different week that does not take us out of the practice of our profession, but which at the same time affords us opportunities to go spiritual, to learn, to give back to the less privileged, and to impact the Nigerian nation, and to relax. I thank the Executive Committee of the Nigerian Bar Association Lagos Branch for the opportunity given to members of the NBA Lagos Branch Law Week Committee 2023 to organize this program. I also thank members of the Law Week 2023 Committee who have worked and continue to work tirelessly to ensure a hitch-free Law Week program. We also thank our donors and sponsors who have supported this worthy cause. I wish you all a very rewarding and enjoyable Law Week. Thank you.
Thank you, sir. Please give a round of applause. Thank you for that wonderful welcome address. So moving forward, gentlemen, this is the period which we get familiar. So I'd like every one of us to just perform a little bit of tax. Can you just turn to the handsome, beautiful lawyers sitting next to you and just shake their hands and say, welcome to the NBA Lagos Law Week 2023. You look wonderful. Thank you for being punctual. I am happy to be sitting beside you. Oh, I'm seeing the gentleman in glasses. He's not shaking anyone. You're highly welcome, sir. Thank you so much. It's nice to have you here. So next on our category is recognition. Of course, we all know to have an event of this magnitude, there are so many persons who have donated generously. They have made gratuitous recommendations. They have supported us. They have partnered with us in different capacities. And we cannot just continue with the program without recognizing their efforts. So please join me as I make the following recognitions. So to recognize our bronze partners, we have Able Partners, legal practitioners. We have Folashade Ali and Associates. We have Kenna Partners. We have Echo Electricity Distribution Company. We have Kevin Martin Legal. We have Dwale Ovia and Alex Adedipe Associates. We have Simon Cooper Partners. We have SB Joseph and Co. We have Tess Dekar Attorneys. We have Chapitri LLP. And we have George Ikoli and Okabwe. Please let's give a round of applause for our bronze partners. They've done generously well for us. Also next to our silver sponsors and partners, we have Ade Sukon and Co. We have Adedeji Owotomo and Associates. We have Aluko and Oyebode. We have Lekki Gardens. We have Banwo and Igodalo. We have Benchmark and Inc. We have Bank of Industry. We have Geo Sodipo and Co-legal practitioners and arbitrators. We have Grey Chapel Legal. We have the Niger Belt Delta Power Holding Company. We have Are Lawal Rabat LP, we have RT and Co, we have Pan Ocean, we have New Cross Petroleum Limited, we have New Cross Exploration and Production Limited, we have Sterling Bank, we have UNL, we have the Law Crest LLP, and on the list we have Templars. A round of applause for our partners, thank you. And then moving on to our gold partners, yes. These are the ones that their generosity was overwhelming. We have ExxonMobil on the list. We have Olaniwon Ajayi. We have the Lagos State Government and the Ministry of Justice in particular. We have Shell. We have Access Bank. We have AFCA, PrintNG.com. We have ESO. We have Udo Udoma and Bello Osage. We have NNPC. And we have Wole Olanipekun and Co. A round of applause for our partners. Thank you for donating generously to the success of the MBA Lagos Law Week. So once again, can we all remember our theme for today? Can we all say it together? What is the theme of the 2023 conference? Law in a globalized economy. And today there's going to be a knowledge trail, and we're going to learn, relearn, and unlearn, even as we all lawyers, both our seniors in the bar and also young lawyers, will all discover ourselves in how we can be more than the 21st century lawyer in this globalized economy that we are currently experiencing. So moving forward, I would like to call on the vice chairman who will be representing the chairman for her welcome address. Please, ladies and gentlemen, join me as I make welcome Mrs. Abiye Tam George. Please, let's celebrate her. She looks so beautiful for that low applause. Thank you, Mario. Highly welcome.
Thank you so much. Good morning to our very distinguished guests, my lords here present, a very respectful netted silk here present, ESCO members here present, a committee that has put up this very beautiful program, aligning with the 21st century demands. We say a very big thank you to you, sir. Our friends in the media would say thank you. I cannot proceed without apologizing on behalf of the chairman of the NBA Lagos branch for his absence. He's not here with us because something very crucial and urgent demanded his attention. He had sent its regrets. This is something he has planned for the past 2 years to be able to appreciate everyone so far, but he's not here with us. But luckily, I'm going to be reading his welcome address, so we can as well take it that he's here with us, even if not in person. Facing the future, law in a globalized economy. For the second time, I have the rare privilege of addressing you, my wonderful colleagues and friends, at the Lagos Branch Law Week in my capacity as the chairman of the branch. With mixed feelings, I also realize that this will also be the last time I'll address a Lagos Branch Law Week in this capacity. I do not take the opportunity lightly. It is even more gratifying when I consider the captivating theme that the Law Week Committee has come up with, the array of speakers, as well as the events that has been rolled out by the committee under the leadership of Mr. Wale Adesokon SCN. On behalf of the executive members of the Nigerian Bar Association NBA Lagos branch, I welcome all the participants to the 2023 NBA Lagos Branch Law Week themed Facing the Future, Law in a Globalized Economy. You will all agree with me that the world is evolving. Previously, commercial transactions were in the form of trade by barter. Most of us have heard about the use of cowries, manillas, and other forms of commodity money, as well as acceptable means of exchange. Consequently, then, came the era of paper money. Now, even paper money is rapidly fading away, giving way to virtual funds and a cashless society. As the world evolves, so do the people and businesses that make it up. The legal profession has not been left behind. I remember days when our legal juggernauts could go to court with boxes of law reports and bogus case files, all to prove a point. And sometimes, despite the boxes of law reports taken to court, the court may not sit. The lawyer on the other side may not be in court. He might have put in a letter a day before. Or a witness may not be in court for any reason. The result could be that the matter could not proceed. We're witnessing a gradual transition from bags full of law reports to laptops placed on court decks to refer to law reports. We have even moved from there to an era of tablets in court because technology seems restless but constantly makes life enjoyable. If I may say so, it has provided means of court hearings without the presence of all the parties in one place, or having your law report and legislation loaded in your gadget. Rather, with a touch of a button, you can call up any law report or legislation on the internet and serve processes virtually. What about the room given to machines to appear in court as lawyers to present cases because they have artificial intelligence? Indeed, the world is moving, trade is evolving, and economies are developing as globalization and technological development continue to advance. The world is evolving, and the word evolving has repeated itself severally, and I think we need to take a judicial notice of it. And it is doing so fast. The question is whether Nigeria, and indeed legal practice in Nigeria, is moving as fast as expected, or if we are still playing catch up. It is my expectation that we'll dissect these concerns this week. For instance, I expect the recent decision of the Presidential Election Petition Tribunal refusing an application for technology to be employed by all Nigerians to see and hear firsthand what is happening in the proceedings will come up during the discussions this week. Was it an opportunity lost by the tribunal to take a step further in the jurisprudence in line with advanced global practice? I'll leave that to you, our esteemed participants, to decide, whilst I applaud the National Industrial Court for his giant strides in this regard. Well, let me leave this here and allow the discussants and you to make elaborate discussions on how the law, particularly the law practice in Nigeria, is faring under the global transformation and what the future is projected to look like. Before I step aside and allow the eminent discussants to take over, I would like to remind us all that this year again will be having another edition of very innovative career fairs, scintillating in-house and corporate council session, as well as memorable Elders' Night in honor of the immediate past president of the NBA, Mr. Akpata Olumide. We thank you once again. I thank the 2023 Law Week Planning Committee and our distinguished speakers and panelists. I also thank you for participating, being here. I also thank you, for participating. Being here means you are willing to forge into the future and meet the requirements for continuous relevance. Finally, I want to thank all our sponsors for graciously donating to this event. Without you, we will be worried about how to actualize this program. We're grateful. Welcome to the 2023 NBA Lagos Law Week. We thank you once again for your presence.
A round of applause for Mrs. Tam George, please. A round of applause. If you're just joining us, you are the NBA Lagos Week 2023 conference titled Facing the Future, Law in the Globalized Economy. And I believe that Mr. Wale Adesokan, SAN, aptly summarized this conference when he said that the activities have woven the spiritual with the intellectual, the academic, the social, and the recreational into a knowledge-packed, fun-filled weekend. A round of applause for Mr. Adesokan. I think that aptly puts together what to expect at this conference. Now, we're moving on to our keynote speech. Our keynote speaker is the Group Chief Executive Officer of Access Holdings PLC. His journey began with a degree from the University of Nigeria and went on to earn an MA in Banking and Finance from the University of North Wales and MSc in Financial Economics from the University of London. He's also an alumni of the Harvard Business School Executive Management Program. His journey began at Coopers and Lybrand, and eventually he joined GT Bank, where he was for 10 years. And finally, him and his partner at the time bought Access Bank, which was ranked 65th largest bank in Nigeria in 2002. He took over the role of Group Managing Director and CEO in 2014, a position he has held until 2022. And in that 8-year period, he has steered Access Bank to become Sub-Saharan Africa's largest retail bank by customer base. Please a round of applause for Dr. Herbert Wike, CFR, who is ably represented by Mr. Amechi Okobi, the Group Head, Corporate Communication, Access Corporation. A round of applause for him, please. Mr. Amechi, please.
Thank you very much. Thank you very much, and good morning. Unfortunately, Herbert couldn't be here today, but he asked that I express his apologies. I should tell us all off for not starting on time, but I won't. Herbert really did want to be here. This is something that's really, really important. And the future of law in this country and beyond is something that he's quite passionate about. So to all of you, I apologize that he's not here. He gave me a speech to essentially read, which I will with your permission. The current era of globalization should not have come as a surprise to anyone. It didn't happen overnight. In fact, the signs that began to point in this direction 263 years ago, to be precise. In 1760, Europe was undergoing many changes, but the change relevant to my topic today is the beginning of the Industrial Revolution that set us on the path towards achieving a worldwide economy. How did this happen so quickly? 263 years is not a very long time to go. From subsisting on a farm and bartering with others for what we couldn't produce ourselves to modern life today. Advances in transport and telecommunications had a huge impact. With increasing trade and communication, more and more companies began extending their reach beyond their own nations. Simultaneously, over the course of the 20th century, capitalism preserved its momentum by exposing the ordinary person through advertising to an enticing array of products, and marketing became a thing to manage. The consumer was created with an unquenchable thirst for more stuff. For manufacturing, the availability of the most basic communication technologies enabled corporations to establish production facilities globally, helping them to significantly reduce costs. Later, the shift to digital in manufacturing impacted the way companies were able to communicate with each other. Worldwide locations meant access to new markets, as well as shortening supply chains. Keeping manufacturing and production flexible and incorporating automated technologies cut production times and allowed companies to respond faster, increasing their competitive advantage. Therefore, for 263 years, industrialization opened up the world for international business. From this time on, the world economy began to integrate, and regions became more dependent on each other. Yet, despite these exciting few hundred years of development and opportunity for people like you and me, globalization has created a highly complex world. The theme of your conference this week is similar to a theme which many conferences this year, and I suspect for years to come, will tackle. You are asking the important question, what are the implications for the law in a globalized economy? Isn't that another way of saying, are the laws that existed 263 years ago still valid today? Or has the law kept up with the light year progress of technology and its resultant international opportunities for business transactions? I think we should all say probably not. There are many who think that the US Constitution, signed 236 years ago, is outdated. The Statute of Marlborough was passed by the Parliament of England during the reign of Henry III in 2067. These laws comprise 25 chapters, of which 4 are the oldest pieces of statute law in the UK still in force in 2023. And what of the billions of international transactions occurring daily across borders in our world that 263 years ago were not even thought of? The challenges for the law is to stay relevant in a remarkably fast-changing world. And your challenge is to modify or replace laws that no longer serve while operating in a legal system, not known for being nimble. Your task as lawyers is indeed a mammoth one. There isn't a single industry unaffected by globalization, and there is not a single industry not grappling with the same challenges. We in banking and finance constantly ask ourselves variations of the same question you're asking yourselves today. We ask, what are the implications for banking in a globalized economy? The speed of technological change and industrial globalization are not isolated phenomena. All dimensions are affected, including economic, political, social, and cultural aspects. We are now living in a completely globalized world, and we are seeking new mechanisms and values to deal with this new world. Our new reality is global interconnectivity and an interdependence of countries, economies, cultures, and societies worldwide. Let me touch on each of these. Economically, the integration of national economies into a global network is characterized by the free flow of goods, capital, and labor across borders, facilitated by trade liberalization, the establishment of global corporations, and the growth of global financial markets. Politically, globalization has led to increased cooperation and intergovernmental relations. International institutions like the United Nations, World Trade Organization, and the IMF, to name a few, play pivotal roles in promoting global governance, setting standards, and resolving disputes between nations. And as with most things, globalization brings advantages and challenges. On the positive side, it has facilitated economic growth, increased access to goods and services, and fostered innovation and technological advancements. It has opened up opportunities for the international trade and investment, creating jobs and raising living standards in many parts of the world. It has enabled the sharing of knowledge, expertise, the best practices across borders, leading to advancements in various fields. It has facilitated the resolution of global challenges such as climate change, terrorism, and pandemics through collaborative efforts. Socially and culturally, globalization has brought people from diverse backgrounds closer, facilitating the exchange of ideas, values, and cultural practices. However, globalization has posed challenges and risks. Economic globalization has led to income inequalities and disparities between nations, with some regions benefiting more than others. It has contributed to outsourcing of jobs, the erosion of domestic industries, and the concentration of economic power in the hands of multinational operations. It has raised concerns about environmental degradation, exploitation of resources, and the impact of local communities and cultures. And of course, the increase in international trade has also created a host of opportunities for illegal and shady practices. The legal implications for a global world are vast, and I would like to comment on a number of these through the eyes of Access Bank. Many of you will know that Access Bank started as a small national institution. Our path to becoming the international powerhouse we are today means we expanded our operations into multiple jurisdictions, all with different regulatory frameworks. Let me go through a sample of the legal challenges we have faced. Each country we enter has its own banking regulations, licensing requirements, and compliance standards. As we expanded, it became critical that we navigate the complex web of regulatory requirements and ensure compliance with multiple jurisdictions. it is necessary for us to understand and adhere to anti-money laundering laws, customer due diligence requirements, capital adequacy regulations, data protection laws, and consumer protection regulations, among others. As a global banking institution, our business involves billions of cross-border transactions, such as international transfers, foreign currency exchanges, and trade finance. We constantly navigate the intricacies of cross-border regulations. Operating globally means dealing with different legal systems, contractual laws, and dispute resolution mechanisms. We must be well-versed in the legal nuances of each jurisdiction we operate in and ensure contracts, agreements, and practices align with local laws. Global banks handle vast amounts of sensitive customer data. Period. Today, we have over 55 million customers, and the data and information that come from that number is phenomenal. We are required to comply with data protection and privacy laws in each jurisdiction to safeguard customer information and maintain regulatory compliance. A globalized banking environment means regulatory coordination and cooperation among jurisdictions is crucial. Banks can face challenges in managing regulatory expectations and coordinating compliance efforts across multiple jurisdictions. Developing effective relationships with regulatory authorities and staying updated with global regulatory changes is essential for successful expansion. Banks going global must address cybersecurity risks and comply with evolving technology regulations. Protecting customer information, preventing data breaches, and implementing robust cybersecurity measures are critical. We must navigate regulations related to electronic banking, online transactions, digital identity, and electronic signatures, ensuring compliance with local laws that govern technology use in the financial sector. Banks are constantly at risk of being used for money laundering, terrorism financing, and other financial crimes. Global banks must have strong AML and financial crime prevention frameworks in place, including robust know your customer procedures among transaction monitoring systems. Banks operating globally may consider disputes with customers, counterparties, or regulatory authorities across borders. Dealing with cross-border disputes involves understanding international dispute resolution mechanisms and navigating the legal complexities that arise from the differences in legal systems, jurisdictional rules, and enforcement of judgments. It's enough to make your head spin, isn't it? Needless to say, addressing these legal challenges require comprehensive legal expertise, a strong compliance culture, and effective risk management strategies. At Access Corporation, we dedicate resources to understanding and complying with the legal and regulatory requirements for each jurisdiction we operate in, and work closely with the legal compliance professionals to ensure adherence to international standards and best practices. In this era of rapid change and increasing complexity, your roles as lawyers extend far beyond traditional boundaries. As well as the examples I've given that affect bankers, you must also understand the economic forces that drive globalization, including the impact of technological innovations, evolving business models, and shifting market dynamics. We all have a responsibility to leverage our legal expertise and engage with key stakeholders, governments, international organizations, businesses, and civil society to shape the legal frameworks that govern the globalized economy. By fostering collaboration, promoting legal certainty, and advocating for justice and fairness, we can ensure that the rule of law remains the cornerstone of a sustainable and inclusive globalized economy. So what does this all mean for the future of the role of law in a globalized economy? Obviously, it means a lot. In a globalized economy, few, if any, areas of law are not affected. With diverse legal systems in each country, the standardization of laws are imperative to facilitate international trade and investment. If we are to encourage engagement in a cross-border trade and investment, a globalized economy needs legal systems that offer certainty and predictability to businesses. Parties need to know that they can rely on the law to resolve cross-border disputes and protect their rights. Therefore, robust legal frameworks, and effective enforcement mechanisms are needed. In a globalized economy driven by innovation and technology, protecting intellectual property rights is crucial. The harmonization of IP laws and effective enforcement mechanisms are essential to combat infringement and piracy, providing confidence for the exchange of ideas and knowledge across borders. The digital age has introduced new challenges concerning data security and cybersecurity. Laws and regulations that address data protection, privacy rights, and cybersecurity are essential to build trust among individuals and businesses engaging in cross-border data transfers. Legal frameworks that encourage corporate social responsibility, environmental protection, and ethical business practices are needed to promote sustainable development and long-term viability. Laws and regulations that address issues such as climate change, human rights, labor standards, and anti-corruption plays a crucial role in shaping the behavior of businesses operating globally. In summary, the key imperatives of the law in a global economy are many. I'm proud to say that recently I completed my master's degree in law from University of London. I'll be honest with you, I'm certain you will all relate. The program was extremely exhausting. There are definite times when I wished I never started, but today I'm glad I did. The program has provided me with deeper insight into the complexities of law in a globalized economy. As a banker who has led the expansion of an institution across Africa, Asia, Europe, and the Middle East, I have witnessed firsthand the impact of globalization on businesses and economies across countries. I have seen how legal systems must adapt to accommodate the rapid pace of technological advancements, the challenges of cross-border transactions, and the complexities of international regulations. Globalization is our new reality, but it shouldn't be a surprise to any of us. The science began 263 years ago. The rule of law has been traced to exist as far back as the 4th century BC in Athens. In 2023, to help us tackle the threats we face as we negotiate a successful future in a global world, to help us seize the opportunities as we build a safer, just, and more sustainable world, the rule of law is still the foundation we desperately need and rely on. Thank you very much.
Thank you, sir. Please, once again, let us celebrate the representative of Dr. Herbert Wigwe, the Group Chief Executive Officer of Access Bank PLC. I think that was one of the most incredible keynote address I've ever heard in any conference. Thank you, sir, for blessing us with such knowledge. So, gentlemen, we know we started the conference quite early, and of course, we have to get break first. So, we'll be allocating the next 30 minutes for a tea break section from 10 a.m. to 10:30, where we'll reconvene to continue and kick off our first plenary section. So, do have a wonderful tea break. Thank you. Okay, so the organizers have brought. Okay, so the organizers have brought the prompt notice, and they are still coordinating the logistics for the tea break, so we'll have to go on with our first plenary section. Yes, please, just a minute.
Speakers.
Thank you, gentlemen. Please, can we all settle down? Thank you. So if you're just joining us, once again, you're welcome to the 2023 MBA Lagos conference. To proceed with our first plenary section, it will be very important to make some introductions. Please, can we have the moderator on stage? Let's give an ovation for Mrs. Titi Lola Akinlawon, SAN, the managing partner of Akinlawon and Ajomo. Please, let's give a round of applause. She'll be seated right here, while the rest of our panelists will be seated over there. Thank you, Ma, for gracing us with your presence. Now to introduce our speakers. The first speaker for this section is Honorable Justice Olayinka Faji, the Administrative Judge of the Federal High Court, Lagos. Please, a round of applause for the Honorable Justice. He'll be joining us shortly. Yes, he is. He'll be joining us upstage shortly. The second speaker we have here is Honorable Justice O.A. Ipaye, Mrs. A Judge Ipaye. Great, I stand corrected. The Judge of the Lagos High Court. Thank you for joining us, Ma. You're highly welcome. Mr. Rotimi Seriki, SAN, the Managing Partner of Rotimi Seriki & Co. You're highly welcome. Please, let's make the ovation more enthusiastic. Let's show them that we value their presence here. Thank you. And our final speaker for today is Mr. Sylvester Udemezwe, the lecturer in Nigerian Law School, Lagos campus. A round of applause as you join us. And for this section, the topic is the globalized economy and the integration of the Nigerian judicial system. I believe we'll have the best learning experience, so let's bring out our jotters, our pens, open our ears to listen and grasp knowledge as we begin our first plenary section. Mrs. Titi Lola, thank you for joining us, Ma. You don't need my mic? Oh, you need? Okay. All right. Thank you, Ma. Please, our sound system, please check if her mouth.
Oh, wow. Okay. Don't finish us. Okay, it's a pleasure welcoming everybody to this wonderful session. We are talking about integration of the Nigerian judicial system into a globalized economy. And as we have heard from the keynote speaker, globalized economy presents numerous challenges for legal systems. This includes harmonizing laws across jurisdictions, addressing cross-border disputes, and ensuring fair and ethical business practices. However, it creates opportunities for legal professionals to specialize in international law, facilitate cross-border transactions, and advocate for global standards. So, without wasting too much time in introducing what the Nigerian legal system will do in integrating global standards in our systems, I will first of all pose my question to Honorable Justice Yinka Faji. Now, we've heard about globalization, we've heard about technology, we've heard about AIs and what have you. Can you please explain to us how technology can enhance the integration of Nigerian judicial system in a globalized economy? Particularly when we consider the decision of the Presidential Election Tribunal about not allowing recording and recording of the proceedings. So I would expect that, I don't have a guide. I thought I would have a guide about timing because I like to keep within time. So you have 5 minutes to please give us these, your thoughts on this. Thank you.
Thank you very much, Lynette Senior. Good morning, ladies and gentlemen. As you can see, I'm all wired up, and I can't wait to get out of this before I suffer an electric shock. Yes, it's a nice idea to have been asked to speak at this event, and I feel very, very honored, and I'm excited that I'm here to once again share my thoughts with a broad spectrum of the legal profession, particularly the Nigerian Bar Association Lagos branch. It is not in dispute that the nature of judiciary you have in a country affects the kind of foreign direct investment that you get in that country. And it's not also an issue that now the world is now a global village with digitalization and advancements in technology. So basic things like, withdrawing money from the bank, online shopping, things like electronic, automated vehicles, automated ships are now in vogue. I cannot imagine whether this was ever thought of 30 years ago. Of course, activities in the metaverse also is trying to create a new world. Probably what technology will not be able to do is to make us eat online. I had some kind of intro to the way people now think, particularly lawyers, when it comes to technology. When some of the law school students were in my court about 2 weeks ago, and one of them stood up in my interaction with them and said, "Sir, how do I practice as a tech lawyer?" And I said, "Oh, really? There's something like that now?" He said, "Yes." I said, "Well, first and foremost, you must study law. And then probably, I do not know whether you also need to study computer science, but I know that one of the challenges we have with the interface between law and technology is that we have not been able to interact with the various areas of knowledge that are relevant to technology and law." Then, when I was going through the brochure for this event yesterday night, I saw a firm called, let me look at it, Tech Lawyering. And I said, yes, we're getting there. I was right in thinking about this topic. But I think in looking at this thing, we must rise above our local challenges and consider the bigger global picture and think about the role of technology in how we can enhance the judicial system in our country. Of course, all over the world now, the movement is towards tech. And of course, there's also the idea of online courts, which is now gaining so much ground. And two broad ideas come up in the area of online courts. Are you trying to automate the system you already have now? In other words, you are able to file your pleadings online, you're able to assign for judges online, you're able to read your files online? Or are you going to transform the system in such a way that it becomes compliant with the current day situation? That could be disruptive, and that is something lawyers don't like. Lawyers like a comfort zone. We are very, very bad at taking risks. Should our processes be as old as our principles? 1660, the rule in Barnard's case, the rule in this, and all that. Is that how we should continue operating in this day and age? Those are the issues which come up when we are looking at the integration of the Nigerian judicial system in terms of technology. I've spoken about online judging, use of technology now to extend the reach of the average person to the judicial system. In other words, you are able now to file your processes online, particularly for people who are not represented by counsel. You're able to track the process of your case online. That is what online judging, online courts are thinking about. How we get there is another issue, and that is something that we should look at happening within the next 30 years. I hope it happens during my lifetime. We also have the idea, of course, what we're all familiar with now is the concept of e-filing. I know the Rivers State High Court does e-filing now. No,
it's not possible at all. Sorry.
No, you're wired, so I'm hearing what you're saying, sir. I sat next to a Rivers State High Court judge and he said, "My lord, look, if they file a counter affidavit in the process before me now. I'll see it on my phone. I say, oh, really? So that's what e-filing is about. And of course, the National Judicial Council also has an e-filing project, which the Federal High Court is keen into very, very soon. Ladies and gentlemen, very, very soon, the Federal High Court will be inviting lawyers to be trained on how we'll use our e-filing platform. I'm very proud to say that, and I'm sure that all of you will be glad to join us.
Oh, well,
yes.
That is good to know.
Yes.
That is good to know, but, well, maybe you would have you thought about considering the infrastructure, the backbone that you require for you to be able to accomplish this, and how, as you have said, how will that enhance our practice within the court system?
Well, enhancing our practice within the court system, I'm sorry to say this, when we go online, we now have online courts. Some of the work hitherto done by lawyers will no longer be done by lawyers. Self-represented litigants can actually interface with the court. We can make use of AI, artificial intelligence, to guide non-lawyer litigants to think about their cases, to know the strength of their cases, and to know how to proceed. Infrastructure is a basic issue, and we really need to work on that. Electricity, internet connectivity, internet penetration, and things like that are matters which we must look at very, very carefully. And also, education of lawyers, education of court staff. Do we really have the court staff who can be trained to do this? I can tell you that, and this is for free, that in the Federal High Court, we do make a lot of use of technology now. Those who are familiar with my courts know that I use a lot of technology, even if it's just WhatsApp, but it's technology. So I think what we're looking at is, we're looking at the ideals and looking at how we can work towards them. And it's very, very good for us to identify the challenges that could have on the way. One basic challenge is infrastructure. One other challenge is, of course, knowledge. One other challenge is the reluctance of lawyers to accept change. Lawyers are very, 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 very slow in accepting change. We see the court as a place and not as a service. The court is a service, not a place. So you don't have to come to Court 2, Federal High Court Ikoyi, for your cases to be heard. You don't need to go and file cases in Federal High Court and be challenged with issues of remitter for your cases to go on. So clearly, our current mode is not sustainable. In my own docket, I have about 880 cases, and I have the least number of cases. I have colleagues who have 1,500 cases, and the cases keep coming. And I just wonder, when I'm assigning the case, I say, how will Justice Alagba do this work? Anyway, when we give him the work, he will do it. So the present model is definitely very, very deficient. I've spoken about the attitude of lawyers. Is it a matter of irrational rejectionism or crude protectionism? I copied these words from a book by Mr. Susskind on online courts and the future of justice. I've also said, should it be a place or a service? Talking now about online courts, we also have what we call online dispute resolution, yes, which is the adaptation of technology to ADR modes. Yes. We're talking about online courts. We're looking at online judging, for instance. You file your processes, the other side files its processes, they are sent to the judge gives a judgment and just sends it back. There's no hearing. That's online judging. Now, the use of technology to enhance the reach of people to the court system is where you have platforms on which people can actually put their processes, or with the use of AI, find out what it is that they are supposed to do to be able to file a particular case, and then at the end of the day, they're able to file it.
Thank you very much, Justice Faji.
Yes.
I know you still have more to say, but I'm very conscious of time. I was looking at the time allotted to you. Maybe we'll have time for you to take us through what remains in your dockets there.
Thank you very much. I'm glad that I've been able to at least deliver.
Thank you. Now, the next question I'm going to pose to Justice Ipaye. The Nigerian judicial system is notorious for inordinate delay in resolving disputes. It takes an average of 25 years for a dispute to be finally resolved by the Supreme Court. What would you suggest as the way to reduce this time to facilitate foreign direct investment in Nigeria in this day of globalization? A lot of people don't want to bring their products to Nigeria because we have terrible judicial system that is notorious for delays. What would you suggest?
Testing. Let me confirm whether I am wired up.
Yes,
Can
you are. You are.
Right.
You are. We can hear you.
Let me first of all express my delight to be here this morning amongst the members of the noble profession. There's no other profession as noble and as articulate and as rigorous and vigorous as the Nigerian Bar Association, especially the Premier Bar. And
of course,
let me also say that I must also give you a minus somewhere, and that is because of your delay in reaching out to me to be a part of this program. I mean, I'm right there. I'm in the Lagos division. I'm the admin judge of the Lagos division, and I get this invitation in a roundabout way at the last minute. And I think this is about the second time I'm having to take up arms with the Lagos Bar. But nevertheless, I am so
sincerely
delighted.
apologize for that.
I am so delighted to be here. Let me also say that I concur with everything that my brother from the Federal High Court has said, and I adopt all of his sentiments as mine. Now to go to my own question proper. Yes, I agree. Dispute resolution by way of litigation in Nigeria it's getting out of hand. The slow pace at which the wheels of justice turn, it has become scandalous. And we don't even want to reel out the statistics. If we look at high-profile cases, just Google it. You look at the corruption index, that they have a database. High-profile corruption take 3,000 days in courts before that for courts to even give a judgment. Meanwhile, they would have gone up and down the appeal system, fighting for one thing or the other before they come back and take their trial. This is very scandalous. I will not accept that the fault is the bench. The fault is with you guys, is with the bar, because you are the ones who challenge everything. The frivolous appeal, the needless appeal, you do it, you entertain it, you take it back and forth, and yet you still come back to the trial courts. All of this is not sending a good signal. It is affecting, you know, all the things that it affects. These days, I even hear that everybody knows when you can enter into the legal system, but you are not sure of your exit plan. You are not even sure whether you will exit. There are some cases that we hear that they fight over jurisdiction. They take it to the Supreme Court. At the end of the day, it's a labor matter. At the end of the day, both the Federal High Court and the State High Court, we were even robbed of the jurisdiction. The matter had to go de novo at the National Industrial Court. And this is all part of the problem. First of all, and I think we really have to talk to ourselves here. If we really mean business, yes, lawyers are conservative people. Lawyers, you know, I don't want to use the word one-track mind. We don't like change. You know, we don't embrace change easily. But we must change our mindset. And that is, we must think of ourselves as dispute resolvers first. We cannot be thinking of ourselves as, oh, litigator, I must have a day in court. You know, we must explore and adopt and embrace other dispute resolution mechanisms. These days now, most courts have adopted the multi-door courthouse model. This is a model that was introduced sometime in 1967 by the American professor, Professor Frank Sander, I believe. And he began to articulate it even in the United States of America. That, look, the courthouse cannot provide just the litigation doorway. We must have different doorways. Just like if you go to a hospital, it is when the general practitioner sees you, sees your symptoms, then he will say, no, okay, you need to see a cardiologist. He will shunt you there. Do you find it when he says, go and see the cardiologist? You don't. If your case needs to be ascertained by a renal specialist, then you concede. Just like what we've been trying to introduce even in Nigeria. Lagos State was the first court to, come out with this kind of a mediation into our services. In fact, it got so bad that we had to compulsorily select cases right from the registry and put them on the mediation track. But what do we get? We still get lawyers. They will fight that process. They will go to the mediation. They are not cooperating. Then the matter comes back to the court. So, instead of diverting cases from courts, it's coming back even into the court. So we're not making as much progress as we ought to. So these are the kind of things that must change. Right from the law faculties, they really need to be taught the negotiation skills, mediation skills. I remember we came up in our rules with pre-action protocols. These pre-action protocols, they have to have been designed by the Bar Association itself. But we find that it's the bench that is developing this protocols to encourage lawyers to first of all think negotiation before you rush to court, before you say you are filing a writ. Think negotiation, write a letter, understand the other side, reach a kind of fellowship or whatever it is you want to reach out, and kind of negotiate. We have claim-specific protocols, we have the general protocols, all of which are designed to change the way lawyers think. I also had the benefit of having law students in my court for their externship sometime a couple of weeks back, and it was like they knew nothing about dispute mechanisms. And from time to time, when they're in my court, I'll say, okay, this case that we looked at, how else do you think it could have been resolved? What are we doing? Why are we wasting the time of the judge resolving a bank and customer dispute? Did you not go to the bank and take the money? Hey, when it's time to pay up, you can't pay up. Then you negotiate with the bank. More time. Why must that become, such an entrenched issue that we want to fight in the law courts? And then these days, what I'm even seeing is that it's the debtor that will rush to court, first of all, and you know immediately that it is just to tie on that case in court, so that the bank or the creditor never smells the money. These are kind of things that ought not to happen. I would advocate, as I said again, the embracing of alternate dispute mechanisms. We have tried so many things. We've improved our civil procedure rules, even criminal justice administration rules. We've introduced so many things, if only lawyers would allow it to work. Perhaps, again, I want to suggest, maybe the time now is ripe for us to have definite timelines for case dispositions. We all know what happens in the election tribunals. They have just 6 months, 180 days to conclude their case. A typical land dispute, it goes on forever, at least as far as I know. I've done my fair share of handling, 10-year-old, 20-year-old cases. But if we have, in addition to,
Thank you very much.
In addition to the protocols, if we have definite timelines for case disposition, then we all agreed. Land dispute, go and do your dispute plan. Then come back, come and determine who has the better story to tell, in your traditional history, or who has the better documentation. We'll look at it. These things should not take more than, maximum 2 years.
Thank you very much. That's a very novel one.
If we begin to pursue it, then we begin to farm up our times.
Thank you. That's a very good one. Probably because I'm a land litigator, I spent so many man-hours, years actually, in the courts trying to prove who is the rightful owner of a property, of the land. I can tell you, it's very frustrating. Now, Mr. Seriki, SAN, I know that you get involved in a bit of arbitration. So, from taking it from what Justice Ipaye had discussed, we now found that even in arbitration, which used to be a quick way to resolve commercial disputes, is now being clogged in the courts by grant of settling or setting aside awards for various reasons, and even stay of execution of the awards. What should the courts do to eliminate these delays in enforcement of arbitral awards?
Thank you very much. Good morning, my lords, learned six members of the bar. I think the starting point is that the Arbitration Act itself makes provision for enforcement of arbitral awards at the courts. It's not a self-executory process. And also, for purpose of setting aside, the aggrieved party is at liberty to apply to the court for an application to have it set aside. I think part of the challenge is that in drafting the Arbitration Act, I'm not sure whether the new Arbitration Act addresses that issue. We need to devise a process whereby if there's any aspect of the arbitral award that has to go to the regular courts, we have two options. Is either we have a time limit for determination of such issues, whether setting aside of the award or issue bordering on the enforcement. The other option is that, which I think can also work hand in hand with the time limit, is that we should limit the levels of courts that get involved in the enforcement of arbitral award issues. I do not see why issue of enforcement of arbitral award will go all the way to the Supreme Court. Because these are processes that are initiated by applications. They do not require any form of trial. So, and based on the proceedings before the arbitrator and the record of proceedings, I believe the issues would be clear. But I'm sorry to say, most of us as members of the bar, we exploit that lacuna, especially when we are acting for the party who was not favored by the award. So we then exploit it to drag. I have one I'm doing right now. The dispute involved development of a land. The developer did not develop for 9 good years. He did not even get building plan approval, yet he commenced construction on the land. We went to arbitration. We declared a dispute, hoping we will be able to sit down and resolve the issue amicably. Now, he was the one that went to file the proceedings. So we then became respondents, even though we were the one that declared the dispute. At the end of the day, an arbitral award was given, asking him to vacate the land, and then for the respondent to take back their land over a decade. They've now gotten another council to file an application to set aside that award. They are raising issues of misconduct, issues of public policy, but really, in substance, if you look at the grounds they are relying on, they are more or less challenging the findings of facts by the arbitrator. So they are now coming under the cover because the law says you have limited grounds on which to appeal. They now couch the grounds to suit their own purpose. And at the end of the day, it's the party who has won at the arbitration that is at the losing end. And I have a feeling that at the end of, if they lose at the High Court, they will go Court of Appeal, they will go to, so how many years is it going to take? Even if there had been no default in the first place in the development project, the number of years we probably spend on litigation, the owners of the land would have derived benefit from the use of that land. So I think we as council, for the issue of delay in arbitration, the bulk of the blame is on the counsel, because the arbitrator has concluded his assignment by delivering the award. So, but we as counsel are the ones that drive this process of delay in the enforcement.
Okay, thank you very much, Mr. Seriki SAN. So I guess the issue here is about us, the lawyers. We are the ones that fuel delay, basically, because I know that in the court system, is the day trial is supposed to commence, that the lawyer would be absent from court and the rest of it. And I think the problem can be solved by the Bar Association imposing sanctions on lawyers. Even when you file cases that you know that should not be filed. I mean, it's only in our jurisdiction that I know a lawyer will go to court to file an action when you know that there is no basis for the action. Just to delay, just to protect a client that is not willing to comply with his own terms of an agreement. It's so bad. So I think the one thing we can get away from this question of delay is us lawyers to start disciplining ourselves in respect of taking frivolous applications. I mean, you imagine a situation where a client will just come in and say, lawyer, this land is my father's land. Can you get me an injunction to stop this person from building? How can you go to court to get an injunction when you really have no cause of action? You have no right. You have no legal right. And then you find some lawyers who file such a case and continue to delay. Why should you appeal, or why should you apply to the High Court after going through an arbitration process? Why? I mean, I just look at it that it doesn't make sense. Everything, they will round it around misconduct or mismanagement of facts or something. It's so bad. I think the regulations of our profession should include such a thing. If it is found at the end of the day that you had no business going to court and you did attend court, then you should be sanctioned. We will sit up. And then the number of cases that we have in court will greatly reduce. The way we're going on, I say to myself, it's like the end of the profession is in sight. Because when litigants themselves will be the one that will tell a lawyer what to do, we're in deep trouble. Now, Mr. Silva, I know you are very popular among the law students, our law lecturer, Mr. Sylvester. So I would want you to look at the issue of conflict of laws. When we have globalized economy, different nations are involved. The law in the UK relating to enforcement of contracts or whatsoever, and the Nigerian law is maybe divergent. So in a situation that we have the Nigerian judicial system, in the Nigerian judicial system, how do we resolve the issue of conflict of laws that may arise in dealing with international trade disputes?
Thank you very much. I'm very grateful to have been invited to participate in this session. I would like to correct I was addressed as a lecturer at Nigerian Law School, Lagos campus. Yes, I was in Lagos campus, but I'm no longer in Lagos campus. So I was in Lagos campus for 12 years, but I'm in Bayelsa campus, Yenagoa campus. So I needed to correct that. I'm very grateful because I am happy with the topic being discussed. Before I to offer my opinion on the question you have asked, I would like to suggest that, with due respect, that I do not think that the unacceptable delay in administration of justice in Nigeria is caused by only lawyers. is caused majorly by judges and the courts. Now, and I'm very sorry about this. No, because we are here to proffer solution to a very serious problem. So one of the problems, in fact, I give 60% of the problems, the cost of the problems, to the judiciary in Nigeria. Now, my lords that have spoken eloquently and, of course, had educated us on a way out of these problems. But I would like to suggest to my lords, since they are here, that there is need for them to do a kind of soul searching. The legal profession in this country is dying. In fact, I'm happy with the topic, globalization. When I tried to research on how to integrate the justice system in Nigeria into a globalized economy, I was in tears because I was thinking about what I was going to say. The truth of the matter is that we are just at the back while the world moves on. But the problem I have when I was coming here is, okay, this is not the first time we have offered beautiful ideas on how this could be taken care of. If you touch NBA, they will tell you that, look, we are not a cohesive organization. We cannot do anything. We are not a government department. You touch the judges, they will tell you this is caused by lawyers. At the National Assembly, there was a proposition to end extension of time, to put a timeline. They voted it down. That was last year. During the constitutional amendment, it was voted, they voted against it. Massively, everybody voted against it, that they didn't want any timeline. But their own cases at the National Assembly, they are decided within 1 month. But ordinary people, they spend 30 years. Imagine a case of validity of quit notice had to last 29 years. Whether a quit notice was valid, was in court for 29 years. How can such a system join the globalized economy? We can't even be talking about it. We are talking about how we are going to wake up from our dead state. So my conclusion is that we can't be discussing about joining the globalized economy because we are 100 years back. And that was why, I'm sorry, my Lord, I was trying to, because my Lord said he hoped that within the next 30 years. And I said, 30 years, that means our profession will be dead by that time. Because we are not moving at all. We are just stagnant. That is the truth. For example...
Okay, sorry. I think what you need to tell us is not to rehash the problems. We all understand the problems.
Yeah, thank you
Just
very much.
tell us solutions.
Yeah.
That's what we're
Thank you very much,
for.
my Lord. So
yes,
my suggestion is that the NBA and the regulatory authorities in the legal profession will need to take this matter head on. Since it is clear, because in other jurisdictions, this is spearheaded by judges. In fact, in Malaysia, it was the chief judge of Malaysia that spearheaded the reforms that made it impossible for any case in Malaysia now to spend 2 years in court. And when I say 2 years, I mean from the court of first instance to the last court of the land. From the court of first instance, no case stays more than 2 years. Anybody can research. In Malaysia, it was the chief judge of Malaysia.
But because
he didn't go. So my suggestion to the NBA, my suggestion is that NBA would need to take this matter head on because lawyers are the people who bear the brunt of what is going on. And the only suggestion there is that there are many factors that give rise to this. So I'm suggesting that NBA, even if it means liaising with members of the National Assembly, lobbying them, going to meet with them to let them know the problem we have on our hands so that there could be a bill. What my Lord suggested is one very vital way of dealing with this cankerworm. Putting a timeline, not necessarily 6 months, but at least but you can't put a timeline when you don't have sufficient number of judges.
Mr. Demenze, you have left my question and you have gone into something else. I would still want an answer to the question that I asked you.
Let me leave it. Maybe I would be able to come back to it later.
When you have your parting shot.
Suggestion.
Now, I asked about issues of conflict of laws. How do we resolve that?
Now, we all know that in a globalized economy, because of the sovereignty of states, every state has its own legal system, and they operate within their legal system. So when we talk about vertical operation, for example, in Nigeria, the Supreme Court is the highest court. And once it decides a case, no other court, even the decisions of the ECOWAS courts are hardly obeyed by Nigeria or by countries within the ECOWAS sub-region. Now, it becomes very difficult, for example, for a court in Nigeria to have the opportunity of integrating with a court in America. So what I've found out is that the one way that we'll be able to deal with, accelerate or ease the bottlenecks we have in dispute resolution on the international arena is to try to amend our laws in Nigeria, for example. And I will give just a few examples because there are too many of them. Number one, this issue of reciprocity in enforcement of judgments, there is a problem. The procedural steps, the processes and procedures for registering judgments obtained outside the country in Nigeria before they could be enforced in Nigeria is too cumbersome. I happen to be teaching, one of the courses I teach at the law school is civil litigation. And we talk about enforcement of judgments. And when you go through the procedure for enforcement...
Please, that enforcement of judgment is something else we are coming to. I was looking at you advising us on how we should determine what the proper law of a contract is. How do we determine what the proper law is? How then, which of the various laws that will come into international trade, how do we come to terms with which of these laws will have to apply when there is a dispute within the judicial systems?
Thank you very much. Now, with respect to international trade, judging from the fact that most companies could be in one country and have businesses or extend their tentacles to some other countries. Like I have said earlier, it may not be possible most of the time, but we have treaties. There are many treaties that relate to trades and trade practices all over the place. So my suggestion is that, judging from the sovereignty of states with respect to their legal systems, I think that since a company can stay in one country and operate in several countries, the best thing to do is to determine, to use the law of the state or the country where the dispute arose to be the deciding law, the law that will govern resolution of the disputes. So if a country like Amazon, for example, is in America and operates in Nigeria, and then has a problem in Nigeria, like the problem between the Nigerian government and Twitter, for example. Now, I think that the country where the cause of action arose should be the country whose law should govern. But then our courts needs to begin to take, and this is happening a lot in the National Industrial Court. Our courts need to begin to take cognizance of international treaties and conventions. Our decisions shouldn't be based only on our local laws. For example, the decision in ASO, did not take cognizance of conventions and ILO conventions on resolution of labor disputes. Okay. And that was why they decided that, of course, they couldn't have gone on strike.
Thank you very much. Because our time is fast spent, I want to round up within the time allotted. So I'll come back to you, Justice Yinka Faji. What are the practical challenges faced by Nigerian courts with the enforcement of foreign judgments and way forward?
Mr. Odemeze touched on some of the aspects.
Yes.
But for me, I think we do have problems with some of the instruments which the Attorney General is supposed to have signed. There is a dispute as to which of the laws are applicable. And I think it's the Macaulay case. So that is one factor that we really need to look at very, very carefully. And of course, there's a dichotomy between judgments of Commonwealth countries and non-Commonwealth countries. And so that's where the issue of Nigeria's international engagements come into force. How many countries do we really have reciprocal enforcement of judgment treaties with? In actual fact, and how many of these treaties have themselves been domesticated into law? Those are some of the challenges which I can just identify off the head. Yes, thank you.
Yes, I must say, even to enforce a judgment of Lagos State High Court in Oyo State, I had to personally engage the Chief Judge of Oyo State at that time. So, I mean, I look at it, if that's a local judgment is difficult to register within Nigeria, I wonder how it is for how easy it would be for foreign judgment to be registered and to be enforced. Because we know that under the Sheriff and Civil Process Act, you have to register the judgment before it can be enforced in another state. It was a tough battle, but I got it done because I would not give up on any issue. Now, Justice Ipaye, sorry, just to a quick one here. I know you recently came back from the Women Judges Conference. Can you please identify to us the kind of issues that you encountered with your colleagues from other jurisdictions, particularly in Africa, about the Nigerian judicial system, how they reflect on all the judicial system in Nigeria? We'll have such conversations and what have you. Not only your recent, you've attended several conferences, so let's hear your view on the way people outside view our judicial system.
Thank you very much, Madam Moderator. She's my friend, but she now has given me a very tough question to answer. First of all, you know how it is. Nigeria doesn't carry last. So we don't air our dirty linen so much in public or to be discussing with my counterparts from Accra or my counterparts from another country about, oh, these are the problems we're facing in Nigeria. No, we go there and glamorize. We are doing fantastic. It is well with us in Nigeria. And, Nigeria has a big contingent when we are going for any of these international conferences. So they are already intimidated by us. The last conference I went for was the International Association of Women Judges. And incidentally, one of our contemporaries from the Federal High Court is now the international president of the International Women Association of Judges, Honorable Justice Binta Nyako, yes. And she's set to do incredible work, and we were all there at her inauguration. It took place in Marrakesh, Morocco. And they were all just impressed and awed about Nigeria. And please just go and check out the website of the International Association of Women Judges. You will see all the beautiful pictures there. This is not to say that we do not have some problems in Nigeria. And I would like to start with my own state, Lagos State. As far back as something like 2004, we have been trying to integrate ICT platforms onto, the judicial process so that these things that we keep on talking about, e-filing, e-swearing, e-payment, and all of this will just be commonplace. But if I'm to ask a sample of lawyers and learned skills here, they will readily tell me that there's still a problem. Oh, you haven't got it right in Lagos State. So I don't know what is going on. We've been dealing with something since about 2004, our judiciary information system, and still it's not working as the optimal level. So I will admit that that still is a chaotic. I don't know whether it is the ICT professionals we have engaged. I don't know whether we have used this wrong software. And judges, we are not into all those things. Just give me Hosbury laws and give me Ganifawe law reports. I can understand all of that. But when you begin to talk about all of these bandwidth and network and Oracle and this, I'm already lost. So I don't know what is going on. Recently in Lagos State, we have also tried to put our lower bench, the magistracy, to put it on the ICT platform. That is called Lagos Commerce, I think, and we've rolled out in about 6 or 7 of the magisterial districts. So even at the magistracy level, you could file from the comfort of your chambers, pay, and swear to your affidavits and statements on oaths and everything online. We have rolled out. I was at a meeting sometime last week, and they were making their presentation. Now, the ICT firm that is providing this service is different from the one at the High Court. And it seems that at the lower bench, they are getting it right. So I don't know where the problem may lie, but maybe we're going to integrate, or maybe we're going to, upgrade and make sure that these things, because it has now become elementary for the judiciary to be hooked up to the internet. It's elementary. And what we're now seeing is that in-person hearings should just go the way of the dinosaurs. Why should everybody come into one anachronistic courtroom that is looking with benches and, hard seats and most uncomfortable things, when we can integrate online? We can all have a virtual hearing. I sit in the comfort of my chambers. You are there also in the comfort of your own law offices, and we take the evidence of the witness. So in-person hearings should go the way of the dinosaurs, and let's start with the hybrid. There are some that we can do virtual. There are some that maybe because of the complexity of the case, we may have to still,
Yes, thank you very much. Thank you very much.
Hearing.
Mr. Seriki, I would need just for you to look at this issue about the new amendment to the Constitution, about the age of judges of the High Court being changed to 70. Can we have your quick intervention on this, particularly looking at it in consonance with our own topic, integrating the Nigerian judicial system into global economy?
Thank you very much.
Please, you have 2 minutes.
Yes.
Because our time is fast spent.
I do not think that the review of the age of High Court judges is the solution to the challenges that we have in that level of courts. Because already as it is, quite a number of judges are putting in voluntary retirement due to health challenges. So by the time you increase the age, 1, you are going to make it difficult to create vacancy for new appointments. And then 2, you will then find a situation where some of the judges will be sitting even when they have passed their optimum productivity. There may be instances where a judge may still be fit at the age of 70, but most times, especially in Lagos that has a peculiar workload, the workload is challenging, the environment is also challenging, and counsel do not make the job of the judges easy. So, to me, we should address the institutional problems that be there. For instance, you have a system now where, because of the price of diesel, the courts don't run non-stop based on epileptic power supply. By a certain time of the day, they will switch off the generator. I was at the Court of Appeal about 2 weeks ago. They didn't sit on a particular day because there was no diesel to power the generator. And everybody knows that public power supply is non-existent. You have the problem of challenge of personnel that work with the judges. Because you find that most of the judges, apart from doing their work, they have to supervise the support staff in order to make sure that things are done properly. So we need to focus on addressing the institutional problems that bedevil the judiciary rather than increase the age of the judges. Thank you.
Thank you very much. I would want to hear Mr. Udemenze's opinion on that same question now. What is your view on that? And please, I want us to focus on our topic. How would it enhance the judicial system vis-a-vis global economy?
the truth of the matter is that the learned sick actually hit the nail on the head. I do not think I support that review for the same reason that he has given. But I would like to add that he also pointed out that there are judges who, upon retirement at 65, would still be very, very willing and capable of offering services to the Nigerian judiciary. So I think the way out, since the bill has been signed into law, is that in those instances where a judge or a judicial officer, where maybe before he gets to the age of 70, feels that he can no longer continue, because even though they say the retirement age is 70 years, there's nobody that forces you to remain there if you are tired or you know you can no longer offer, because you have nothing again to offer in terms of maybe your capacity or your health. I think in Nigeria, people should learn to live when the ovation is loudest. So if the law is that you retire at 70, of course that's...
You must live by 70.
Yes.
But at 65, you may.
So the law is that you live at 70. So if you think that you may not be able to get to that stage and you are no longer capable, because the problem we have is that if you sit down there and insist that you want to wait until you get to 70 years, the people that suffer are the litigants and the society in the long run. And that hampers the progress of both the judiciary and investors. Because what we are discussing is about globalization. If the courts are not functioning, there won't be a reliable judiciary. And if there's no reliable judiciary, it won't attract investors. Although it attracts investors, delay in administration of justice can also attract investors, some fraudulent investors. Because, yes, I've seen some people who are very happy that Nigerian judiciary does not move. Yes, I've interacted with clients who say, look, that after all, they will go to court. And when they go to court, the case will not be decided. So even when if there is a case of compensation, for example, they are supposed to offer a reasonable amount of 5 million. They will tell you, give them 500,000. If they don't agree, they should go to court. After all, they will be in court for the next 10 years. Even the 5 million, if they get it, it doesn't mean anything. So when the judiciary is not reliable, it hampers our progress.
Okay.
Thank you very much.
We now have a bit of...
Madam Moderator,
oh, yes.
You cannot have two judges as panelists without sampling our opinion on that point.
I thought to myself that it's safer that I don't come to you because you are the subject of the conversation. So except of course you willingly want to say something about it. I don't want to rock the boat. I just want to do my job and quickly get out of here.
All right, I'll take a cue from my lord, the Federal High Court judge. Since he's not saying anything, I will zip my lips.
I thought it's safer. Now, we seem to have a bit of an extension of time. So I would have to come up with other questions for the panelists. Now, Justice Faji. Sorry, they want to ask questions. Let's just, we will get there. Let me just ask this, let them give their parting shots. So, okay, instead of asking further questions, can each panelist will have 2 minutes to give their parting shots, then we'll come back to the audience. Parting shots in 2 minutes. Yes, Justice Faji.
Thank you very much, Madam Moderator. I think the way to go is to go digital in our court system. It may look a bit altruistic, it may look a bit difficult to attain, but that doesn't stop us from considering it. And 30 years is a long time in this day and age when a transaction can be concluded at the click of a button. I also think that there's a lot to be done in the legal system as a whole. The legal profession must self-regulate itself effectively. Many of the things that we face in the courts these days are not things I saw when we got to the bar. Professor Chodikwa is here, Mr. Adishokon is here, 37 years ago. But there are some things that lawyers do these days that are unthinkable. Yes, judges have their faults, of course. We are not standing in the ivory tower, we are saying that we are blameless. We have our own challenges as human beings and as lawyers. So those are some of the things I think we should look at. In terms of globalization, I think our court system has a lot to do by way of improvement. We must look at a sincere and effective means of discouraging cases from going to court. In commercial cases, we should look at a realistic filing fee regime. The judges should be bold to impose realistic costs. This idea of saying that you will not impose costs on an indemnity basis is not a matter of statute. It's just a matter of practice over the years. But if judges can move out of this idea of not wanting to impose costs, then you see the thing is this: a legal system, a judicial system that must work, must have an effective cost regime. There must be consequences when cases are filed when they should not be filed. There must be consequences when a counsel comes into court that morning and says, I just filed a motion for extension of time. There must be consequences when a lawyer refuses to come to court. Those are issues that we should look at. That's my parting shots. Thank you very much.
Thank you. Well, then I go to Justice Ipaye. Can we please have your parting shots in 2 minutes?
All right. Thank you very much. I want to adopt everything that my learned brother has said. No, we don't concur at the trial court level, but I adopt it. All right. It's a persuasive precedent. And having said that, I would also like a situation where, if the truth be told, standards are falling everywhere. Standards at the bar, standards also on the bench. I've been on the bench for 22 years, and I know, because newbies, the kind of questions that they call me up, my lord, please, what happens? And when this one, and I'm like, this is too elementary. You ought to know this. I'm not that I'm disparaging my colleagues and stuff like that, but I'm just saying that we need to pay attention to the kind of curriculum our new lawyers, that they go through, not only at the law school, but also in the law faculty, so that they will be very, very versatile. And also, we need to take a very close look even at appointments on the bench, if the truth be told. And since this is a learned profession, this is a noble profession, this is something that we're talking to ourselves in-house, I might as well sell it and say it and bail the cat. Thank you very much. So there should be transparency, and we should always go for the best. That's the bottom line.
And I think global best practices, like in Canada, US, and UK, is that the Supreme Court of those countries, billions of appeals are filed yearly, but they have a filtration process by which they select an average of 80 appeals. So all other cases terminate at the Court of Appeal. They don't get to be heard by the Supreme Court.
Well, I think that problem, let me quickly, my own opinion on the issue about the clog in the Supreme Court, is that when Supreme Court, as you said, was in Lagos, how many courts of appeal do we have? Today, it's like every 3 states have a court of appeal. And appeals will come from all of those courts of appeal to go to one court. How are they not human beings? How will they do it?
Now, the solution to that is that we have 2 options. Is either we limit the subject matter of appeals that get to the Supreme Court, and along with that, we minimize the issue of interlocutory appeals. Even in civil matters, whatever issue you want to raise, even if it's jurisdiction, raise it at the end of the trial, so that everything will be considered together. And then the other option, which is what operates in the US, we claim federal system, because virtually each state has its High Court, Court of Appeal, and Supreme Court. Then the Central Supreme Court only handles constitutional matters or disputes between the federating units.
That's it. I've advocated that too many times, because I see no reason why chieftaincy matter of Elegushi should go to the Supreme Court. how will they understand what is going on? Land cases of Kirikiri. Why should they go to court? I've always said it. You know, before the military came in, we have the Western Region Court of Appeal. We used to have a Court of Appeal in Ibadan, where appeals from the Western region they used to go to before it was abrogated. But anyway, those are matters that are germane to our discussion because it's part of the issues that the globalized economy will have to determine how long it takes us to deal with our cases. So thank you very much, my learned brother Silk. Mr. Udemeze, I'm back to you. Can we have your parting shot quickly?
Thank you very much.
Thank you.
The truth of the matter is that if our judiciary or judicial system would have...
It's not just by introducing digital technologies into the court system. It should be about efficiency. Why is it that in 2023, judges still do not have stenographers in court? This is something that can radically reduce the time spent in court for cases. Judges have to write longhand, and that alone takes a lot of time. So instead of, before you even think of e-filing and things like that, you should have stenographers in court. I was reading a book, The Art of Cross-Examination by Francis Wellman. As far back as the 19th century, they had stenographers in the US courts, and they've always had stenographers. So why is it that in Nigeria, in 2023, we don't have stenographers?
Any other one? Because
Yes, I'm saying if we need to be efficient in the introduction of digital technologies, stenographers, e-filing, but we should be efficient. It's not just about introducing just anything.
Thank you very much. But I could immediately tell you that even in the courts in Lagos State, that there are verbatim reporters, you still find the judges writing longhand. Well, I need a lady now. Okay. Oh.
Thank you very much, Madam Moderator. Mine is just a simple invitation, perhaps to the legislature now, to go back to the 1989 Constitution of Nigeria, where indeed the issue of interlocutory appeals was banned, was prohibited in the Constitution. For some reason, in subsequent constitutions, it was removed. I have made this call several times, and I make it again, that perhaps that provision should be reinstated. And then following on that, and what the learned essay and Mr. Rotimi Seriki said, about the issue of increasing the requirements for people seeking to apply for preferment. Indeed, many lawyers I know who practice in areas where their cases result in settlement. If you're in maritime law, for instance, many times once the vessel has been arrested and the parties pay and all that, they settle the matter. Then you are not able to use that case to apply for silk. So perhaps, again, the requirements as well should be amended.
Thank you. We can only take 2 more questions if we still want them to have, okay, female just finished. Okay, can I have the gentleman to the SAN? So, and we'll come back to the
Thank you very much.
We have
I'm very grateful to my lords, and first I must thank them for their very fruitful presentations. I want us to understand that in administration of justice, there are 2 major aspects: management of the courts and adjudication. We must, at different levels of the courts, be able to put in place a good structure to address this. How can we do that and achieve it? The second issue is that if you look at the presentations of all the panelists, with due respect to their respective views, it is important to really summarize and agree that this problem has a lot to do with professional discipline, has a lot to do with judicial discipline, has a lot to do with corruption. And I say this because, one, in adjudication of justice, the judges, how can we address the issue of capacity and courage? And I also think we should pay attention. Most of us are familiar with the case of Williams against Hope Rising Voluntary Fund Society, but the attention is always on how to set aside judgment. But the salient point, which was made in that case by my Lord Justice Idibe, who decided the case at the Supreme Court, was that at the High Court, the court understood the law, the judge understood the law. The judge was also not in doubt as to what the facts were. And he still went ahead to give a wrong decision. He got to the Court of Appeal. The Court of Appeal, the majority of the judges there understood the law and also were in agreement with the Court of First Instance as to what the facts were. But still ahead, it was only one of the judges that dissented, I don't want to mention names of the judges, but it was at the Supreme Court that they realized that there is need for a judge to be courageous to do justice to a particular case. So I think these are some of the issues we should look at. Thank you very much.
The last person will be this lady. We've done 10, and that's fair enough. We still have to get back to the panelists to give answers or react to the comments.
Thank you, Leonard Silk, moderator.
Ask your question.
Yes.
Let's get it or comments.
I want to talk about the remuneration of judges, you know, and the general welfare. I think it's going to be better if the judges' salary, part of it is monetized. So if somebody's made a judge, give them a house in real estate, you know, so that they get the courage to dispense justice no matter whose ox is God, you know. So you'll be taking the money from their salaries gradually during their lifetime on the bench. So they don't retire and don't have houses that call their own. And also, I spoke about the Federal High Court building on Boylan Road. It needs to be finished. We need to decongest the courts. The courts are congested with cases and adjournments and so on, and that makes dispensing justice tardy. We want faster, equitable justice because it's the hassle of the common man, the judiciary. You know, yes.
I will pass on your comments. They've heard you.
So,
they've listened.
Thank you very much.
Back to the panelists.
Thank you very much, madam. The last point you made is quite pertinent. The Federal High Court building on Bodylawn Road, very many challenges, funding, and then, of course, about a year or two ago, we realized that we needed to retrofit the court, and that has delayed the, formal commissioning of the court. But I want to say here that before the end of this year, definitely, and there's no doubt about that, we would have at least 4 courtrooms operating in that complex. That is certain. 4? Yes, because those are the 4 courts that have been retrofitted, and they are going to be state-of-the-art courts. And if I say state-of-the-art, then they will be state-of-the-art courts. I have seen the courtrooms, my chief judge has seen the courtrooms, and we have been assured by those building that it will be ready before the end of the year. I don't want to say before September, but I know that before the end of the year, it will be ready. We've had challenges. Funding is a basic problem, probably because, as somebody has said here, many people, the government itself doesn't see the judiciary itself as an arm of government, and all the things that happen with budgeting and all that also affect the judiciary. All the issues of what to do at the National Assembly, which cannot say here, also affect the judiciary. I have only one complaint to attend to, and that's a complaint by Mr. Fajolu. Let me start by apologizing on behalf of my colleague. It is not our practice at the Federal High Court to delay the issuance of but of course, you know that there is a lot of processing that also goes into it. Depends on when the application for the order was made. You said it's been now for 2 years, 2 months or 2 weeks, and of course it needs to be certified. And my brothers have just said something this morning that we do have a congested cause list. So it's not really very easy. Some of my brothers have 1,200 cases, some have 1,500 cases. So it's not really very, very easy. And of course, you say, can we get it by email? That is where the issue of automation of the process has to come in. I think we are able to do that. And like I said, I apologize, and I will look into it. Just let me know what it is. But I can assure you that before the end of this week, or probably the end of business tomorrow, if you tell me, we'll get your order.
Thank you very much. I'm constrained by time, but I will still have to ask my Lord Justice Ibaye to say one word in a minute. Our time is gone. We have to get up from here.
Thank you very much. I just want to say thank you for giving our small claims court a AAA rating. You love it so much that you even want the jurisdiction to be increased from 5 million to 50 million. I'm an assigning judge, and I know that appeals from the small claims court, they come to my table, and I'm beginning to see an increase in it. And I'm wondering what is going on again. These lawyers, they have started. 5 million is the cap, is the jurisdiction. You are fighting it again. You want to go on appeal. But I hope that the judges will begin to see the red line and, order you to pay the money in court before you are even granted the leave to go on appeal. So I just thank you, because that is one of the success stories of Lagos State, and it was designed in order to encourage foreign investment in the country, so that we'll have a responsive judiciary attending to small claims, small businesses, small and medium scale businesses trying to collect their trade debts. Thank you very much.
This will have to be the end of this session, although there are many more issues raised, and I can assure members that our panelists are still here. If your questions have not been answered or you have other questions you want to ask them, please feel free to do so before they walk out of here. I thank you so very much. It's been a very stimulating time for me, myself, to listen to them. Thank you for listening, and thank you for being such a wonderful audience, even as we thank our panelists. Thank you very much.
Thank you so much. Thank you, my lords. I think another round of applause for my lords. I think we underestimate the service that they give us. Like someone said, it said, imagine writing 1,500 legal opinions, and somebody says do that in 1 year. Even if they wrote a judgment every day, he will still have a deficit of 1,200. So a round of applause for my lords, please. Thank you so much, so much. Please, we'll have pictures right away and the presentation of plaques.
Yeah, thank you very much. Distinguished ladies and gentlemen, how do we thank this wonderful panel? I think we need to do it in a special way. And let me confess, we actually put them under pressure. But they are passionate about this, and they are stakeholders in what we do. So can we please give them another round of applause? So in appreciation, we have a symbolic gesture. Okay, let's take the picture first. No, let's do our own last here. The way they are seated. Just come. Okay. Justice Faji, thank you, sir, for always being there for the branch. We appreciate you, sir. Thank you very much. My Lord, this is a token of our appreciation. Thank you very much. Thank you, ma'am. Yeah. My learned brother Silk, Rotimi Sheriki, thank you so much. We appreciate you. Siveta, okay, please come. Thank you so much for your contribution.
Thank you,
and for making yourself available despite the short notice. Thank you.
Thank you.
You need to come here. Thank you very much for making this so engaging, so interesting. It shows you are an advocate par excellence. At the slightest, shortest notice, she's always there. Thank you very much, ma'am.
Thank you.
We appreciate it.
Thank you.
Yeah. So,
thank you.
We can now have the tea break. Thank you for being such a wonderful audience.
Thank you to our honorable justices, our lecturer from Bayelsa campus, and Mrs. Titi Lola for what what we could describe as a mind-blowing panel section. Please let's celebrate them once again. And let's make the ovation very deserving.
I always do this to Mrs. Akilawo. Another round of applause for her, please.
Yes.
That's the very first law firm that I worked when I came to Lagos. So round of applause for Mrs. Akilawo, please.
Wow, I can see your personal interest. So, ladies and gentlemen, while we're about to go on our second plenary section, we have to bring an important announcement that the tea break will be ongoing while the plenary section is going on. So I will leave Mr. Vicern to do the wordy introductions of our speakers and moderator for our second plenary.
Thanks, Vanessa. Appreciate it. So we're moving on to a very interesting second plenary session.
Thank you, ladies and gentlemen. Please let's all try to maintain decorum while we're exchanging pleasantries. We understand the importance of exchanging pleasantries and giving a handshake to people you haven't seen in years or months, and it's a very beautiful sight to witness, but let's all try to still maintain decorum. Thank you.
Our very first speaker is Mr. Chinua Asuzu. He's the Dean of the White House. A round of applause for him. Please, sir, if you can join us on the table, please.
You're welcome, sir.
Anywhere
over here.
Over there.
Thank you.
This plenary session promises to be very fiery. Again, we have our moderator who's in the house, Mr. Larry Fashola. He's the CEO of Legal Blitz Legal Limited. At times, I often refer to him as the other law school. Mr. Larry Fashola, a round of applause, please. A round of applause for Mr. Larry Fashola, please.
Thank you for joining us, sir.
Okay. Our next speaker, I must warn you, is quite fiery, and I'm sure she has a lot to offer in this session. A round of applause for Professor Joy Ngozi Ezelo, Senior Advocate of Nigeria. A round of applause for her, please. Two people will be joining us online. Larry, I'm sure you're aware. The first is Professor Olarewaju Fagbohun, Senior Advocate of Nigeria and former VC of LASU. A round of applause for him, please. And Mr. Tunde Simoya, CEO of Precise Share Associates. A round of applause for them, please.
Thank you. So because this is a hybrid section, if you're an online participant, please make sure you drop your questions or contributions. Our technical team will bring it to our attention. So just give it all your attention, and I promise you this is also going to be another incredible learning experience.
Thanks. Larry, over to you.
That's what I'm
Yes.
saying.
We can hear you, sir.
We can hear you, sir.
Okay.
Hello? Hello?
Sound team, please check on his microphone.
Are we starting right away?
Yes, please.
Okay. Hello? Is it working now? Hello? Hello? Okay. All right. Good morning, everyone. Right. Good morning, my great teacher.
Thank you.
Yes. Okay, so we're moving on to the next session today. And the topic we're looking at is the globalized economy and the integration of, the skill sets of Nigerians, the globalized economy and the skill set of the Nigerian lawyers. Today I have very interesting panelists who are going to be looking at this topic, but just like an introduction to this particular session. Today we live in a disruptive world where it seems like everything that we've always known has transformed and is changing before our very eyes. From the way we meet our wives to the way we conceive our babies, or the way we give them life, to even the way we buy our house or handle issues that have to do with our health. Everything has been globally disrupted. A man and a woman do no longer need to meet, as the Bible said. They can actually just, one donating semen and the other donating egg, into a machine, and then it gives birth to a baby at the end, after 9 months. You have a full-blown baby. So many things have been disrupted. And then again, just as the world is changing, it seems like lawyers themselves are not actively following the trend. Yeah. And this is part of the general challenges. And with the state of the economy, it appears there is now what we call the Japa syndrome, with a lot of brilliant young people emigrating out of Nigeria. When I checked last, the global legal services market is about 901.78 billion naira, dollars, as of 2021. And it's projected to grow to about $1.429 trillion by 2030. And then at a CAGR of about 5.25%. The major areas of legal practice that are actually thriving and cashing out from this particular boom are taxation, real estate, litigation, bankruptcy, labor and employment, and corporate practices, right? And generally we see the way, due to the globalized economy, we see that things that have almost nothing to do with Nigerian law, even Nigerian lawyers are called to mediate over such issues because of the interactions of people from all around the world. Today, I have a very interesting panel with erudite scholars and practitioners who are going to be looking at this particular topic of globalized economy and the skill set of Nigerian lawyers. I have Professor Olanrewaju Fagbohun, Senior Advocate of Nigeria, former Vice Chancellor of the Lagos State University. He's going to be joining us virtually today. He's at the tribunal as we speak. Prof is one of the most renowned professors of environmental law, and he was former Vice Chancellor of the University of Lagos. He has done extensive research in the area of environmental law, business law, environmental policy advocacy, international environmental law, and climate change. He's been involved at the highest level, both locally and internationally. He was part of the 18-man special task force on climate change, justice, and human rights, which was set up by the International Bar Association. Please, can we put our hands together for Professor Fagbohun, SAN? I also have a very distinguished scholar and one of the legal Amazons of our time, Professor Joy Ngozi Ezelo, Senior Advocate of Nigeria, Officer of the Order of Niger. She was of the Faculty of Law, University of Nigeria, Enugu campus. Prof is a Senior Advocate of Nigeria, and she has done a lot of research in the area of women and gender advocacy. She's a former United Nations Special Rapporteur on trafficking in persons, especially women and children. And she founded what is called Women Aid Collective, WACO, and TAMA, as well as pioneered the teaching of women, children, and the law in 1997. Prof is going to be doing justice to this topic today. Let's put our hands together for Prof. Thank you. I have my friend, an HR specialist, who is also an international recruiter, today, Simoyo. Today is joining us from Kenya today. Today is an HR specialist, and he has worked on a lot of banking and finance, PPP and infrastructure transactions, project financing, debt and capital market transactions. He's Vice President of Oshoni Capital Limited Investment. Oh, he was Vice President of Oshoni Capital Company Limited and was General Counsel, Sahara Group Limited, Oil and Gas. He has worked as a consultant with the African Bank in Tunisia and Ivory Coast. Let's put our hands together for today's Simoyo. I have my great teacher, the man who corrects my English all the time, Mr. Chinua Azuzu. Is one of the, very reputable trainers that I know. He is the Dean of the Writers' House and a senior partner of Assizes Law Firm, a fellow of the Chartered Institute of Taxation of Nigeria, and a fellow of the Society for Advanced Legal Studies, University of London. Mr. Chinua is also an expertise with areas covering legal writing, academic legal writing, brief writing, business writing, contract drafting, and is an upright and righteous autodidact. Am I right? Autodidact, sorry. An upright and righteous autodidact. Chinua is all about writing. Let's put our hands together for Chinua. Right, we go straight into today's session. And, oh, okay, I also have my great teacher, Professor Abiola Soni. He's a professor of taxation, a senior advocate of Nigeria, and is of the UNILAG. I'm from UI, so he's from UNILAG. So you're welcome. So let's put our hands together for Professor Abiola Soni. Right, today's session, what we're looking at basically, I feel it also correlates with what we handled the last time. We're looking at the disruption in the market and the skill sets that Nigerian lawyers need to be, embracing right now, the gaps that we have and the challenges it poses both to ourselves as lawyers and to the clients that we advise from day to day. I'm going to have Professor Joy starting the session today. And she's going to be speaking to us for about 10 minutes. She has a presentation for us before we go into the discussion.
Thank you. Thank you, moderator. Thank you, fellow panelists, distinguished learned colleagues and others. I don't know whether they have my PowerPoint presentation uploaded. If not, I'll just speak quickly to my presentation. Is that going to be showing? Is that okay? If it's, then you just get it running. I'm going to be speaking to what you already have seen in the agenda, which is the globalized economy and the skill set of the Nigerian lawyer. And here I'm looking at both the concept of globalization without spending a lot of time on it, but to then look beyond the concept of globalization to the nature of globalized legal practice and the forms or models amongst global law firms, and looking at specificity of practice of law in Nigeria, and moving therefrom to reaction of Nigerian lawyers to threats of globalization. And then looking at moving forward, what are the skill set of lawyers before concluding the presentation. So I know I have about 28 slides and the organizers have promised they are going to share. So because I'm going to just quickly speak to them because if I'm to spend one minute, that's 28 minutes and I have really 10 minutes and they start to count already. Looking at the globalized economy, is something we already have been dealing with, and definitions we know are many mnemonics, but notwithstanding within the context of global economy, and you can call it globalized economy, global economy, economic globalization, and related terminology all indicate a shared notion and trajectory broadly characterized by human innovation, technological revolution, and global interdependence. And I think that's very important. IMF defines globalized economy as integrating economies around the world, mainly by moving of goods, services, and capitals across borders. When we look at globalization, we always think of the markers of those globalization, and that's consumerism and travels, and that involve the movement. And within the movement, whether for labor, knowledge, across international borders, and the broader political, social, environmental dimensions. Of course, I'm not going to talk about the downside of globalization or the way they've criticized it at the beginning as Americanization, but we've long moved beyond this, and we're all thinking outside Western metaphysical framework, and we're all involved, and it has altered our vision. So if you need to read more, you know where to go. So, but important thing here is the issue of the demand, because if you look at globalization, then you talk about market fundamentalism. And then in there at the core is the issue of trade and services in our present world has become borderless. As the UN Special Rapporteur on Human Trafficking for 6 years, I used to tell United Nations Special Rapporteur that human trafficking knows no border. And some of the transnational crimes that we see knows no border. And when we're talking of globalization, about trade, movement of people, goods, and services, it knows no border today. And then the cyberspace has made it even possible that what was virtual now is tactile, and you could feel it. So technology and internet have made it possible for the virtual world in the global cyberspace and telecommunication to become very real, and they're brought home to us. So I could be in Nigeria talking to anywhere, in the world and doing business there. They've also introduced new ways to our old village. And what it then means, it challenges the legal profession to innovate in all its ramifications, to be positioned to take advantage of opportunities that globalization brings, while at the same time overcoming the challenges that necessarily come with it. But we can't be complaining or say we are victim. We have to participate, and we all have to take benefit of it. So in terms of concept, I already have that in my paper, and time will not permit me to go deeply there. But it's important to say that given that negotiations and perfection of many trans-border transactions generally require knowledge of the applicable host country laws, demands for the service of both local and foreign lawyers by clients located in different jurisdictions have made globalized legal practice an increasingly reality. There are global law firms with branches located in various jurisdictions and staff drawn from different jurisdictions because they have to bring on board that knowledge, that skills, and the culture that they are not aware of. So lawyers from foreign jurisdictions have participated in business negotiation. So today we live in a world of global trade, commerce, and we know that Nigerian lawyers are profoundly caught up in this process, and their skill sets are constantly tested and exposed to constraints of competitiveness and quality assurance, as well as opportunities to benefit from new law practice areas. Many areas of legal practice influenced by global economy have an inexorable international dimension. And we all know the areas of intellectual banking, finance, intellectual property, competition law, trade and investment, merger and acquisition, even dispute resolution, environmental law, human rights, constitutionalism, even family law. Every day you get cases around what happens, international adoption, abduction, issues around dissolution of marriage, enforcement. So it is criminal law, of course, we know. So the legal and normative frameworks of these areas of law are also, they also have regional and global instruments enabled and supported not just by the World Trade Organizations and those Bretton Woods institutions, but also the United Nations that has become a site for such discussion. So in terms of globalized legal practice and its nature, is the provision of legal services across national boundaries, simply stated. And the forms or models amongst global law firms as independent operating, there is no one person that can be called a global lawyer. You can't, practically speaking, have an audience in all jurisdiction, so to speak. So, but you find that, expatriate partners, lawyers, locals, they just have to, pool resources together through the emergence of conglomerates, providing a suite of professional services or ad hoc membership of different law firms. There is also the issue of outsourcing of briefs to lawyers offshore. So it's not just talking about oil and gas offshore. Offshore, which allow lawyers in particular local jurisdiction to address critical legal issues based on applicable local laws. So practicing law in Nigeria, we know what it takes. And it's very clear. And I recall, even during our time in law school over 30 years ago, that those who came from Gambia, they couldn't, because you have to, of course, go by the Section 8 of the Legal Practitioners Act, 1978. It makes it clear the right of audience granted to legal practitioners subsequent to their enrollment under Section 7 of the Act before courts of law sitting in Nigeria. And unless you've done that, you're not entitled to practice. And we know about a case of Okafor and Nweke, and where former Onege JSN said that the combined effect of the provisions of the law is that for a person to be qualified to practice as a legal practitioner, he must have his name in the role, otherwise he cannot engage in that practice. So, but the reaction, what you see is that rather than embrace, maybe for our lawyers, the global trend of free trade and services, what one witnesses in Nigeria are the constant complaint by lawyers that outside jurisdiction, legal practitioners are poaching and stealing the legal businesses which rightfully belong to them. And then there is the issue of capacity even. And then the reaction of MBA is usually to influence protectionist legislation that reserves certain types of government legal briefs or legal requirement by government or its agencies for lawyers or just exclusively for law firms in Nigeria. So beyond this reaction, and empirical evidence has shown that most Nigerian law firms lack, and it's important, the capacity to handle the growing number of modern, high-tech, sophisticated legal drafting and contract terms that are multinational and transactional dealing in unfamiliar, uncharted territories, for which even their law school, by the way, does not pretend. I think I'm looking at my time. So remaining 2 minutes, I'll go to the...
Please take 5 more minutes.
Yeah. I'll try to go, because I think you will get presentation, but
I'm saying that some of the issues that others,
definitely. So let me look at the skill set. Nigerian lawyers and the threat of globalization, I'll get that passed. But moving forward and looking at Nigerian lawyers, they must key into the evolving globalization of legal practice. And that means that they have to render professional services, but locally and internationally, they must have to have the knowledge and understanding of fundamental doctrines and principles that underpin the substantive and procedural law to make it competent, to be competent. An appreciation of legal regimes there, the issue of revision of methodology for teaching, adjective, whether procedural, multinational, developing analytical thinking skills in law students. That's very important. Yeah. To clinical legal education, the Socrates method, experimental, which often is lacking. Technology in aid of legal education. This is a time to bring it in. Skilled and creative application of their knowledge of principles and practice of law in order to address legal issues. And I'll move to finally to conclude, because there is also additional skill set required. Issue of practice skills, legal drafting and reporting, something as reporting meetings. It's so vital. Mm-hmm. And this is where our educational system is lacking. Because you come in, you don't get opportunity to write a lot of essays, a lot of practice in areas. So issues of business skills, communication skills, project management, internationalization and cross-border practice, interdisciplinary experience, resilience, self-confidence, language, communication. We are surrounded by many Francophone countries. And it's in Nigeria that we have the least language ability to communicate to our next neighbor. And then you go to Senegal, everybody will speak English. In a way, you go to Benin Republic, and we are surrounded, and Anglophone is there. So those are the keys to practice it. So conclusion is that the global legal practice requires specialized skills. It is highly competitive. Globalization has impacted Nigeria, and we know that we must have excellent knowledge of use of communication, information, and technology, knowledge of laws, and I think even culture, ethical issues, the skills that is required, ADR, the flexibility in diversity, even in terms of time and communication, outsourcing skills. The year 2022, we saw 2 of Nigeria's largest law firms firmly expanding their presence abroad by opening offices in Europe and Africa. And that's Olaniwu Ajayi LP broke uncharted ground with the launch of the UK office. So we can't be complaining. Yep. We should take advantage and outsource and be there. So the desire to attract international clients remain an important aspect of our law firm. I think I will have opportunity to talk about MBLS CLA program, and then also the issue of learning skills more, and what we need to do to be engaging the pedagogy, talking about curriculum review in a way that is the emerging market that will be able to also key in to that. But for now, I'll just stop. Thank you so much.
Thanks a lot.
Thank you very much, Paul. Thank you. I feel you've provided a broad overview of everything that we want to do, and that's a very brilliant presentation. Thank you very much.
Thank you.
I want us to be very practical with this session because of a lot of the younger lawyers who need to know what the future, that lies ahead of them. So it's very good to be very practical based on your experience and based on what you've seen around the world beyond the classroom. Right. So I'm going to go to Professor Joy. You are still the one that I'm going to start this particular discussion with. You spoke about...
Or is it the question?
No,
Are you speaking? No, leave him. Leave him.
They were on before. Okay, please, can you bring Professor Fagbo and Today back?
Oh, okay.
Okay, I understand that Professor Fagbo is currently at the tribunal. He just had to step out to be part of this session. Right. Prof, thank you for joining today's session. Well, I know I've...
Can you hear me?
Maybe somebody needs to repeat the question back to him from that by chatting.
Can you hear me? I can't.
We can't hear you.
Please,
we can't hear you.
We can't hear you. We can't hear you.
Yes. Please, operator, can you repeat what you are saying back to him from the system?
He can't even.
Now, I can hear you now. When you are asking the question, you cut off.
Okay, can you... hello, Prof?
Yes. I can hear you now.
Oh, okay. I said, apart from the 2 questions that I formulated for you before, I'm just going to add a little cap. I want you to speak generally to... Prof has spoken about international practice. She has spoken about the skill sets of lawyers. But I want to understand what this globalization is all about in a practical way. Well, explain it to a baby. What is this globalization all about, and how does it affect the practice of law in Nigeria?
Now, if I'm going to, do you want me to speak to that first, or you want me to talk about skill gaps? Which one do you want to talk about?
Yes, so speak to that first before you speak about the skills. The gaps in the skills.
Okay. If I'm going to talk, permit me to just put up my video so that it will help my connectivity.
All right,
Let
that's
me just
fine.
put up the video so that it will help my connectivity.
That's fine, sir.
Can you still hear me?
Yes, sir.
Good. If I'm going to talk about globalization as it relates to legal practice, the example I will give is this. If they are bidding for a transaction that relates to privatizing an entity in Nigeria, if Nigerian law firms submit bids and foreign law firms submit bids, you will see that the bid that will be submitted by the foreign law firm is likely to meet the terms of the bid more than what some Nigerian law firms will submit because of the high exposure that they have had to international transactions. And if care is not taken, they will come into that jurisdiction and take all the briefs. So you see a situation where there is a need for a balance, so that while you are working together, you look at how do you ask them to collaborate such that Nigerian law firms can collaborate with international law firms in relation to transactions that it will even appear that we do not have the competencies to fully work on them. If you attend some conferences outside Nigeria, you will find a situation where they'll be talking about some transactions that is so foreign to you because they have been doing them over there. Yet when they want to do similar things in Nigeria, it will be easy for them to come over here. So how do we ensure that the skills set that they have to be able to do those things, Nigerian lawyers also have them? That is the issue that has to do with globalization, because everybody is working together. But if you are not careful, you find a situation where Nigerian law firms may not be able to compete with counterparts from other developed jurisdictions. And that is why you see some protective measures trying to come in once in a while. But at the same time, just as Joy spoke earlier, you cannot totally block out the system and say they should not come in here. Otherwise, we will not grow. So we should encourage collaboration and cooperation in some of these things. I will leave that and go to the issue of the skills gap. And I want to thank the MBA for inviting me to be a part of this, and also other panelists and our very distinguished audience. I will say straight away that there are significant expectations on Nigerian lawyers to have the skill sets that will match the need of the globalized economy. Can you still hear me?
Yes. Sure.
Yes, that will match that skill set. But the thing is this, I asked that question, that don't we appear to have an assumption that the lawyers in question, that is Nigerian lawyers, all of us are possessed of the basic skill sets upon which to build new knowledge, or that our legal education is being reformed in a way that when our students are turned out of the law school, they have all the requisite skill sets. I think there's an assumption. While I am not going to generalize, I will say that there is an assumption that all the basic skill sets will have them. But where you see a problem is when you see recurrent and constant complaints that the rejection level is high in recruitment processes, then you begin to ask the question, what is wrong? I was part of a process where they wanted to select about 3 lawyers in a law firm, and about 20-something lawyers presented themselves. And I can tell you that it was really a difficult time picking the 3. I will say that the problem is not so much that our students are bad, but I will say that it's a complication and complexity of a number of factors. You find out that if a lawyer lacks a deep understanding of fundamental doctrines and principles that underpin the substantive and procedural law, it will be very difficult for that lawyer to compete globally. Again, where a lawyer lacks or is deficient in both verbal communication and writing skills, again, you are going to see a major problem in competing. But what are the problems? Because as I stated earlier, it is not as if our students are bad. It is because there are some complications in the system. The first one I will point to is that there are too many distractions in our society that is deepening both the frustration of lecturers and students. So you see a situation where there's a challenge of meeting basic necessities. So people are no longer able to show the commitment that is required. They are also not able to push for delivery of excellence. Another major problem we have is diminished quality assurance process. And I'm glad that the moderator said something, that we should speak from practical experience. When we are talking about quality assurance, you are looking at internal quality assurance and external quality assurance. Quite a number of our universities, they play lip service to internal quality assurance. And when it comes to external quality assurance, they also do cosmetics arrangement. You find out, and some of my colleagues will admit of this, when you know that a team is coming from NUC, and you cook things just to make it give a semblance that you have all the equipment, it is a problem. Again, you find out that interventions that ordinarily should make the difference are not monitored or evaluated. And I will give just two quick examples. Look at legal clinic, i.e. the clinical teaching methodology that we talk about. You see problems of frustration in funding. You see the indifference of lecturers who see this legal clinic as an extra burden on them. You see at times that even the coordination of it is a challenge. Another one I'll go to as a quick example. Many of our universities, because I actually called a number of students in some universities, and I found out that some of our universities are actually not engaged in clinical teaching methodology. And even those who are engaged, the students treat it as an optional thing. So where do they get that practical experience that you are trying to inculcate in them? The fourth thing that I'm going to throw up quickly is that in many of our institutions, the style of teaching still do not recognize that technology has changed the mindset of our students. We all know it, even with our children at home. Their attention span is very short. By the time you now want to go ahead and start dictating to them, you will lose them. But what they want is a situation where you are engaging with them to learn. You find out that a number of our colleagues, they still teach students to regurgitate answers. But what is happening in other climes is that they are teaching students to learn. They are teaching, because when you teach a student to learn, as against giving you the answer that you have given to him, it will deepen the analytical thinking of the student. If I pose a question, for instance, here in Nigeria, some of our institutions, when they tell the student XYZ is not okay, they will give the answer, XYZ is not okay because of ABC. In other climes, when the teacher poses the question that XYZ is not okay, the response you will get from students is, why is it not okay? Why is it not?
I think you should round up. Yeah.
I will round up now. Who said it is not okay? Again, you find a situation where our institutions are still fixated on enrollment and completion of education. We do not track the labor market. As for us to have a feedback on our products, these are the areas where technology can make a difference. And finally, there is a major problem of funding. Inadequate funding is still a major challenge of our faculties. Let me give you an example, and I'll close it. Here in Nigeria, you will see that you have 2 lecturers at most to a course. But I will give an example of University of Westminster. And this is something that can be verified by members of this panel and our very distinguished audience. I asked one of the students who attends University of Westminster, I said, give me one of your courses. He mentioned law, police, and practice. What is the student population? 410. How many instructors do you have? 55 instructors for that course alone. Not that the 55 instructors will be taking all the students, but that means they are going to be taking the students in pockets in order to deepen their knowledge. They had a support staff that is 3, and the assessment type is not examination. The assessment type is research, because they are trying to test the knowledge of the students and their commitment. Another topic that I asked him, course that I asked him, your thought. In thought, the student population is 412. Instructors, 21 instructors. Assessment type, they work with essays, multiple choice questions, and short questions. So those are the kind of things. When I have opportunity, I will talk about what are those strategies that I think can have a role to play.
I think we're coming to that.
Yes, these are the challenges and the gaps that we seem to have in our system. So it is not the case that our students are bad. It is not the case that our lawyers are not good, but it is the case that the way we are preparing them, we still have a major problem, particularly when it comes to monitoring, when it comes to evaluation. Quite a number of our colleagues are not doing their work, and it's a challenge. Thank you very much.
Thank you very much, Prof. I'm just going to go very quickly because we don't have, we don't have a lot of time on our hands, and I would like us to be very brief in our responses. Professor Sonny, I'm going to be coming to you now. Right. Oh, okay. Today is on standby. Okay, today, yeah, I needed to answer, I needed to clear this particular point before I come to you, since you are talking from the angle of a recruiter. Okay, but we can come to you. Okay, today you are a recruiter and you've been recruiting for international organizations. And one of the things that I find out, Prof said something about in bidding, right? Nigerian law firms want to compete with international law firms, but then you find that when they submit the bids, the international law firms are more favored than the local law firms. And we're looking at why is this so? You know, what is different in the law, or what is different in the skill set that Nigerian lawyers are presenting that is different from what the international law firms are presenting, that is making Nigerian law firms not to be favored. As an international recruiter, and who has also interfaced with a lot of these international organizations, what do you feel is actually the gap that Nigerian lawyers need to look at?
Okay, Larry, can you hear me?
Sure.
Thank you very much. I'm sorry to have had to wave, and I'm very jet lagged, as you know, and I just said to myself that I have to attend this session because I have a lot of insights. Now, to the question that you raised, and maybe I should just first by introducing myself properly. I'm an international lawyer that is an entrepreneur. So in my entrepreneurial ventures, I run an international legal recruitment firm, Precise Hire Associates, and we are going to shortly be launching a Pan-African recruitment outfit. Now, the question you asked is a bit complicated, but it's very, very simple. And the way I see it is that we've stopped becoming a knowledge society. We've stopped becoming a society that craves for knowledge, appreciates knowledge, and gives people with knowledge their due. So people that have the intellectual capital is very, very easily dismissed in this society. The issues that the Nigerian law firms are facing are the same issues that we faced in this in setting up an executive search and recruitment firm. Now, the issues are multi-layered. The first thing first is, if you want to get on all these big issues, we need to rethink the way we're presenting ourselves as a country. You know, when we have leverage, we don't know how to use that leverage. We don't understand that, look, you know, if you have leverage, you use that leverage to the benefit of your country and your society. Nowhere in the world do people just open things up and, you know, are not taking care of, you know, their own law firms, their own professional services, you know. Now, when it comes to the procurement rules, and I'm very, very familiar with these procurement rules, you know, internationally, these rules are written specifically to favor international organizations. It's very, very simple. You can't get a leg in if you're a startup. You can't get a leg in if you're just getting experience in a certain area. And it's all, how do these international law firms have all this experience? It's a function of exposure. So what I would say is that, number one, if there are procurement bids going on in Nigeria, from the get-go, to increase local capacity, because I'll tell you this for free, Nigerian law firms are some of the best on the continent. I've worked across the continent. Nigerian law firms are some of the best. Two jurisdictions, mainly Nigeria, Kenya, South Africa, Morocco, Egypt, you get excellent lawyers, but anybody will tell you that Nigerian lawyers are on point. Because I've worked on deals, when I worked as a transaction lawyer in other African jurisdictions, and I just, I'll keep quiet on that. So for these procurements, it should be joint bids. If you're going to bid, you have to bid with a Nigerian law firm because we want to develop our local capacity to work on these transactions. So we won't have situations where we have just an international law firm working on a bid and there's no local law firm working on the bid. That's what. And even when the local law firm is working with the international law firm, there's a responsibility on the part of the local law firm to know that, look, this is a knowledge sharing opportunity to deepen expertise and get exposure. So for me, that's the first thing. The second thing also is, look, general counsels have a lot of responsibility in Nigeria. They have a lot of power. They don't know they have that leverage. So you're a general counsel in Nigeria, you're giving out all this international work, right? How are you using your leverage and position to ensure that the law firms that work for you reflect the environment that you're in? So you're giving work to international law firms. What's their commitment to diversity and inclusion? What's their commitment to the promotion of African lawyers? What's their commitment to the promotion of African law firms?
Today, I
mean, are they going to,
Yeah, thank you. I feel, sorry, we have just 10 minutes to treat the other issues, and I still have a lot of issues I want us to treat. But I'm going to come to Professor Sonny. I see that in the trend, global trend, generally, you find that taxation is one of the most profitable or flourishing practice areas on the global table of legal services market. But then what you find is, we talk about globalization and Nigerian lawyers are always, a lot of people feel very, some are about international law firms or international practice. But I recall about 2010, there was a global phenomenon called outsourcing. And it was like everywhere. And the Indian law firms cashed out real big on what they call outsourcing. But then Nigerian law firms earn almost nothing from outsourcing, as it were, right? In this globalized market, are we really meant to be competing or collaborating to deepen our market at this point? Let me lay a foundation to this. I read a paper about how the English lawyers became some of the best in mergers and acquisitions. And I saw that it was about when UK started privatization, about the early 80s, late 70s, early 80s. And what I found out was that what they did was to collaborate with the American law firms. And many of them had to migrate back to the UK, right? Practice out of UK. And then it was these transfer skills that made UK what it is today in terms of, mergers and acquisition and all that. So should we be cooperating or should we be competing at this point?
Okay, thank you very much, the moderator. Whether we are cooperating or we are competing, skill set is an imperative because you cannot give what you don't have. And for the young lawyers who are here, so that they are not overwhelmed, it takes time to acquire the right skill set. So the gestation period might be fairly long, but the good news is if you keep at it and you find a good place to learn, dirty your hands, make your mistakes, you're on your way to the top. So now, relating to whether we are collaborating or we are competing, to compete, you must specialize. So the era of jack of all trades is gone. The little visibility I have today is because I specialize. And I consciously did it. I left where I started my teaching career because taxation is dead in a provincial area. Okay? So there must be conscious effort to actually dig deep so that you can get to a point where you can engage, you can interrogate, you can begin to see that those who taught you didn't know it all. Then after specializing, you also need networking. And then in this globalized world, all your friends can't just be from your geopolitical area where you speak the same language. Even your outlook must be different. You can't go to a place and you are looking for ogbono, you are looking for ewedu. You must be cosmopolitan. So in the course of socialization, then opportunities begin to emerge. Then in terms, whether you are collaborating, it has to be what works for you, okay? You need to have somebody who is reaching out to you or somebody you are reaching out to. But what is important is for you to have value proposition, for you to make a success of whatever you are working on. So thank you very much.
Thank you. Chinua, I read an article about the way lawyers are trained in the 21st century, in this disrupted market. One of the things I found out is that Nigerian law school, and it's almost common in most African law schools, we train the first 5% to make first class from law school, right? And then by the time they come to the law firms to work, right, the law firms want to plug and play, and they want people who can actually think about money, who can generate money, who understands bottom line. Because at the end of it all, money is the fuel, to run international practice in this globalized economy. But then, what do you feel is missing in the way lawyers are trained?
Okay, well, before I go to the question of training, we've been assuming that Professor Ezilo pointed out something very important, the sophisticated character of the transactions we want to enter into. The question I ask is this: in this room now, how many people are even interested in learning those transactions? We are assuming that people are interested in learning, but they don't have the knowledge. Law firms in the US and Canada are ahead of us in certain areas. Are we even interested in learning those things? I've not seen any young person ask me questions or ask anybody questions, how do I learn MIE, or how do I learn it? Curiosity is lacking. There's no curiosity. Even when people encounter a word in a normal document, after high school, words you should know. People who are lawyers encounter this word or phrase or idiom. They don't look it up in the dictionary. They don't want to know what it means. So the hunger for knowledge is absent among many of them. Then the research mentality. Look at how we start cases in court. Lawyers go to court and say, ratio 3, ratio 4. What that means is that you are telling the court that the law reporter decided for us what the ratio of the case is. Whenever you say ratio 7, you are talking about the law reporter, not the judge court. It's already, they don't even read the case that they are going to use in court, let alone reading widely. So the problem is curiosity and interest. So when I teach, I say, are you even interested? If so, I'm wasting my time. If there's no interest, you can't really get it. Then the law schools and the faculties of law, well, they are understaffed in terms of numbers. They're also poorly staffed in terms of manpower, the brain power to teach. What they should do, because they have a system that is very crazy. They say if I know somebody who knows something, if today we had a faculty of theater arts, the great Yoruba theater artist, what was his name? Ogunde. Why don't you invite him to talk about it? You say you must have a master's degree before you teach. He knows it better than the master's degree people. He knows that subject better than PhD holders. Bring him to tell us what he knows, how he does it. Olusoyeka never had a master's degree. I hope you know that. Chinua Achebe never had a master's degree. Do what you know. So they have to supplement, the law faculties and the law school have to supplement their faculty with outside experts, like yourself now, for example. They should call you in. They should call Bila Sani in. They should call Mrs. Ezilo in. And you, call you to come and the practical thing you need to do. Then in terms of the skills gap that we have, I'll speak in a few minutes on the cognitive skills we need. And then I also address attitudinal orientation. The attitude, the cultural attitude is critical. If you have the attitude of law as a cult, most Nigerians see law as a cult, where they must wear black and talk strange language and speak legalese. And then ostracize the clientele, treat the lay people as inferior. You can't function. You have to change your attitude and respect every human being from every field and relate in a normal way with somebody. If somebody writes you start saying pursuant to, you're talking nonsense. You have to speak like a normal person and write email that makes sense. If they see one pursuant to in your email, they sack you in a serious transaction. So you have to learn to write normal English that educated people speak, not legalese. And you have to also, if you allow me 1 more minute, at the judiciary, we need to learn case management. The common law system gives judges power to manage cases, to push cases forward, and to impose costs to move cases forward. But even if it doesn't provide enough resources to do that, we can borrow from adjudication systems. Because right now, arbitration is forcing a kind of blend between both systems. You can freely borrow from the French, the German, and other systems that are not common law.
Thank you very much.
Yeah.
So we're going to be moving straight to question and answer. Although would have loved to have more time so we can say more, but I feel we'll be willing to answer questions from the audience. All right. Yes. Microphone, please. I have somebody here. Hello, sir.
Good afternoon, everyone. I think this is a very good panel because we have many professors in the panel. So my question is to be able to improve the skill set for the Nigerian lawyer. What's the plan to improve the curriculum? So something practical that we're doing to see how to improve the curriculum. Thank you.
Thank you. So, Prof, are you going to answer that question?
Thank you. I think the point need to be made that we must re-examine our legal education fundamentals. The curriculum, pedagogy, which is part of methodology, and the culture. And what is the aim and purpose? It's aiming at building knowledge, skills, and culture, which include the ethical issues. And then we have to then look at the whole gamut of issues. Remember, we're talking of skill set of lawyers who are already out there in the market, maybe. But the discussion in this area, interestingly, I think in a newly constituted MBA committee, I'm part of the legal education committee. And last year, there was a big conference on legal education hosted by the Afebalala University, which MBA anchored. Because the emerging areas of law, you have to have expertise as a teacher to teach that. And it's not just, yes, we're all doing in certain areas self-taught. I recall when ADR started, some of the old professors in my faculty then, like Jofo, had to move in to ADR arbitration, and they taught themselves that, and they're teaching it. We've moved also to the area that telecommunications, like Professor Sani S.A.N. said, he went on taxation law. And I recall even when I was doing my LLM over 30 years ago at the University of London, they started the Center for Commercial Law. I think we went to Queen Mary, did we?
Yes.
Yeah, exactly, at Queen Mary College. And then I was there. Then they were doing already specialization. When the keynote speaker said LLM was quite tough, I recall even in 1995, that's when I did LLM at the University of Law, we had over 400 courses to choose from. Over 400 courses. And all the colleges would take one exam. And I audited many because many was interesting, even though I was specializing in public international law. Then you look with a lot of human rights bias, but I will see human rights in developing world. And we go there, they will be talking about merger acquisition, all these practice, things coming up then. And Nigeria was already doing the Cameroon case and everything. You find that, yes, we can say Nigerian lawyers are quite dynamic. People are learning on their own, but there is issue of capacity, and that also deals with the people, admission process. I am a law professor, and I've reached the last step of law professorship in the university. I'm a bencher. I'm a senior advocate. I started teaching at the University of Nigeria in 1993, I've learned that 30 years ago, I've learned some things about educating law students during this period. First, most students today need to attend law school to equip them with a proper foundation to build their legal skills. And that we can be sure. In this our era of Japa, because we are losing people. In fact, at a stage, we had a lot of former student PhDs coming back that have studied around the world. During my deanship, even in 2018, at a stage, we were over 65 lecturers, among whom we have nearly half, PhDs from abroad. Now, all of them, they're all going and sourcing Japan. You have to
Prof, I think this is what.
But what is important? I think we need to do much more to build relevant skills for tapping, in order to tap into globalized economy. More so because of the gaps that exist. And we have to, because look at it, even ordinary, I won't say ordinary, but if you look at WTO and things that happen, you find that sometimes African countries, including Nigeria, are not able to even engage in that process and that sophistication of trade because we don't have the capacity. So simply people have to make cautious effort, and a system also helps, including government. From my experience at United Nations, being a UN, you see countries pay money to have their country people come to certain agencies, and they pay them junior JPO programs, WTO, WHO. And Nigeria, you put in money, you don't give condition. This is a place they can put $2 million, $5 million, 100 Nigerians to aside WTO, to go to WIPO, to go to this. But, our foreign policy is skewed. It's on a shoestring. And we don't have people even that are in the level of technocrats governing us that have capacity. As ministers, as things. And that is where we have the fundamental problem. Education, you have who was a minister for 8 good years in Nigeria. 1 step forward, 10 steps back. And how are we going to make progress with this kind of state of affairs?
Thank you very much, man. We're just going to take maybe 2 more questions. I'll take them together, and then after, the panel will speak to it in their closing remarks. Right, so,
a journalist.
Professor Bankole, SAN. Oh, okay. Yes, after you then, I'll take the lady behind you, sir. I'll take you first. I'll take the lady behind you, then I can take 1 or 2 from the online audience.
Yeah, thank you very much. The MBA is doing a lot in terms of capacity building for lawyers. Now, one of the problems with the universities is that NUC has rules about who can teach at what level. And so when we had some experiments at Babcock and tried to bring some people from a town to join the gown, and it worked. But because of these rules, you cannot have, if you don't have a master's, if you don't have many of the professors in Unilag up till the recent times did not have, just stopped at masters, and they were fantastic, Vergara and all the others, So MBA needs to engage so that we can have, when Professor Fagun was speaking earlier on, the examples he was giving is because those universities, like Queen Mary, they have the professors who are there full-time and the people who are experts from the town. Adjunct. So we need to work on that, and NUC will stop us unless we engage NUC. Otherwise, this thing will not work. Thank you very much.
Thank you. So, okay. Right, so do we have anybody from the online audience?
Yeah, that will become problematic.
Today, you want to make a point?
Yes, I want to make a point. Several points, in fact.
Yeah.
Several points, in fact, because there are several things I've seen, as we've, worked on legal recruitment in Nigeria and across Africa and globally. So we have something called the LLM legal recruitment, right? This service is focused on assisting Nigerians and African lawyers get roles in international law firms. Now, with the young lawyers, what we see is that there's not a lot of career counseling. Career counseling is a big deal because we see people basically score own goals and just mess up their opportunity, mess up their career trajectory, all because they're too focused on leaving the country. So I just wanted to point that out, that and to all the young lawyers attending right now, please do not, the fact that you're smart enough to go for a master's does not mean you should go for a master's after 1 year, 2 years work experience, or 3 years. I would recommend at a minimum 4 to 5 years work experience to really get the maximum out of it. We see people leave after 1 year, 2 years. They're not able to get what they want after the master's, out of the master's program, because they don't really have enough work experience and understanding of what they want. They're not yet specialized. That's the first thing. 2, I mean, if you're going to do a master's, you need to get a lot of counseling. There are partners in your law firm, there's senior lawyers that you know. Speak to them, speak on the schools, the funding opportunities, what you want to do post your graduate program. The fact that, you know, you want to just get out of the country, Japa, right? There are ways to do this. There's a way to do this where basically you're not leveraging on your academics here in Nigeria, and you're basically shooting yourself in the foot, really. Because people come to us and we tell them, sorry, you know, we can't work with you. You should have done this 2, 3 years later down the line, you know? So that's one thing I wanted to mention. The second thing also that I wanted to also mention is on, I think the NPA has to do something about this, but, you know, there are a lot of legal roles in Nigeria where, you know, effectively, and I want to be careful how I parse my words, where, you know, how do I put this? You have basically multinational companies in Nigeria, and there's no, even where they're Nigerian lawyers, the Nigerian lawyers are not effectively the heads of the legal departments or the general counsels in those companies. I'm not talking about situations where they have, you know, a general counsel in maybe Singapore covering Middle East and Africa, and, you know. I'm talking of companies in Nigeria where they're Nigerian lawyers. So we need to do something about this, because unauthorized practice of law is rampant here in Nigeria. Whether we want to believe it or not, it is rampant, it is happening. And, you know, for me, Nigerian lawyers have to get the due exposure to the work in their country. So that's the second thing. On the JAPA syndrome, we need to do something, because it's a crisis. If you ask any of there are no senior associates in Nigeria right now. If you ask any of the top corporate law firms, there are no senior associates. So they're effectively working with just, you know, associates 1 to 2 years and partners. And it's not a unique phenomenon to Nigeria. This is happening in South Africa, has the same issue. Kenya has the same issue. And we need to start to think about how we're going to, you know, develop talent to replace the talent that has left. Now, for the lawyers for the young lawyers in the room, this is an excellent opportunity for them, because at a very young stage, you get exposed to a lot of work because the senior associates are not there. So it's up to the young lawyers to be studious, diligent, get that
take
transaction
advantage of the opportunity. Yes. Thank you very much.
And, you know, the sky's the limit.
Thank you.
Okay, thank you. That's all.
Thank you. Very valid points. And maybe I don't know if anyone still have anything. I mean, something to say.
I think the issue, and you made the point, bro. In terms of learning skills, we need to have an open mind, openness to learning something new.
Yeah.
And gone are the days when lawyers could consider their education as done and over. Especially, we call ourselves learned people. We are learned. So in it, you know, is a done deal. So it is still being determined whether a contemporary lawyer can still assume that he or she is indeed learned.
Should be dropped.
Given the ever-changing standards and the technological development, we still have a bit of a gulf or disparity between analogs and the digital. and you have to be open to teach yourself. I was telling my student, okay, we do Zoom, and Telegram will admit people, it's cheaper for the student. You find new ways of even engaging. And I recall a colleague who was to be given a scholarship to do some fellowship. They said, can we meet by team? He started asking the people in South Africa, what is team? And whether team, that he doesn't know that one, he knows. And then before you know it, they just, put her out and know that, no, well, this is not what we need at this stage. So cognitive learning and all we have learned outside law directly affect our abilities. So we have to learn, unlearn, and law classes should evolve, including training that will transfer skills and have all of these things. Because for us to key into and become actors in the globalized economy, we will have to come well equipped. And there is a deliberate action. I'm one of those, I don't know how people feel about it, but I think because we don't really question, not only just power of questioning, but actually decide in the overall and larger interest of the country. I don't think we need law school anymore.
Thank you very much, man. Thank you very much.
I don't think we are sitting in their building, but the truth is we need to look at things differently. 5 years legal education, people can start doing their clerking by law chambers, beginning to specialize, going to areas, and they will be designated over. But now, it's not going to be one-day affair. If we need to do it in 30 years, we need to plan now. And in 20 years and at the end of this is how we are going to do. There are others today in other Francophone countries, they go in to specialize. If you're going to be a judge, either criminal division, either accounting, either this, either that. And people do get that and it's impactful. Look at our population. It doesn't make for the kind of education and equipping people with the skill we need. Even to engage through secretaries, even legal education. And the same way, you garbage in and then they move in that numbers to law school. It's not sustainable in the long run. No. It doesn't help to put the skills people need. And that is the truth of the matter. But maybe as we move on with we are expecting, there will be changes. But we have to be able to look at this comprehensively and take a decision.
Thank you.
Thank you.
Just by way of conclusion, I feel generally there needs to be a rethinking around what legal profession should be, even in Nigeria in the first place. What I find out in the UK, and I see all the time when they come for legal services mission in Nigeria, you find that they come with the client and they're prospecting out of our space, right? But the only time Nigerian Bar Association went outside, we went for photo ops, and we can't really say. But if you look at the history of the legal profession, we are economic diplomats. We are the ones who are supposed to be at the forefront of economic diplomacy, bringing even these our international clients to Nigeria. One of my friends told me that he was looking for a particular mineral, somebody that has license of a particular mineral in Nigeria, and he works with an international law firm. And I asked, what is your own interest in that? Are you investing in this business? He said, no. He's finding it for his client. If he can get this, somebody that has this license for his client, they have the money, they will come to Nigeria and partner with that particular person, and it's a very big industry, right? So these are some of the things that, I feel is lacking. What exactly do we want lawyers for? Is it just those who go to court or who write agreements or what that is? Even our judiciary as well. Judiciary contributes to the economy of a nation, generally, in terms of, the returns on the cases. But here, because we can file for 1 naira and 2 naira, we file all sorts of frivolous matters in court. If a lawyer knows if I file this, I will be penalized, heavily penalized, he won't dare it. And the judiciary itself will make money from such unethical lawyers. So these are some of the things we need to look at. And for young lawyers, my advice for you generally is that beyond the letters of the law, try and improve yourselves in some soft skill areas, including business acumen. Today they've spoken about networking, they've spoken about your social skills. All these, you can deepen them by learning a lot of finance, business acumen, networking skills, communication skills, presentation skills. These are all skills that you need to acquire to be able to, compete in this globalized world. And for those who want to japa, I am not against it. Please go. The ones who went and left India, they went. over of hundreds of years. They jackpot from India. By the time they are returning today, Indian legal profession is better for it. So there will be a time when people will go, like the Israelites, who will go to exile. And there will be a time when we'll return back to Canaan to rebuild the fallen walls. Thank you very much.
You are assuming that the Red Sea will part.
Yeah, there has wrong answer. Preface.
Okay.
Thank you. Thank you. Thank you for the invitation.
Thank you so much, Indore. Thank you.
Thank you for the invitation.
Thank you very much.
Good afternoon, ladies and gentlemen.
Can you help me remove this?
May I use this opportunity to say thank you to the moderator, Mr. Fashola, and the panelists, Prof. Ezelo, Prof. Abiola, SAN, Prof. Fagbon, SAN, the international recruiter, Mr. Tunde Shimori, and Mr. Azuzu. Thank you so much. Please, let me invite the chairman and other members of the committee and ESCO. Let's take group picture. Then we just present the plaque to them and we move on to the next session. Thank you. Mrs. Ali. Mr. Joseph, please join us.
Moving on to the plaque presentation.
Professor
to our
Joy
speakers and moderator.
Ngozi Ezelo, please. Your plaques, please hold on and.
To our speakers, please, we need to do a plaque
the
presentation.
Speakers, please come back and collect your plaques. All right. Professor Sonny, please join as we present this plaque.
Without him, I'm not taking this plaque. Where is my
Prof?
Professor
Sonny.
I said without him.
All right. Thank you, Prof, for being a part of this.
Thank you.
Mr. Chinua.
Mr. Chinua Azuzu, please. Thank you for your contribution. Mr. Tunde Shimonyon and Professor Fagbon will deliver their plaques to them. Mr. Fashola. Yes. Mr. Lere Fashola, thank you for moderating this session. Thank you, ladies and gentlemen.
Thank you, ladies and gentlemen. A round of applause for our second plenary section. What a very worthy time. Thank you to our distinguished professor and other resource person who delivered excellently on that section. So, ladies and gentlemen, we will be taking a short break. And this break is going to comprise of a musical interlude. The sound team will bless us and give us some very scintillating music. And while this is ongoing, we will also be having our lunch break. So in case you have not observed your tea break, you can go back to the section, the room over there. And also, we'll also still be convening there for the lunch break. And by the time we are done, by 2 p.m., we shall reconvene back for the third and fourth plenary section. So I do hope that you're having a very interesting time, and we'll continue to deliver a very excellent conference and other season activities for the course of this week in the NBA Lagos Law Week. Thank you very much. DJ, we are waiting on you. Yes.
See, I don't look like waiting, I don't see. I will never forget the 90s. Many nights I go they beg for mercy. Sickle cell pain showed me crisis. Thank you for the journey, oh Lord, oh Lord. If I say my story, oh, fire can't school, I'm ever blazing. I roll deep with the I did try for myself. VIP no regular. Can't copy this formula. I ain't fast Angel. I did try for myself. VIP no regular. Can't copy this formula. Money no filter, don't let them fool ya. Make your rubber, stack your paper. Let them know when you pull up, pull up. Man down when I pull up, pull up. I'll be a leaker, fuck the chaser. Bang, 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 Undertaker. They scared when I pull up, pull up. Yeah, road mafia.
And please, DJ, please lower it a bit. So just an additional clarification. In case you were not here when we observed the first tea break, if you follow the room on my right-hand side, starting from here, you can go there for your tea break if you've not observed. And then for the lunch break, they will need to be seated. The lunch break will be brought to you. But if you still want your tea break, please, I know since you're sitting facing me, so that should be the room on your left-hand side. You go over there. There are ushers to direct you and guide you. And please just sit down. The lunch packs, they're handing it out now. So just sit down to ensure you get one. Thank you.
Maybe it's 'cause we're just two fools, broken by love. We know how to pick all the pieces up. It's a storm outside of you, baby, trust me, you the truth. Can you hold me like I ain't got forever? If it's a flood, then we gon' float. You know I see what you don't. Make you better 'cause I keep it together, yeah. You know it's good, you know you're mine. I put in work, you know I'm fine. Won't do too much, but still we gon' try. Me not chasing you, you not changing me. We know ain't no crossing that line. You not scared to move, I ain't sweating you, 'cause we both know better this time. Maybe it's 'cause we're just two fools,
contemplate me. Don't want me there with you. I realize love don't cost no dime. Love is crazy. You amaze me, girl. You amazing. All I got them only really want to play me. Don't want me there with you. I realize love don't cost no dime. Yeah, my baby, love don't cost no dime. Love don't cost no dime. There used to be a graying tower alone on the sea. You became the light on the dark side of me. Love remains a drug that's the high and not the pill. But did you know that when it snows, my eyes become a larger? The light that you shine can't be seen. There is so much a man can tell me, so much he can say. You remain my power, my pleasure, my pain, baby. To me, you're like a grown addiction that I can't deny. Won't you tell me is that healthy, baby? Did you know that when it snows, my eyes become larger and the light that you shine can't be seen? Baby, I can bring you to a kiss from a rose on the grave. Ooh, the more I get of you, stranger it feels, yeah. Now that your rose is in bloom, a light hits the gloom on the grave. I've been kissed by a rose on the grave. I've been kissed by a rose. I've been kissed by a rose on the grave. I've been kissed by a rose on the grave. There is so much a man can tell me, so much he can say. You remain my power, my pleasure, my pain. To me, you're like a grown addiction that she can't deny. Now, won't you tell me, is that healthy, baby? But did you know that when it snows, my eyes become a larger and the light that you shine can't be seen? I can bring you to a kiss from a rose on the grave. Ooh, the more I get of you, the stranger it feels, yeah. Now that your rose is in bloom, a light hits the gloom on the grave. Yes, I can bring you to a kiss from a rose on the grave. Ooh, it's the glue on the grave.
Body they throw me like a banana. Body they rise in my tongue, I say come on, you broke out, no go this logo down. Kelly they bossy my pololo. Can make a salute your commodore. Kelly if you balance Diego, I get paper. No go do me Diego, my Maradona. Kelly if I lap your sueto, I'm a farisa. Kelly your back, keep it connected. And I can follow your Cresco. Sunday, down the Cresco. Pay for your waist, and I could pay for your lace. Whatever waist. Sunday, down the Cresco. Pay for your waist, and I could pay for your lace. Tell if you balance Diego, I get paper. No go do me Diego, my Maradona. Tell if I lap your sueto, I'm a farisa. Tell your back, keep it connected. And I can follow your Cresco.
You see, true love, she used to leave here before, but I done messed up and threw her out the door. Now I don't feel irate like I used to before. All the things we used to say, all the way we used to play, how we used to play. Now there's an emptiness inside of my soul, and they say my manliness will start to show. And God knows I cannot take it no more. That's why I'm asking you, how do I come up with you? You see, I'm looking for someone to satisfy me, looking for someone to love me completely, looking for someone to show me true love. And I'm searching for that kind of possibility, someone to truly love me for me, someone to come and be my true love. Now loneliness is the order of my days. Since she's gone, I feel like fading away. Lord, not die day. Oh God, hey. See now she gonna make my head been this way. Now that she's gone, I feel like jumping in a well. Oh, I cannot take it no more. That's why I'm asking you, how do I come up with you? You see, I'm looking for someone to set my someone to love me completely. Looking for someone to show me true love. And I'm searching for the kind of possibility. Someone to truly love me for me. Someone to come and be my true love. 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 Oh, hey. Seen her shivering and make my head in this way. I feel like jumping in away. Can I take it no more? Oh God. You see, I'm looking for someone to satisfy me. Looking for someone to compliment me. Looking for someone to be my true love. And I'm searching for the kind of possibility of someone to truly love me for me. Someone to come and be my true love. 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 Yeah. Seen her, seen her, make my head in this way. True love, where's my true love? True love, I feel like fading away. Where's my true love? True love. See, I'm looking for someone to set my soul free. Looking for someone to love me completely. Looking for someone to show me true love. True love. And I'm searching for the kind of possibility. Someone to truly love me for me. Someone to come and be my true love. True love, true love, that's my true love, true love, that's my true love, true love, that's my true
So we both gave up, can't take it back. It's too late, we reached the climax. I've fallen somehow, feet off the ground. Love is the cloud that keeps raining down. Where are you now? When I need you around, I'm on my knees, but it seems we're nowhere fast. We've reached the climax. We're together, now we're undone. Won't commit, so we choose to run away. Do we separate? Oh, don't wanna give in, so we both gave up. Can't take it back, it's too late, we reached the climax. I gave my best, it wasn't enough. You get upset, we argued too much. We made a mess of what it used to be love. So why don't I care at all? Give it other separately. I just need you one more time. I can't get what we had on my mind. Where are you now? And I need you around. I'm on my knees, but it seems we're going nowhere fast. We've reached a climax. We're together, now we're undone. Won't commit, so we choose to run away. Do we separate? Oh, don't wanna give in, so we both gave up. Can't take it back, it's too late, we reached the climax. Do
Hello, ladies and gentlemen. I hope we're all enjoying our lunch break. So I just want to drop a little reminder. We will be reconvening back for the third plenary section in a few minutes. So please, if you have friends or partners or colleagues that stepped out, please just remind them or give them a tap notification to make their way back to the hall so that we can get seated and organized for the next section. Thank you. Okay, I got a very interesting question from a member of the audience. She said, what is my few minutes? Don't worry, a few minutes could be a range of 10 minutes to 20 minutes. But we'll just be diplomatic around that. Thank you.
Trying to find
Okay, thank you to our sound guys. The interlude was very scintillating. So while we're rounding up with our lunch, please, we'll have to start getting ready for our next section. I believe that we have been getting the best of everything at the conference, from the entire logistics to the resource persons we have impacting knowledge, to the beautiful phrases we have for the purpose of networking and great conversations. And I hope that even while we continue on the successive days, we'll also continue to have a very perfect experience. So moving on to our third plenary section, the topic for conversation is the ease of doing business in Nigeria, lessons learned, and the way forward. So I believe that we are all looking forward to this conversation, especially if we're interested in running a law firm or starting up a partnership or running a legal startup or whatever kind of business which a lawyer is blessed to start. So to have our moderator here, we have Ms. Uto Upana, the company secretary of MTN. Uto Upana, the company secretary of MTN. A round of applause, please. I know that our mouths are busy, but I trust that our hands are still a bit flexible. Please, Regina, confirm if our moderator is around. Okay, so let's go ahead and introduce the rest of the speaker on the outline. We have Professor Wale Olawoyin, SAN, the managing partner of Olawoyin and Olawoyin. Your presence is highly recognized. Please proceed to my right-hand side. That's where you'll be sitting. Oh, you're welcome. Thank you, moderator. Please join us. Oh, you look very elegant. Thank you. And of course, just as I initially introduced, the managing partner of Olawoyin and Olawoyin. Please, a round of applause. Let's give him a very deserving ovation. Thank you. And also moving on, we have Mr. Ayokunu Ojeniyi, the project manager of PEBEC, PEBEC. You're highly welcome, sir. Please don't worry, our speakers are joining us. The logistic team are just trying to get them on the mic, so you will see them very shortly. And also next in that order is Mr. Yomi Adebanjo, General Counsel, Main One. You're highly welcome. Thank you for joining us. And Ms. Ada Osakwe, the founder of AgroLay. In case you're just walking into the hall, please remember the topic for this plenary section is the ease of doing business in Nigeria, lessons learned, and the way forward. And in our usual fashion, please get your questions ready in the course of the deliberations. If you have any question or promptings or clarification, or you want to contribute to the topic, you're very welcome to do so at the ending of the section. Do have a very enjoyable time. Over to you, moderator. Thank you, ma.
Thank you very much. I'll just wait for the panelists to be seated. So please give us a few minutes.
Tuck me right in the corner. No, he's got it. No, I'm good. This idea.
Let's. Thank you very much, distinguished ladies and gentlemen. I think there's an echo somewhere. It's absolutely delightful to have the time to engage in this conversation. I believe this mic should go, probably to minimize the echo. Thank you very much.
No, it's going to be over.
And we have a distinguished panel here to discuss ease of doing business, lessons learned, and the way forward. In 2016, apologies for that break. I paused so that the panelists could be seated and so that we can start. In 2016, the government at the time set up PEBEC, and the whole essence was to converge all the efforts and also implement reforms to eliminate all the bottlenecks and bureaucracies in the system, essentially so that businesses, it would create an enabling environment for businesses to thrive in the country. And so we're going to have a conversation around the subject, the ease of doing business, the lessons learned, and the way and the future, the way forward. So I have a distinguished panel. They have all been introduced. And I think I need them. Oh, wow. Okay. So it's starting off on a good note, ease of doing business. And so I'm going to start with Mr. Ojeniyi. And usually analysts would, in terms of deciding whether to come into Nigeria to business, they tend to look at the ease of business rank index and see Nigeria's positioning in that index. What's been the journey so far? When I looked at the index in 2019, Nigeria was 131. Last year, we were 150. And so what's been the journey so far? What are the success stories on that journey?
Thank you, and very good question. In the last couple of years, as you rightly said, the PEBEC was established to remove bureaucratic constraints to doing business in Nigeria. Between 2016 and 2019, Nigeria moved aggregate of 39 places on the Global Ease of Doing Business Index from 170 in 2016, from 170 in 2016 to 131 in 2019 before the World Bank rested that report. A number of reforms have been implemented. One of those will be the passage of four major laws, as we would say. In 2017, we passed, working with the National Assembly, the Credit Reporting Act, 2017, Secure Transaction Immovable Asset Act in 2017, and of course, CAMA 2020, which is Nigeria's most significant business legislation in 3 decades, and most recently, the Business Facilitation Act 2022, that seeks to amend 21 different legislations and also codifies the Executive Order 01 on transparency and efficiency in the business environment. We've also worked with the judiciary, establishing 9 small claims courts across 9 jurisdictions now, states judiciary, and Lagos State sort of breasted the plate with that, and we know that hundreds of cases have been decided in the small claims court. Working with the subnational, which is very central, we know that people essentially live in states, within the judiciary of the states. Again, working with states to pass a number of reforms, and most recently, we've now gone in partnership with the World Bank, providing some incentive to states governments to implement these business climate reforms, and that is starting this year, essentially giving states a head start, saying if you implement this and this, you get certain disbursement of money, and there's been significant interest from states in that regard. We believe working with the state governments would be a game changer, because a number of issues that people deal with, the businesses deal with, it sits within the remit of states. But it's not to say that it's all been all rosy. There are thorny issues. Some of the problems we've had that we've not been able to resolve, the trading across border, making sure our ports of entry easy to do business. But perhaps one of the most significant reforms, if not, would be that now we are speaking about ease of doing business. It's now an agenda, so to speak, on every mouth. Elevating the issue so that people will actually understand that Nigeria indeed can be a friendlier place to do business in terms of cost of doing business, making it easy, clarity of procedures, and of course the time of getting permits and licenses, so to speak. So I'll leave it at that. Thank you.
Thank you very much, and thank you for articulating all those initiatives. I will move on to Professor Olaoyin. We recall that in February 2023, the Business Facilitation Act, or as some would refer to it as the Omnibus Act, was signed into law. What are the major changes? Again, this is another effort to try and eliminate the bottlenecks and make sure there are synergies in the system. So what are the major changes in that act? And take us through what that act seeks to achieve.
Thank you very much, Uto, and thanks to MBA for giving me this opportunity. I think before I talk about some specifics in the act, I think it's important to have some context to how we arrived at the act. And when we talk about ease of doing business, I mean, a simplistic way of explaining what we're trying to do is that there is recognition of the need for a seamless interface between private enterprise and public institutions. That is just a simplistic way of talking about ease of doing business. But we all know that private enterprise cannot operate in isolation. There must be regulation by the government as a sign of an exercise of sovereign authority, as it were. So you can imagine the tensions between the basic instincts of a private entrepreneur who wants to make profit and the instincts of government trying to control that appetite. So in that context, government then decides, look, we need to take steps to ease the tensions between this competing interests. So like Ayokunu said, in 2016, set up, in 2017, there was Executive Order 001. But because there are potential legal issues with executive orders, in my view, it became imperative that some of those laudable initiatives had given some kind of statutory imprimatur, and that is what essentially led to the Business Facilitation Act of 2022. And like this is an amazing piece of legislation. And for even PEBEC to be able to achieve what they achieved in this law is an exceptional achievement. Trying to amend about 21 different legislations, but not in the sense of substantive reform of those laws, but just picking up sections of those laws where there's an interface, particularly in an administrative context, between a private investor and a public institution. But it's interesting to just look at some of the provisions, particularly, like I said, the codification of those objectives, Executive Order 001 of 2017. Because the most important thing, or one of the challenges that private enterprise has in the interface with government authorities is the uncertainty about when you will get what you are required to get from government. So one of the key things that you will see, apart from the statement of the objectives, which is to promote the ease of doing business in Nigeria and eliminate bottlenecks, the most important sections that I would invite people to look at in their spare time, which I consider to be not only innovative, but actually transformative, are sections 3, 4, 5, and 6. So what those sections try to do now is to impose obligations on MDAs. Prime obligation is that if you're an MDA that is enjoined to issue licenses, give permits, and stuff like that, you are under an obligation now to post on your website what the requirements are to get those authorizations, and more importantly, stating the timelines that is required for you to obtain those authorities. But the most important, in my view, is the section about default approvals. You know, we've experienced in the past that you apply and months on end, you are waiting for a decision from government or the public agency in question, and it's not really forthcoming. And for those of us that do advisory, particularly in the context of foreign direct investment, I mean, in initial opinions that you have to do, a foreign investor would, you list to them all the permits that they need, and the next thing that the foreign investor would say is that, what time will it take for me to get this one? What time will it take for me to get this one? And then you say, oh, well, from my experience, probably 4 to 5 weeks, but you never know, and then, you know, the foreign investor starts getting jittery. So Section 4 has pretty much cured that. And what it does is that because it has imposed an obligation on the government agency to now expressly state the timelines for whatever permit that you are going to get from that agency, what Section 4 then says is that once you meet those documentary requirements and you submit your application, the clock starts ticking for that government agency. And once the period that the government agency itself states to be the period within which they're expected to give you license, they fail to give you that license, then you are deemed to have obtained that license. So you can see that is an extremely transformative provision in there. And on top of that, then says that once that time expires, because ordinarily your foreign investor will still want to get some kind of document out of government to say that they've gotten the permit and stuff like that. The section then says that after the expiration of the time limit, once you send in notice to the public agency for them to issue you a certificate within 14 days, to all intents and purposes, that your notice itself constitutes the permit, as it were. Then there are obligations on the MDAs to also have service level agreements. As I said, the Act amends 21 laws. CAMA 2020 is there. You will see that most of the laws there are the laws where there is all interface between investors and government agencies like the NIPC, the Customs, the Immigrations Act. I would urge people to look at it. Just my quick 3 takeaways from this extremely important legislation. One is that the area that it covers will still not be sufficient to give the level of comfort for investors, and I'll tell you why. Land remains a major factor of production, and those are issues. Ownership of land, development of land still remains with the states. Happy when Ayokunu again mentioned that government is engaging with subnationals, because I believe that the subnationals themselves also have to pass some kind of business laws in the context of time limits for governor's consent, for example, building up which are critical aspects. Second point is that the BFA now demonstrates to us that as a country, we should not be waiting 10, 20, 30 years to amend our laws, okay? You will see that CAMA passed in 2020. In this BFA, there are 20 amendments to CAMA 2020. So that's in a space of 2 years that we've seen amendments. So a good thing out of this is that the legislative arm and executive should come to the realization that as business evolve, as issues evolve, there might be need to be changing the laws on a regular basis. And my last point is that we should all remain vigilant to ensure that the MDAs are compliant with this act. And I did a small exercise this morning. I just went onto the website of NIPC and I saw that they were compliant, CAC compliant, Immigration compliant. So joy cometh. Thank you very much.
Thank you very much, Prof. Indeed, joy cometh. I'm going to take up your last point, which is the cohesion and the cohesiveness amongst the ministries, the agencies, and all the other arms of government. And I'm going to go straight to Mr. Irukera, because that is a field where he plays and has advocated a level playing field. He's a strong advocate of that. And being in that space, all the reforms, the legislations can be on paper. What has been achieved in actual fact? And particularly taking into consideration your agency, your commission's mandate. What's your role in ensuring that the ease of business agenda is achieved?
Thank you very much. Good afternoon. And thank you, Lagos.
If you don't mind, please speak into your mic.
I believe, okay, sorry. And thank you very much, Lagos MBA, for inviting me. For a moment there, I had my heart in my mouth when Professor Olawoyi was conducting a roll call of agencies he considered compliant. But you make an important point when you talk about how the dynamics of the best intentions can actually ultimately provide benefit. Because in reality, the best built train in the world would be absolutely useless and perhaps even be if it wasn't put on tracks. I suspect if you put the best built train in the world in the water, it would become an impediment to ships sailing. And so it is important that there is a framework. Of course, there's the legislative framework. PEBEC has actually straddled both sides of this from an execution standpoint. Interestingly, I think the work of PEBEC started more from the execution standpoint and worked its way back to the legislative framework. Understandably so, because the sense of urgency that was required meant that legislation would take some time. And in our experience, and I think the FCCPC is a perfect example of how the dynamics of working together can demonstrate the problems. In the sense that the FCCPC has some kind of is an orphan, has no parents, and essentially pokes his nose into literally everything, both from a business standpoint and from other government entity standpoint. I'm considered a busybody. A building collapses, the FCCPC, something goes wrong with airtime, FCCPC, and we embrace the responsibility. But each of these roles, each of these functions also have some regulators who, in fact, are experts, and we're not experts in any of these things. And so the way the agencies and the ministries work together is vital. And one of the things we've seen with the executive order, and that we're beginning to see operate, for instance, is government says, look, if something is in your custody as the government, you cannot require private citizens or businesses to go procure it. And so you'd see that in the relationship with the Corporate Affairs Commission and FIRS, for instance. And so what we're seeing is that certainly it's easing up. And if you think about the difficulties we have now, you can only, you almost want to wonder how were our lives even livable before PEBEC started. And I think that there's still significant bottlenecks that need to be fixed. I even said that earlier on. You think about the single window with respect to clearing things out of the ports. Just think about the sheer number of agencies and documentation that you have to deal with to get things through the ports. A friend of mine was telling me that we're doing a study tour in Singapore recently, and what they were racing against time to reduce the time it takes to clear a container from 9 seconds to 6 seconds. And in Nigeria, it could be 118 days. You know? And so there's still a lot of work. But what we've seen is technology is a very powerful tool. And in the FCCPC, we've seen that. When we were approaching COVID, we realized that we needed to make sure that transactions could continue. And so what we did was to set up a dedicated email address for merger notifications. So people didn't need to travel, people didn't need to come. And what we saw from that was to migrate a merger notification to a technological platform, which is what we do now. And I think we're probably one of only 2 countries in the world where the entire can be done electronically without meeting with anyone, without seeing anyone, without having to ask any questions. And all the questions you might want are right there on the platform, including calculating even the notification fees. And so I'd say technology is an important part. And in closing, we will always have areas of overlap in regulation. And that those overlaps exist is not a failure of the legislature, or it's not laziness. It's actually an indication of what a nation prioritizes. Where you have regulatory overlaps, it shows that that's an important space to that country. And what has happened globally is that all the regulators find a way to bring their expertise to operate best. Now, does that eliminate conflict? No, because we would continue. I mean, and I keep giving an example of when I practiced criminal defense in Chicago. I remember on one, I practiced both immigration and criminal defense. I had a gentleman arrive, apparently from Nigeria, who it turned out was carrying narcotics. And so in that airport, you had the DEA, jurisdiction over narcotics, the FBI, jurisdiction over narcotics, U.S. Customs and Border Patrol, jurisdiction over narcotics, Illinois State Police, jurisdiction over narcotics, Chicago Police Department, jurisdiction over narcotics. And they had their battles, but you could see how they worked together. The moment we made a call saying that, look, I know that there's someone there, I'm his lawyer and I want to get to speak with him, the clock for how long they could hold him started running. And so what they did was to give him to the immigration service, which is not criminal. And so they could have immigration hold him while they were a bunch of other things. They wanted to see who was meeting him, so they spoke with the O'Hare Police Department, saying, make sure that you're not exiting any arrivals through this gate anymore, until the gate thinned down and they saw 2 men waiting. And when those 2 men got into their cars and were leaving, they got the Chicago Police Department to do a routine traffic stop just to get their identities. And so you would continue, and it doesn't mean that they don't battle, but they work at it, and we will keep working at it as a country also. We would continue to have disputes as to turf, but we will continue to work at it.
What I might say at a forum like this to lawyers is that in my limited experience in government, the biggest disputes we've had between regulators are promoted by lawyers. Almost every time.
I'm going to ask you to hold your thoughts right there. And because we actually need to move and hear from, and thank you for that really insightful illustration. And it takes me to Mr. Adebanjo. They say he who wears the shoes knows where it pinches. You are a private sector player. And we've heard about the reforms. We've heard about all what the BFA and other legislation that have gone into creating and enabling a business environment in the country. I want to hear your experience as a key stakeholder in the private sector. What has that experience been for you? Has it translated into gains? You know, do you experience it, or are these all just efforts and documents that have not translated into actual gains?
Yeah, thank you very much for that question, and thank you for the NBA for having me with this distinguished panelists. So in terms of, answering that, and, it's good to reel out all these laws that have been passed. But I think one common mistake we always make is to think that the reform starts and ends with the passage of legislation. No, that is just the first step in that entire value chain. So if I was to answer that question, it would be very ambivalent. Is there a conducive, enabling environment for business? Let's look at the ad facts, right? Let's look at the numbers. If indeed there was, you would look at your GDP, you would look at it shrinking, you would look at your income per capita for individuals, it's very low, it's 0.8%. You would look at your employment rate, whether it's unemployment or it's underemployment, it is falling through the cliff. But again, that's a very nuanced way of looking at it, right? Because again, I'm coming from as a business person. So the point there is that, the beginning of creating that conducive environment, yes, might be, having the laws in place. But what I see as the biggest pain point is that there's usually a dissonance between, you've created this really great law. It's like a perfect blueprint of a skyscraper, but you've not built anything yet. So what does that mean by you've not built anything yet? So I still go to, if you look at the indices for measuring ease of doing business, for instance, maybe it's getting a permit, and you're looking at it holistically. Yes, people like FCCPC might be far ahead in terms of the value chain, in terms of that process, and they've seen a significant amount of progress. But if you were to look at other areas where you could get permits or registering a property, those simple, very simple things are still a big issue. Registering a property, even getting a little as a permit from your local government for something that you need. What about issues around multiple taxation? What about issues around, regulatory lack of any oversight on the regulator itself? Because one of the biggest issues that we also see is that you have regulators that are both the judge and jury in a number of sectors. So where is that omnibus or that person that provides oversight even to the regulators themselves? Or even in terms of even measuring the efficacy of a legislation. You've passed the legislation. Is there a body that is set up or that is looking at, I know PEPEC would have that bit of that mandate, but do they have enough coverage to be able to do that? That is set up to really ensure that all the stakeholders that are relevant for that particular legislation are making sure that everybody's adhering to the key parameters that have been set by that legislation. So for someone like me that is wearing two hats, I double hat. I'm both the regional business head of my organization and also the general counsel. And because I deal with other markets, so I cover Ghana, I cover Cote d'Ivoire, and I cover a lot of Francophone West Africa. Now, because I deal with a lot of other markets, you get a sense of where do you find it easier to allocate capital? Because the whole essence about ease of doing business is really the choice for private capital to decide where they're going to allocate that private capital. Would I put it in Lagos or would I put it in Abidjan? That has a more seamless process, that has a set of laws, the OADA rules, that makes a lot of sense for if you're a Francophone-speaking organization, for instance. So those are the kind of questions that you would ask. And I dare say that I don't think we're there yet. I think if you also look at since when PEPEC came on board and the amount of reforms that have happened, I think there's been appreciable progress. However, I think there's still a lot of work that needs to be done in terms of reducing the bottlenecks, in terms of streamlining the taxation, in terms of making sure that ministries, MDAs meet to timelines, in terms of digitizing the MDAs, leveraging technology a lot more. Why are they not leveraging enough technology? I'm not going to say that because I'm in the technology business that they should be leveraging us, but in this day and age where you could be moving a lot of your resources off-prem, right, rather than keeping it in-house. Why are you still using a lot of manual? There's still a lot of manual processes that is involved. I view evolved into using a lot more electronic data. Where are you keeping your data? Those kind of things are the simple things that will help any organization to make that decision as to decide where to allocate capital, where it seems that not only they will get the best returns, but also that where they know that it's easy to do business. One other thing that I would say is enforcing contracts. That's another also a big bottleneck. Until we see significant reform in the judicial process, at the pace at which contractual issues, whether they go to court, are resolved, right, we will continue to lose out a lot. And I say this because why is it that today you're doing an acquisition, an M&A, and in the SPA, people are putting England and English law as the basis for governing law, or are using, whether it's for arbitration, they're using unicitral or they're using ICC. Why? Nigeria, I've always said, should be is the powerhouse of West Africa in terms of, yes, numbers and economy, but also in terms of the judiciary. We should be the ones, everybody around West Africa should actually be using us as the basis for governing law or even legislation, governing law or even dispute resolution. Can you imagine the quantum of cases, or the quantum of, even if there was clarity in terms of enforcing contract and there was clarity in terms of the judicial process, can you imagine the sheer volume of transactions that will be coming here because they are using Nigerian law and Nigerian courts as the dispute resolution mechanism?
I mean, you've raised some very germane issues, and particularly those that should be really of interest to us as legal practitioners. And I'd like to move because the issues you've raised, if they are so, enormous for you, I wonder what that would look like when we look at the SMEs. And so I'll ask Ms. Osakwe to, share her experience from an SME perspective. What are those benefits that the ease of doing business has brought for the SME community? And what are those challenges? Because just sitting and listening to Yomi speak, I'm like, well, if this is the big guy, how much more the little guy and the smaller players?
The little woman, right?
Absolutely.
Over 40% of women here in Nigeria are SME owners, are entrepreneurs, so it's a big thing. So thank you. Thank you for having us have this really pertinent conversation. And thanks to the NBA, between 11 and 250 employees, or just under $1 billion naira in assets in your asset base, being in the formal sector, these are all criteria that make you an SME. So I'm an owner of a small and medium enterprise here in Nigeria, right here in Lagos. And like me, others who are actually SMEs as well, we apparently contribute about 84% of employment to the economy. We contribute 48% of the GDP. So I would want to believe that what concerns me concerns the economy. What concerns me concerns my government. So, I can share with you my big concerns. And as I think about it and take a step back, for what are the maybe overarching things I think about when I wake up or trying to sleep at night? What are those maybe two big issues around the policies, the governing laws, the processes that affect my operations? Two things. I want to operate peacefully. I want to operate profitably. It needs to make sense to me. So I hear the reforms PEBEC has put in place. I think it's fantastic. It's a great step in the right direction. It's about time we had the competent people in place to drive such policies and eventually laws forward. And, my able panelists here and colleagues, they've spoken to why those laws were important. I think about opening a business today. I can go online and register that business. That's a big deal. That wasn't there before, right? Kudos to PEBEC. You think about even some of the things I have to do when it comes to increasing my share capital. Now it's just a board resolution. And I can go on. There are a few things. But, at the end of the day, it's a step in the right direction, right? We're beginning to close those loopholes. But I say to myself, is this really moving the needle for me? Is it truly making an impact when I think about those two things I mentioned, to operate my business peacefully and profitably? And I think the answer is quite negligible. The impact is negligible. And I'll just quickly say the challenges I see on those two areas. On the peaceful side, yes, we can talk security. That's one that maybe affects everybody in the country, or the lack thereof of proper security. But then when I talk peacefully when I talk about the issue of peacefully from the standpoint of running a business, it's about, maybe the processes, the policies, the governing laws. Does it make it illegal for some local government person to come and shut my store down, or harass me, or harass my colleagues? Can they go to jail for that?
Now,
because they're not letting me be peaceful. And then when I talk about profitability, at the end of the day, profits come from managing your costs. PricewaterhouseCoopers did an excellent survey on SMEs, I think 2 years ago. And they showed us that the most pressing thing that SMEs want, obtaining capital, one. The second thing was they want more customers, and I guess customers who actually have the buying power. And the final thing was infrastructure deficits. And that affects our bottom line. Somebody is just sending me a message now that our power bill, electricity tariffs are going to go up 40% by the end of this month because of the unification of this exchange rate. And I'm like, how am I going to survive? How can I keep those over 50 people under our payroll in a job? So do we go to that do we think about that bottom line when we sit in Abuja? Or, theory is very different from practice. It's very different from practice. We have to think about the realities. And for me, it's just, we're not there yet. I have some thoughts around how we get there and some of the quick wins, but I'll leave that
I was actually going to just ask you to dive into that.
Yes.
Because we have a government that has just come into power. The president has recently made some very bold statements. And you've talked about how it affects you. That's what resonates with you. And you've also given us a pulse check of how the reforms, how they impact you or do not impact you, as it were. So what two key advice, and I'm using two, because you've done peace and profit, and you've talked about two challenges. So I'll ask you, what are the two key go-to points, low-hanging or long-term, that you would ask the government to embark upon?
Yeah, no, thank you. I think maybe two. There's so many, but you're really pushing me in a corner here. But the two I'll think of in the context of our conversation today, maybe the first is around truly empowering SMEs, business owners, entrepreneurs with the knowledge, full stop. So we talk about these laws, Business Facilitation Act. I think I can call, if I could put it on speaker, and call at least 10 of my colleagues who are business owners. I'm sure they don't know that act exists. They don't. I remember when we used to have issues with local government coming to my store to close it down or say, give us this, you haven't paid for this, tenement, this one, whatever. And, thank God I have two parents. My mom and dad are both lawyers. So they really pounded it on my head, to be empowered with knowledge. And I had that list of the actual rates of local government, and I actually would bring it out and I'll say, no, this parking, no, this is it. And they would literally run away because I was empowered with the knowledge. And I put it on my social media pages. I used to share it with other business owners. I would get messages from them in my DM telling me, thank you so much. They ran away when I showed them that document, you know? So I think we really need to do something around that. The second thing, very quickly, I would say, you know, I talked about that, obtaining finance. Money is still a big issue, but forget that. It's how do you bring it all together? How do we truly have an agency that truly advocates for SMEs, this all-important group that is contributing nearly half of your GDP and employing people in the formal sector, paying taxes? Do you understand? You know, so how do we have, it's not a SMEDAN, it's not a BOI. CBN has no business giving loans to SMEs. Let's truly have, you know, a small business loan association, you know, like what they have in the US, federally guaranteed loans, right? That gives you solid capital, working capital to move forward, to drive your business forward. When you're waiting for payments from ShopRite or whoever, when they've not paid you, you need the capital to keep buying your raw materials. We need to keep moving. So we get stuck, and you see that over what? 80% of business SMEs fail? Why? Within the first 5 years. Why? Yeah. So those are some just very quick things I can think of for this incoming administration, if they truly see SMEs as the engine of growth for any economy. Thank you.
Food for thought. Very well said. Prof, I'll jump to you. You advise potential investors. What do you tell your clients?
Oh, well, so now it is a bit of an easier conversation with the clients, with the law. And I take the point that it's one thing to have the law in place. It's another thing in terms of implementation. And that's why I made the point that we should all remain vigilant in ensuring that these MDAs comply with their obligations under the Act. I mean, from our perspective, it's a lot easier now to do those advisories, particularly in a foreign direct investment context. In the local context, it's a slightly different conversation. Like she has said, I mean, there are still issues around multiple taxation. There are still issues around enforcement of legal rights. We try to drive people to arbitration rather than litigating in the courts. People are getting encouraged about arbitration, but also a bit worried about costs. So we keep on trying to juggle all these different balls and hope that at the end of the day, we get to that point where everybody's comfortable and happy.
Thank you very much. And I'm going to go back to Mr. Ojeni, because a lot of issues have been thrown up here about the gap between the reforms and actual what is, you know, the impact. So what are those measures that have been put in place to assess impact and ensure that these reforms are actually effective?
Thank you very much. Very good question. One of the areas we've worked on is to, for example, the Executive Order 01, to work on a compliance report on an annual basis. And FCCPC, just in the last report, came out one of the top 3, right? So the goal is to measure MDAs, how compliant are they to these orders. Now, the other bit of it is that we need the support of the private sector to use those reports and test the law. Now that the Business Facilitation Act has been passed, for example, how do we test it? We've had a sensitization with MDAs, with the Attorney General, actually telling the MDAs the legal obligations, their legal obligations as relates to the law. But we now need to go a step further to test those laws. And just as Prof said, where you go, we need tested. For the subnational, we've had 2 reports we've worked on in the space of 4 years. It's a biannual report, essentially capturing what the business climate realities across the subnational. Again, we'd like you to go to our website, download those reports, and get those insights. Now, with those insights, we also need, again, speaking about collaboration, these issues are very germane. They're issues that they've been brought to our attention. But one of the things, just as you said, the new administration is making bold statements. Engagement has begun on how we can make MDAs more accountable. One of the greatest challenges is that we have 1,000 MDAs at the last count. We need to make sure that everybody syncs from the same inbox as opposed to running different shows. And that has been a major challenge, and one thing that the current administration is bullish about, making sure that it's that form of accountability, and the Business Foundation Act is one area where we can go through upon, particularly as it relates with default approvals. Just as Prof said, if we can really, really work on the default approvals, it's going to be transformational. But a number of issues need to come up. The Executive Order 1 was there for 5 years, but we only had one private organization use the force of the Executive Order 1. So the law is there. We would need you to please test it and continue to engage with us. In passing the law, we had 40 law firms through the section of business law working with us. We wouldn't want that to stop. We want it to continue to happen. We've had the first engagement with SBL 2 months ago. We'll keep, I hear your point about education, and I've noted that we would, ramp up sensitization in this regard. Thank you.
I thank you very much. I think that is so important, awareness. It's interesting that even in the business community, very few are aware of a lot of these reforms, and even the BFA, very few are aware of the legislations and the consequential amendments. I'll ask Mr. Irukera, because in the course of this conversation, there have been, we have spoken about the role of state and federal government and how they are critical. You mentioned that you're a busybody. How do you see this panning out?
So, from my experience, one of the things that I've seen working is engagement. And I was going to make the point that engagement is a whole 360-degree value chain. Because the people in government have a lot to do also. And one of the things that's promoted engagement sometimes are the private sector practitioners, especially the lawyers. And conflicts and disputes are actually an important platform for collaboration and improvement. And so, as I was saying, when an issue arises, if what council does is to say, well, FCCPC, we don't understand why you have a business in this. This is a food issue, and NAFDAC says it's okay. You're not likely, all you're doing is deepening what really is a problem that affects that private sector far more than a few individuals in government sitting in different agencies. And so, understanding that this engagement is a whole 360-degree value chain, and look at the example Pebek just gave about using some of the most important pieces of legislation that have come out in the country in the past 8 years were products of work done with the SBL. First, they sat with government, sat with the legislature, sat with Pebek, and identified what you call the priority pieces of legislation that everybody needed to focus on. And so it's that kind of engagement, it's that type of collaboration. Winning one case is so inferior to fixing the space. Because if we fix the space, you'd serve your clients far better, they'll be more satisfied, there's more revenue, and it's win-win every step of the way. But if you're going to win a case by literally challenging that this person doesn't have a right to do this, it should be this person, you end up just deepening the conflict and adding to the lack of clarity. And one of the biggest problems with the regulatory space is just, it's not predictable, it's not clear, and when it's either of those two things, it's not sustainable. And so it's that collaboration.
Thank you very much. We're going to take questions. before we do that, Yomi, I'll just like you to quickly tell us, are you optimistic about the future? Having heard everything today, are you going to walk away and be very optimistic? And what prospects do you think the future holds?
Look, I'm going to talk from the narrow side of my sector and then maybe talk about the wider macro. In terms of my sector, which is the telecommunications sector, I'm into digital infrastructure. I think I'm quite optimistic about the future because there's been a lot of market entrants because of the sheer volume of data that Nigeria consume, either in the form of social media or other forms of media, right? So I think that we'll continue to see additional growth. Now, that growth or how accelerative that growth is a function of also the enabling environment, how conducive the enabling environment is. You know, can people bring in their money and take it out? You know, inflow and outflow of capital. Can people get the permits that they require to do business? Can they get it on time? Can you get the approvals on time? You know, I heard Ayo talk about default permits. Is it default approvals? And you know, in as much as that is such a really novel thing, in some certain sectors, in some certain highly regulated sectors, it's not going to work because that same, if you do not have, which is why I was talking about in terms of oversight, making sure that somebody has oversight over that particular regulator. Because if you decide that you're going to go ahead into that venture because you have a default approval, guess what? There might be license terms and conditions that have not been stipulated that you're making an assumption on. So how do you really proceed? And what if you even want to, imagine you're raising financing and somebody asks you, where's your approval? You're going to say, oh, this notice is my default approval? You know, so again, there's some real practical things that we need to, it would have been great if that default approval came in form of a standard license that everybody could see, right? That this is what your default approval license is, right? When, you know, the MD has not responded to you. But I digress. So I think there will be some level of growth, but what can accelerate that growth is if we, other than just having laws, we see a good collaboration between the legislative framework that has been generally the administration. I'm going to be a bit measured in terms of approach. The only good thing that I think I see is that we know that this administration, under the leadership of President Tinubu, he has a liberal economic view based on when he was a governor in Lagos, and he is very pro-business. No matter whatever it is that you might say about him, he is a very pro-business individual. So I think the hope and prayer is that, you know, pro-business policies are implemented, and, you know, things that allow us to attract capital and allow inflows of FDI and FPI inflows into this country are the kind of policies that we will see, right? So it's not only just in terms of legislation, we're open in terms of policy, in terms of actual adherence to whatever framework has been laid out. You know, there is that adherence. And hopefully once that is done, right, because of the sheer size of the economy of Nigeria, which it's a gift and a curse, you know, you would have those investors and investment come in. So early days, but I think...
And if you have any questions, ask a question. Please do not make a comment. Kindly go straight to your question and start by stating your name. Thank you.
Thank you very much, ma'am. My name is Titi Layo. I know Scott. I'm the managing partner, Scott's Legal. I have two questions. One is for you. And you did mention
the subjects or targets of investigation. We issue even an order to show cause saying, these are the things we found. Challenge them if you may before us and upwards. And I don't think that there's any way that we can progress as a society without a robust legal community that's willing to test everything. And the regulators actually, and what I say repeatedly is that let's go to court. I even say between regulators, let's go to court to clarify this. But there's a culture that says, government taking government to court. Won't you guys look like you're fighting each other? But I think we should. And the jurisprudence is actually important for the future of the work. And so we welcome it. And the only thing is, what I found is if you're going to go to court, you take the good and the bad with everything. I mean, if there's, we've had cases where a company says to us, we want to challenge you in court, but our worry is, enter this final order, you would publish your order, and it would damage our reputation. Damn right, we will. We will do our job, but you're entitled to challenge it. And so we can't eat our cake and have it by saying that we are the regulator, the court, and the law. But you can't eat your cake and have it by saying, I don't agree with you, but let me challenge before I decide. So you must take, the two sides, whatever coin you choose. And to your question, consequence management. You're talking about the digital lenders and all that. And that's a very, very sensitive point. Because in reality, and my role from a consumer protection standpoint is penalize those who are behaving inappropriately, but make sure that people have access to all the things they need also. If I damage a brand by just saying anything about that brand, that's anti-consumer protection, because I'm not doing the work that I'm supposed to do for those people who like that brand and want to patronize it. And what we've discovered from a digital lending standpoint is they're far more nimble than traditional lending. And we live in an economy where people truly, truly need what those guys do. Some people borrow 5,000 naira from digital lenders to buy medication, to pay emergency hospital bills. Access to finance in that way is so critical in this economy. And so what we've done is to make sure that we could make sure that business continues, but to eliminate those who act inappropriately, not even the entity that acts appropriately, but inappropriate conduct. I mean, and bashed for even allowing digital lenders in the space at all, even more bashed for registering some of them. But what we've done is we recognize the importance of what they do, and so we would regulate it, and we would provide the strongest consequences for when they violate people's privacy rights or when they compound interest in a manner that is exploitative. And so that's really what I think is one of the most important things that is lacking in the ease of doing business. Businesses, not all. Businesses think ease of doing business is a free field for them to find full expressions for their passions. That's not ease of doing business. Ease of doing business is also that there are appropriate consequences. We in the FCC PC have taken the approach to business that's quite liberal. We will let you do your business in the manner you consider appropriate. Unlike some other agencies that says, no, we want to supervise the water you drink, we want to supervise how much oxygen you breathe. But when you snooze with us, be sure to know you will lose. We'd let you do your business, but if we catch you with your hand in the cookie jar, the penalties would mirror the fact that you had the privilege and the liberties to do your business the way you want. And I personally firmly believe in that. And I think businesses don't like it. In fact, some businesses have said, it would have been more helpful if you had told us when we were going wrong. So, well, but when we don't inspect, in the FCCPC, we do not inspect any businesses. If you see us at your door, it's because it's an enforcement. We're not trying to find out if you're doing things right. It's because we have evidence something is going wrong. And I don't think government should babysit. To come and be supervising your business is to outsource supervision and oversight to the government at a cost. You should do your business and get it right. And when you don't get it right, there's no middle ground. You go straight to jail, do not pass go.
I mean, he's dropped it like it's hot. And there's a lot of work that needs to go on. We've actually, I wish this conversation could continue for the rest of the day, but unfortunately, we have to wrap it up. And I would ask, as we wrap it up, to really take key notes of the issues that have been discussed across the divide. both from the government side and also from the private sector side, because truly the private sector is meant to be the beneficiary of all these reforms. And if it's not working, then there's still a lot of work and an ongoing conversation and dialogue that has to happen. In wrapping up, I'd like all the panelists in 30 seconds, please, to just share your final thoughts. I'll start with Ada.
I think I've said my thoughts for today, so I appreciate being here. Thank you very much.
Excellent.
Thank you. Thank you for the invitation. Just to say that government is, at least as far as we're concerned at PEBEC, we are for you. We'll continue to be your voice in government to amplify your concerns. Please walk with us, and the future can only get better. Thank you.
Excellent. Prof?
I think the BFA is a good start. We should applaud it, but we still know that we have a long journey to go in terms of businesses enjoying the benefit of the law. So, as I said again, joy cometh.
Thank you. And for me, it's just to answer the question you asked earlier on. Optimism or pessimism. I think pessimism is a luxury. I'm not even sure we can afford it. And I truly, really believe that the future is bright.
Thank you.
So I'm just going to latch onto that, and as well in the spirit of optimism. But I'm also going to encourage. This is a fantastic forum that's been put together by NBA Lagos, and kudos to them for putting it together to talk about the topical issues that are germane to us as not only as a body of lawyers, but as a society at large, right? So these are the kind of issues that we need to continue to focus on. I was last in this chamber maybe 15 or 17 years ago when I was doing law dinner, and it's good to be back here after almost 17 years and seeing people converse about all these kind of topical issues. So fantastic.
Thank you very much, and thank you to you, wonderful panelists. Please, a round of applause for the panelists. And to the participants, thank you for having us. Thank you for listening and for your patience. On that note, we'll call it a wrap. Thank you.
Thank you very much to you, madam.
Thank you so much. We're going to have pictures very quickly just before we present the plaques. If you can help take off the microphones. Thank you, Mrs. Upana. Thank you, Ms. Osakwe. Mr. Adebanjo, Mr. Oyeniyi, Mr. Rukera, and Professor Olawe, thank you so, so much. I know it's a Monday. You have taken out time. Yes. Thank you so much taking out time from your Monday afternoon to be with the MBA Lagos branch today. If we can have our panelists just please pose for the pictures, would appreciate that. With the chairman and alternate chair of the Lagos Law Week, please. If we can all spread out for the pictures, thank you very much. Once we're done with this, Mrs. Ali will be helping us present the plaques to our panelists. No problem, ma'am. My apologies, Mrs. Ikwago will be helping us with the honors today. Thank you, ma'am, for the correction. Are they all out?
Is she the one presenting? Does she have the mic? Yes, I have the names on. So now to the business of presenting. Now to the business of presenting the plaques. May I have your attention, Mr. Babatunde Rukera. Thank you very much indeed. We enjoyed. Thank you. I think we should, yes. Hold your plaque so that they can take the photo. Please, can you? Well done. You're presenting plaques. Okay. Thank you very much. Next plaque. And to Mrs. Uto Upana, thank you very much for your able moderation of the session. It was the most interesting session, as I'm sure you'd all agree. Thank you. Mr. Abayomi Adebanjo, I'm sure you must have felt some pleasure sitting here again 17 years later. We enjoyed your contributions. Thank you very much. And Ms. Ayo Kundu Ojeni, thank you very much indeed. The Premier Branch appreciates your contribution to the panel discussion. Professor Adewale Olawoyi, SAN, thank you very much indeed. The Premier Branch appreciates your readiness and availability at all times. Thank you. And last, no means least, Ms. Ada Osakwe. Thank you very much indeed. We appreciate your contributions to the panel session. Thank you all very much, and the audience too. Thank you very much. I don't have a picture again.
Thank you so much. A round of applause for our panelists. We're going to have a final picture with just the panelists, please, and their plaques. Nice smiles. Like Mr. Rikera said, please learn to go past go. Thank you so much. A round of applause, please. And a round of applause for the MBA Lagos branch, please. So we're moving on, and we're the fourth plenary session for today, and we are our final plenary session. We're discussing the artificial intelligence revolution, transforming legal practice and ensuring a sustainable future for lawyers. We know that we're in a time where AI seems to be taking over. We're waking up these days and we're seeing songs by artists who claim they didn't sing those songs. We're at a time where people are getting opinions from chatbots and AIs. And we've assembled a very good panel to help discuss this. I'll start with the moderator. It's a good friend of mine, Dr. Kolawole Mayomi, partner SP Ajibede & Co. A round of applause for him, please. A round of applause for him, please. Thank you so much. Kola, if you can just sit down on this side here. The next panelist, I will require a resounding round of applause. If you were in the law school at least 17, 18 years ago, this person will be very familiar to you. A round of applause for Dr. Titi Hamid. She's the Deputy Director of Academics, Nigerian Law School, Lagos Campus. A round of applause. Pleasure to see you again, ma'am. Next person is Mr. Babajimi Ayorinde. He's a partner with the new practice. A round of applause for Mr. Ayorinde, please. Also, we have the principal partner for BBO Solicitors, Mrs. Bukola Ogunsaki. A round of applause for her, please. Thank you so much. And our final panelist is Mr. Omori Ediogwawiri. He's the founder of Ediogwawiri & Company, LLP. A round of applause for him, please. And we look forward to an exciting time. Mr. Dr. Kolawole, over to you.
Thank you very much. So, good afternoon, distinguished ladies and gentlemen. Please, can you hear me at the back? Hello, good afternoon. Can you hear me? Great. So, I welcome you all to this very interesting session on artificial intelligence, otherwise called AI. And AI is one of the hottest topics now that's being debated worldwide. It cuts across all professions. But our focus this afternoon will be on the impact on the legal profession. And one big question that you will discern from our discussions this afternoon is if AI will augment the work of lawyers or will eventually replace lawyers. So can I do a very quick survey? If you think AI will eventually replace lawyers, can you say I? Okay. So AI cannot replace lawyers. Are you sure? But are you aware that in a recent uniform bar exam in the US, the newest AI model, that's the GPT Chat 4, beats 90% of all lawyers that wrote that exam? Are you aware? That's exam. All right. So again, in other news, you also see that there has been a robot now, a robot lawyer that was created by a tech company called Do Not Pay. That's the name of that company. They created a robot lawyer, and that robot lawyer has been sued for practicing without license. That has happened in the US. Now, taken together, all these development shows that AI is going to have profound implications for the work of lawyers. And this session will be taking a very deep look at some of these issues. We have a very stellar cast of experts, and I will be starting, ladies first. I'll be starting with Bukola Ogunshaki. Buki, so can you please tell us, what is the current, or what are the current and global applications, current and future applications of AI globally? Just give us like a background. How does AI operate? Break it down, demystify it in about 3 to 4 minutes.
All right. Good afternoon, everyone. It's awesome to be here. I stand on all existing protocol. I'd like to thank the NBA Lagos and the NBA Law Week Committee for putting this together. Okay, I'm going to try my best within the time limit. We'll have to start, first of all, with the definition of artificial intelligence. And artificial intelligence are systems that work with predictive models. So they predict using statistics and the data they've been fed to output knowledge which is supposed to mirror human intelligence. And that's why it's called artificial, because it's not self-aware. It's just doing a lot of predictive analysis, additions and subtractions, and trying to predict the next sentence or the output that it should bring forth. But artificial intelligence in itself is very wide. So we have machine learning, we have natural language programs, and then we have deep learning as well. So it's a lot of different aspects that make up artificial intelligence. If I want to go to the background of where this started from, I think from the 1950s, we've heard the word artificial intelligence, and we've had different researchers come up with different models for artificial intelligence. But I think most of it became public knowledge in about 2012, 2011. And the very first popular ones started from voice recognition, and then from voice recognition to image recognition. So the systems were able to identify images and identify voices once it's spoken to. And then, of course, we now have the generative AI, which is the popular ChatGPT 3, then 3.5 and 4. We have 5 in the waiting, about to be released, or waiting to be released, rather. And so that just gives us a bit of background of artificial intelligence. Now, this becoming public knowledge, what do we use artificial intelligence for right now? Artificial intelligence is said to be able to do 50% of the jobs that are currently available in the market and in the world. And the remaining 50%, it's actually able to augment those jobs. So what does it do? It mirrors human intelligence. And part of the part that people are worried about is, will the intelligence surpass human knowledge eventually, or will it still remain within the cusp of human intelligence? So right now, just as you said, we have different APIs and different apps that work with AI. So we have Do Not Pay, which are robot lawyers. We have AI tax. There's so many examples. I think last time I checked, it was about 4,000 AI apps or more that we have that are available, and they're able to help you augment your task. They majorly act as a co-pilot with you with the task that you have. So if you're a lawyer, for instance, tasks that AI could help you with would be agreements, contracting, legal drafting, legal research, and so many other aspects of legal work that AIs can actually currently help with. And obviously, it's not just law. It's not the legal industry alone. We have healthcare. We have radiologists. AI is able to read scans. And I believe that the research showed that it was about 98% accurate on reading x-rays and scans, just like doctors. So that begs the question, when it comes to law, are we going to be replaced by AI, or is it just here to be a co-pilot with us with the future tasks that we have?
Thank you very much. So AI, as you said, artificial intelligence. So let me come down to lawyers. And Baba Jimmy, now how often have you seen AI feature in legal practice, particularly in Nigeria? And how, if again, if I can ask you, can you also forecast going forward, drafting contracts, drafting briefs of argument, drafting wills? How do you see AI being used in all this? Is it going to reduce the number of juniors you are going to employ in your office? Take note of him now. Yes, please.
Okay, good afternoon, everybody.
Good afternoon.
And thanks to the organizers of this Law Week for the opportunity to speak to you. So, how do I see AI presently in the legal profession in Nigeria, and what kind of impact do I think it's going to have in the future? AI has been with us for a long time, right? And most of us don't realize this. In our everyday lives, we're actually using one form of AI or the other. I think one tool that almost every lawyer in this room would use from time to time is Microsoft Word. Microsoft Word has components that are driven by artificial intelligence. When you write, if you write my name, a Yoruba name in Microsoft Word, it gives you a red line under and tells you that there's something odd about that. But you can teach it. You can tell it, don't worry, it's not a mistake. This is my name. And then the next time you're typing a document and you write your name, it's learned from you. That is just one of the most basic examples of how we use AI right now that we don't even realize it. If you use Outlook for mail, right, sometimes you get an email. I get mine usually on Monday mornings, right? It tells me that I sent an email to someone on Thursday last week and said, I'll call you. And then it reminds me to call that person. That is AI. Those of us that participate in arbitration, you might have experienced software that essentially transcribes what you're saying, right, into writing, real time. Right? You might have heard of Opus 2. That is becoming used more in arbitration. So AI has been with us for a long time, and we're actually using it without realizing that we're using it. What has changed is that the technology is gradually moving away from what you call extractive AI, which is, the software that we had prior to now would essentially just look at data that you fed to it, and then it tells you, or it helps you to look for things within it. We're now moving to generative AI that is now creating its own content, right? And that is why there's such a buzz about it. Now, how does that affect us as lawyers? Before, we didn't need to worry much, right? If you put in a word, a keyword, and you searched, right, it will only bring out documents or emails that have that keyword. Now, these machines have the capacity to actually write things for you, right? They have the capacity to almost think for you. So how does that impact us? Let me give a statistic, and then I'll give an example. I was reading an article in The Economist this week, and it said that about 40% of the work that lawyers currently do, and this isn't restricted to Nigeria, 40% of that work can be done more efficiently by artificial intelligence, right? Now, in terms of practicalities, when I started practicing law, if we wanted to do a due diligence exercise, you would have to tell the clients that you are going to perform the due diligence on well in advance. They would literally have to empty their conference room in their office for you. They would load it up with boxes of files, and then you send a team of about 5 to 6 or 8 lawyers to go and pour through those files, right? And these are human beings. They're going to get tired. They're going to miss things. We've moved a bit from that now. A lot of those documents are scanned. So nowadays, we just tell the client, we've created a cloud folder for you, upload those files, the scanned files there, and you sit in the comfort of your office, and you can go through all these files, and then you make your notes and come up with your due diligence report. Now, this is where generative AI is going to change things for us. We can now go a step further. We can now tell that machine, right, that I've fed all these documents into you. I want you to look at them, right, and I'm looking for these particular trends, right? I want you to create a report for me, right? What have you found? We're now getting to a situation where you could literally feed in, let's say, for example, the database of Nigerian Weekly Law Report, and ask a machine to tell you how many times has the Supreme Court of Nigeria, right, dismissed appeals, right, based on jurisdiction. That is without going into the merit. And this machine will be able to read all this for you and give you that type of analysis. So the reality is that it's going to make our lives easier. But if we're also not diligent, it might make some of us redundant. Right? So I'll stop there for now.
Thank you very much, Jimmy. There is a little question I will ask you that you will reflect over and come back to us later. So if you have a team of 4 lawyers, even 6 lawyers, going out for due diligence, and their place is now taken by a machine that can do all that, what happens to the billable time? What happens to the invoice that you send to the client? Think about it. Let me first let me next go to Dr. Titi Hamid. Dr. Hamid, you are a director, academics in the Nigerian Law School. And I'd like to ask you, in the present training of aspirants to the Nigerian bar, what role does AI currently feature? Does the syllabus now capture how lawyers can use AI to simplify their work?
Right. Good afternoon, everyone. It's nice to be here to have these discussions. Let me first of all say I'm not holding the brief for the Nigerian Law School. So anything I say here is from my personal perspective. The truth is that we move with the times.
Yes.
Particularly with the syllabus. So it's what we see out there that we reflect to teach the students. I personally am not averse to AI, okay? And then you see lawyers saying that they don't want AI to take over their jobs. So what do we do? Okay, so the truth is that the practice as it is going to be around for quite a long time. And that is what we observe in our syllabus. But having said that, it doesn't mean we don't do anything that has got to do with technology. We may not have gotten to the standard of AI, but it's not like we run away from technology. So of course, definitely you don't have a choice but to teach students on online filing, online searches, going to the CAC Lands Registry. You have to be technology and you have to be savvy technology-wise. You cannot escape it. So for the things that we can relate with, for example, ODR. Okay, so we already teach ADR, and we know that these things don't always happen physically. There are times that you have to strike those deals online, and we'll let the students be aware that this kind of things, you can meet it in practice. The same thing with ICT in law office management. Okay, so gone are the days where you have sole practitionership, you have more of partnerships. And when you get into a partnership law firm, what do you find? You find that they're quite savvy. It's usually more of technology, so that if you don't have technology, there's nothing you are doing there. Take, for example, the time of COVID.
Yeah.
It really showed a lot of things. So we were at the point, or almost at the point of sending students away for their externship, and then COVID struck. And we still thought that we could manage it somehow. Okay, so just try and sign and get the chambers that are online, and then the students too should be prepared to go online to have their externship training. But you find out that a student will come back and they carry the type of phone that is not technology-based. So where do you start from? They even tell you they can't afford data and all that. So it's not like we don't want to, but we have to read the environment. Is the environment really ready for this? Remember, we're a public institution, we're not private like colleagues here. Okay, so it will still take some time to adjust the syllabus to adapt AI into it. Thank you.
That's quite a lot said in just 3 minutes. Thank you very much, Doc. Now, Omorui, I come to you. From all we've said so far, AI is disruptive. So how do you see AI disrupting the traditional ways we practice? Or in other words, how can AI come in to aid us, not to work against us, to aid us to streamline the way we practice and achieve efficiency? Yes, sir.
Thank you. All protocols observed. It's good to be sitting on the same panel with my teacher. Dr. Hamid taught me in the law school. And, it's good to have you. And it just shows growth, that decades down the line, we're sharing the platform, discussing law, and law has evolved. One thing I say about technology is that technology is a moving train, and it doesn't give you an option to refuse to get in. You either get in or you're crushed. So let's just do a little analogy. If you've got a 3310 phone, a Nokia 3310 that used to be the craze back in the day, if you have that phone today, it's still SIM-enabled, and so you could still use it to make calls. So I can still connect with Leonard Silk. I can still call him. But is the phone fit for purpose? That's the question. Can I use that 3310 phone to imagine I have a 3310 phone and I get an email from a client, or a client calls me to say, look, I've sent you an email, we need this review to go in within the next 24 hours, and I'm on the road. Can I do that? I have got to look for a computer, or I've got to find something. Even though I have a device for communication, it is no longer fit for purpose. And so when you look at it from the gamut of the legal profession, one thing is very clear. Artificial intelligence and technology has come to disrupt the way we do things. It's no longer business as usual. Okay. For some of us here, if you recall, 5 years or even, 5 or 6 years down the line, it took 1 year, 6 months, 8 months to register a company. Today, you can do that in 12 hours. You can do that in 24 hours. You can sit in your office, prepare the processes, upload everything, and on the click of a button, you submit. On the click of a button, you download the certificates and stuff, right? But before, people had to travel from Lagos to Abuja. You had to have a middleman in Abuja to do stuff for you.
Yeah.
Now, that's what technology does. Technology changes how you do things. And as far as the legal profession is concerned, we may not know it, but it has taken over the way we do things. Now, that answers the first part of the question. Artificial intelligence is going to disrupt legal practice as we know it. Now, I like what Babajimi said, automating your processes, right? You have document Q&A. And what's document Q&A? You upload an agreement, and you ask the agreement what you want it to give to you. So I upload a 600-page document, and I say, I want to know the termination clauses. I want to understand the dispute resolution clauses. I want to understand, the M&A clauses in this document, and it gives it to you, right? So it makes it easier and faster for you. So AI has come to disrupt, but in a good way, because what it does for you is it enhances your your practice. You know, and we have Find Law today, for instance. We have Case Text, we have Clio, and these are AI platforms or apps that enhance the work we do. I always say to people that lawyers are very privileged. And you know why? Artificial intelligence is to our benefit. It's an enhancer of professionalism. It keeps you up to tune. So when I hear people saying AI or technology is going to disrupt the way you do stuff, I laugh because I say, look, it's a God-given tool because it's coming to make you do things faster, get more results, and charge more money. Now imagine you get a 4,000-page document to review, right? And you've got, and the thing about professionalism is that you cannot afford not to see stuff. You can't afford to say, oh, I didn't say this, or this is, because you churn in a legal opinion to your clients, they're going to deal on it. I say to my guys at work, I say, look, we're like doctors. We make mistakes, clients die. And so AI is going to make your work easy, faster. So you get that document, you turn it in, Q&A gives you your report. Now here's the thing, and this is the good news for the music in our ears. It cannot displace, because there's something AI doesn't have, the emotional intelligence component, right? Yeah. So I met the client. Leonard Silk at this occasion was the client. I met him, we had a conversation, I read his body language, I understand the urgency given his body language, and I know the end point of the conversation. AI doesn't know that, it's a machine. So it's plug and play. You tell it what you want, it gives you what you want, faster and in a more efficient way.
Okay, thank you. Let me very quickly come back to Abajimi. So traditionally, you have a big company that instructs you, do due diligence for us, and you bill them by the number of lawyers, number of hours that will go there. Now, you now employ AI, and AI finishes the task under 2 hours. Does that lead to loss of billable hours?
Okay, so it's interesting you ask this question because that's a debate that has been going on in more developed jurisdictions lately. What happens when you have these machines that do things more efficiently? And the simple answer is that, yes, the machine will do it more efficiently. You're going to spend less time. But then we're most likely going to change the way we bill. The way we charge our clients will evolve, right? Yes. We're not going to be charging based on the amount of hours that we put into the work. We'll probably be charging for the costs of acquiring that technology because AI isn't cheap, right? Even the publicly available ones like ChatGPT that we use, they're actually subscription-based ones that are more expensive. So we're going to be paying for that technology. We're going to be paying for the maintenance and updating of that technology. So some of the articles I've read have suggested that maybe the way lawyers are going to do this is charge a technology fee, right, to cover that cost and, of course, give you a margin. But, you know, there was a time when all we did was based on paper. We wrote all our briefs on paper and all that. Now we have our laptops and we type our briefs. We're spending less time than we did. I mean, I remember the days when you'd have to go through NWLR index before you even start looking for the actual volume that you want, right? Now we can do this online, right? So we've always been doing things more efficiently as new technology has come along. And it hasn't really eliminated our jobs, right? But the reality is that, yes, right, it's going to change the way we do things. You had asked earlier about the due diligence example.
Yes.
My simple answer is that where I would have needed 10 juniors to go into that data room, I'll probably need 1 or 2, right? So we as lawyers also have to upskill, right? We need to try and equip ourselves with skills that allow us to do more higher value work, because at the end of the day, what AI is coming to take is really the mundane stuff, the routine stuff.
Okay, Baba Jimmy, let me stop you there. Let me move to another scenario. So in recent news, some lawyers were caught, some lawyers ran into a problem in New York. They used AI to generate a written brief. And that AI that brief contained fake citation. Fake cases were there. So the machine had, what's the word I should use? The machine had generated fake cases, non-existent cases. And they are facing disciplinary issues. Now, I'll come back to you, Baba Jimmy. In Nigeria, what do you think, what does that portend? Is that not professional negligence? Because the lawyers are blaming it on AI.
Okay, so I think the particular case you're talking about is about a lawyer in New York State. I think his name is Stephen Schwartz. To make matters worse, right, he didn't only ask ChatGPT to write the brief for him. He asked ChatGPT, right, are you sure about what you... He said, yes, I can assure you that all the authorities I've cited, all the cases I've cited are real, and they all turned out to be false, right? But look, there are rules of professional ethics that deal with stuff like this. If you go to our Nigerian rules of professional ethics, I think it's rule 16B, right, that says that you should not conduct your client's case in a negligent manner. There's also something, I think, in Rule 14 that deals with that. Once you've been engaged by a client, right, not only are you contractually bound to perform the service, right, but even if you want to deploy technology to help you in the performance of that service, you don't abdicate, right, the primary duty to ensure the quality of the work. So I would say that lawyers will find themselves open to professional misconduct, lawsuits for breach of contract, lawsuits for negligence, if you just abandon your responsibilities and leave it to ChatGPT to do for you.
Very well. Bukola, I will just quickly put the same question to you. So, how might the legal industry regulate these kind of problems? I mean, already, and I'll also come to our primary regulator here, Dr. Hamid, was already, it is not an unknown phenomenon in courts. I have personally seen lawyers citing bogus cases. So it's not new. What is new is that the lawyers are now blaming it on the software. So Bukola, what do you think we can do? What kind of regulatory framework can we put into place to stop this kind or these potential abuses of the use of AI? Yes.
Okay, so first, I would like to categorize the different types of AI. Because currently what we have is narrow AI, and we actually have what we call general AI, which we haven't gotten to yet. So narrow AI will be systems that are able to focus on one task, but then general AI is AI that can do multiple tasks at the same time. So what the artificial intelligence giants are trying to create kind of a digital god that knows everything and can do everything. We haven't gotten there yet, but there are two major factors that might get us there quicker. The first is 5G, and the second is quantum computing. We haven't gotten to the level where quantum computing is public yet. But the moment we get to that point, I think the conversation we're going to be having in forums like this will be completely different. So meanwhile, before we get to that stage, what we need to do is to prevent AI from getting dangerous, if I can use it like that. So just the same way the government has to regulate drugs and other harmful things to the public, AI could actually be very dangerous, which is the reason why economies like the EU are looking at governing AI from a risk-based approach, okay? So I think for us in our climb here, we need to be looking at the risk of AI when addressing any AI systems or how to use AI, even within organizations. So I'll start from law firms, for instance. We need to have operational procedures and policies, processes in place regarding AI. I know the popular case of Samsung restricting their staff from using AI was in the papers not too long ago, and everybody was able to read about that. Law firms need to have their own AI policies. We've spoken about upskilling and reskilling. Right. There needs to be education, awareness. Lawyers need to know about AI because whether we like it or not, AI is here to stay and is not going anywhere. In fact, just like I mentioned, once the technology progresses, it will begin to cause there to be a decline in some of the services that we offer. We're looking at things like creating new business models. We've talked about that as well. New ways of invoicing, charging the clients, new ways of working as well. You might not need as many interns. You might need one. You might need to create a new department. You might need to have a chief AI officer or AI strategist within your organization to know how to bucket the different data that you have. You might need to start using AI tools, just like we mentioned. There are many on the market now, some very expensive, some much cheaper. We may need to begin to use our own API versions of, for instance, OpenAI's API. We might need to subscribe to models like that, but what it will be doing will be to we're going to be feeding it the legal information, probably confidential information within our law firm, and then look for how we can have a cybersecurity system that keeps that data safe within the law firm brackets. Now, then for the legislative or agencies, we need to be looking at research, innovation labs. We need to discover where AI is going, because whether we like it or not, AI is some sort of they call it the singularity, because we don't know the end of it. It started, but even the researchers cannot categorically tell you where it will end. So it's like a black hole. So you need to have research teams who are looking into how to govern this process more. And so and then we need to look at the regulations as well. EU has the AI Act, and the US has their own act, and they govern it in very different ways. So the EIA governs with a horizontal approach. So they look at, before you deploy any AI system, there's certain rules that you need to abide by. Whereas in the US, they do it is sector specific. So autonomous vehicles will have their own transport, you know, the different sectors, which is, I think, in Nigeria, the agencies are looking more towards the US approach. So we need to look at all of this when we're speaking about AI. It's very vast. We're just at the beginning days, so there's a lot of work that still needs to be done.
So I think I will depart slightly from protocol, and I'll very quickly throw the question to the learned silk. So it's been suggested that learned silk Chief Adeshoko. So it's been suggested that in some jurisdictions, that the way they've been regulating the use of AI is, I think Bukola said in EU, there's a general act that covers all sectors. But in the US, it is sector by sector. So assuming we adopt that approach in Nigeria, and it is the legal profession that has to regulate it internally, in just 1 minute, sir, how would you suggest that will curb this kind of problems? A lawyer will come to court and say, it's not my fault. It is the AI that wrote all those fake cases. What do you say, sir? Can someone please give him the mic for just 1 minute, sir?
Thank you very much. Some of us have clients, when they instruct you, they tell you that even though this brief has come to your law firm, you are primarily responsible for it. In fact, some of them would ask counsel that are specifically in charge of it.
Yes.
And they'll ask for the particulars, the phone number, the email addresses, and they try to make you. Some clients have been doing that to me for more than 20 years. It is as if they have become aware of this kind of problem in future. It will come, or it's been coming. Now, it has crept into, has come in unknowingly. I was discussing with Mrs. Ukwagu. There are now online doctors, online legal practitioners, especially in the UK and in other advanced countries, and it's gradually coming into our own jurisdiction. Now, our rules of professional ethics is supposed to be designed to take care of it.
Yes.
I have also always said something. We are not regulated in Nigeria, and it's the basis of a lot of problems we are. We are all told about solicitors' accounts. Who has ever come to check anybody's books in Nigeria? And that's why a lot of things we need to empower, we need to create the backbone by MBA. Every branch ought to have branches of the MBA doing spot checks into the way we are keeping. Standards are just not there. And so it is difficult to enforce professional ethics. It is the extreme cases that go to legal practitioners, disciplinary counsel. It is the extreme cases.
Yeah.
If they have to check our books, visitors and auditors, many of us will be in problem. Many of us will be in problem. So what am I saying? What I'm saying is that we have to look from the point of view of professional ethics and the regulation of the practice of law, especially by the MBA at the national level. All those professional ethics rules that we have, they are only enforced, most of them in breach. So from that point, there must be a system that puts me in account, that audits my practice on a regular basis. We are not doing it. And so artificial intelligence will come and will continue to wobble and wobble. People will apply various standards. People who have access to subscription, who can afford it, who are tech savvy, they will do it and take advantage. They become qualified for some transactions. Many more will be unqualified because they look at you and they look at your setup and they decide that, oh, you cannot do this work and that you can do this work. They don't even need to interact with you. They go on the website, they go on the internet and research you. They research your firm and then they say, okay, you cannot do this kind of work. You are not qualified for this. It's already happening. All based on partially, did you say the narrow artificial intelligence that we're talking about before we go to the general? So I would say,
analytic, a lawyer can't just go to court and hands up and say, my lord, it's not my fault.
For now, no.
It's the artificial intelligence fault.
For now, no. But many times we give silly excuses and we do disservice to our clients.
Very well.
Because of very poor regulation, especially by the NBA, in terms of rules of professional conduct.
Thank you very much, sir. Much grateful for your intervention. I will come back to you. I would like you to shed a bit more light on where I think Bukola left it behind, the commercial aspect of it. How can we use AI more to leverage our practice? Now we've seen that it's not an enemy. It's actually a tool. But that tool, if you are not careful, can also take away some bit of our work. That's fine. But if properly handled, can actually boost our practice. Can you speak a bit more on that, please?
Okay, so let me start. Let me start here. In 2024,
next year,
yes, 30% of generalists, lawyers or attorneys will be out of business. Rule number one, it's no longer fashionable to be a generalist. Your call to bar, I always say, look, your call to bar certificate only gets you into the room. What keeps you in the room is specialization. So that's in itself, because see, AI is plug and play, right? So you've got to understand what you're plugging and what you're playing. And then creative sphere. So I see Nigeria and I see the African markets going more towards the sector-specific AI regulatory system, where you're going to have AI for law, AI for medicine, AI for construction, and all that, instead of a generalist approach.
Right.
So what that means is, first of all, you've got to specialize. You've got to be known for something. And then you've got to invest yourself in it as much as you can. 2, lawyers must begin to move towards automation as against moving away from it, right? We do a lot of work, but we're very few. And that's because we leverage heavily on technology. So I wake up in the morning and my virtual assistant has given me 60 things I have to do this week. Right? It's telling you what to do. And 5 minutes before the time, it's reminding you, it's plugging in. And guess what? It's gone beyond even you setting it up on your devices. It's taking note of what you're saying. It's noting it down, and it's churning out those reports. Now, that's where AI gets a bit scary, right? But as lawyers, if you don't understand that you're going against a fast train that is not going to let you have a choice to come in or not, then you prepare yourself to jump in. Because if you don't get in, it's going to crush you. Now, so embrace AI as a tool, right? Understand that it's here to keep you in business and improve you. So imagine, and I really don't want to go into the highfalutin. AI is really deep, right? Last week I was at the AI Summit, and I was overwhelmed by the level of innovation. We're in Nigeria and we're doing very well, but we ain't seen nothing yet. There's so much happening in the world of AI. Even things as scary as teleporting. Human teleporting are already in the works, right? So at the London Tech Week last week, a company came with products where blind people could wear devices on their feet that will make them see or, give them a route. So they more or less can see, right? So in the legal system, there's so many. I mentioned so many applications. When you pick a niche, look for the tools that will elevate you and get you productive in that niche. I told you, a couple of years ago, it took us years to incorporate simple companies. Today, on the go, you understand the system. You can go on your computer and everything is automated. Guess what? Even the policies of government today are going into blockchain. The federal government has passed a blockchain policy that's going to revolutionize how government does stuff, right? And now that blockchain policy means that even if you want to even deal with government, you've got to understand the system. So as lawyers, we must begin to build ourselves and cut out that middleman approach. I still see so many lawyers who don't even understand how the CAC portal works. So they've got vendors in Abuja or wherever who understand the system and who they pass their jobs to. In a couple of years, they're going to be out of business. Because your clients are very knowledgeable, and if you are set up someone like me that's in the tech space where you're providing professional services to the clients who are innovating this technology, then you've really got to be on top of your game because they are telling you the latest technology, they're telling you what's going on and all that. Now, to mention a bit about what Buki said, and the issue of lawyers coming up with technology, with wrong cases and the likes. The truth is, AI always gives you a caveat, like ChatGPT, for instance. I accosted the team in London, and I said to them, you guys have set a lawyer up. He's facing the disciplinary bar in New York. And they said, look, that's one of the things that they did at the time they were developing ChatGPT is put in that caveat. After every feedback, it tells you that I am an artificial intelligence model, and you cannot take what I have said hook, line, and sinker. This is where we should clap for ourselves as lawyers. That means artificial intelligence ain't going to take our jobs. Because that human emotional intelligence component now comes to the table, right? So continuous learning and upskilling is very, very important. If you are not upskilling, if you're not learning, if you're not leveraging on technology, if you are still relying on the manual processes where you've got tons and tons of files and books that nobody opens, you're wasting your time. You've got to have laptops, you've got to invest in apps, you've got to invest in digital devices where you can access these things on the go. Now, technology is not cheap. It comes at a cost. So really, at the end of the day, it's really almost the same thing, because unlike the books that we buy and that you could have for 5 years before the next edition comes out, you will literally pay for these apps every month in dollars, and that costs a lot of money. So it's really not cheaper. And it's really not going to make your services cheaper because you're relying on AI. Rather, it will even be a lot more expensive. But the good thing is, artificial intelligence has come to improve your processes as lawyers, to make you faster and more efficient. And if you can understand that it's there to help you as against chasing you out, you are more inclined to work with it.
Very well. Thank you very much. Before I put the last comment, and yeah, thank you very much for putting your hands together for him. Please do that. Before I call upon Dr. Ahmed for the very last comment, I'll just quickly pick on what Uyi said. He said all those books that will line up behind us may not be relevant in the future. So some of us that are going to want to take pictures. So, Prof, all those pictures, you know, judges and senior lawyers, you don't take official picture. There must always be some books behind them.
So, Kola, AI has got all those stuff. So here's the thing.
It will generate
There's something they call, there's even, the dangerous part of AI are the deep fakes, right? Where you can't even distinguish between the original and the artificial. But
so meaning all those pictures
you could have background images. Even look at Zoom. Technology like Zoom. You could decide to change your background image on a Zoom call.
Exactly.
Right?
That's interesting.
And this is not saying we shouldn't get the books. No, it's aesthetic, it's beautiful. But what I'm saying is, you could have 1,000 books in your shelf, and depending on the size of your office, but you could have 10,000 on your mobile device.
So should I just line up laptops behind me?
You just need one laptop. And another thing that lawyers must know is you must get the tools that are relevant and useful. So if you're buying a laptop, for instance, you've got to buy a laptop that is amenable to technological improvements and changes. There's no need buying a laptop that many of the softwares can't work in because it's outdated and the likes. Technology is beautiful if you understand how to work it.
Okay, very well. I will stop you there because of time. Now, Dr. Hamid, we've heard the story of the software that did the uniform bar exam in US and passed or had a higher success rate or had a higher pass mark than 90% of all the lawyers. Now, if that happens in Nigeria, if such a robot or software goes through university and writes the bar finals and passes by final with first class, would you call it to the Nigerian bar? Question number one. Okay, please answer that. So would you call that bar, would you call that software that passed bar final, is he eligible for being called to a Nigerian bar as a fit and proper person?
All right. Personally, I'll be looking for that AI script to assess or to reassess. But on a serious note, like the Leonard Silk said, this legislation, particularly a legislation like the RPC, the LPA that regulates lawyers, in this regard, an overhaul may be what would be relevant, to be able to conveniently accommodate AI practice for lawyers in Nigeria. So you talk about whether the robot can be called to the bar. The first question is, who is a lawyer? Who does the LPA define to be a lawyer? That before you can practice, it must be somebody, it must definitely be somebody that has had their name enrolled on the list of legal practitioners that can practice law in Nigeria. So the question is AI a person? Will AI be considered a person? And for you to have your name enrolled, there are certain steps that we all know that you must go through. You must attend the Nigerian law school. You must satisfy the attendance, do your externship, eat your dinners, be fit and proper, like you said, the first hurdle, then write the exams and pass. When you have written those exams and passed, then you move to the call to bar stage. You're presenting your qualifying certificate, still making sure that you're a fit and proper person, still making sure you have eaten those dinners. Is AI going to eat those dinners? Or is the robot going to eat those dinners? So these are the issues that we look at. The only thing I can say that the AI will do satisfactorily is to pay the the practicing fees. Okay, so nobody's going to question because they want to collect that money. Okay, but every other stage is not, it's not likely. It's not likely that such a robot, in fact, that robot is not a person, to be made a lawyer that can practice law in Nigeria.
So from what you say, a robot is unlikely to be licensed to practice law in Nigeria.
According to the LPA, it's not a person that can practice law in Nigeria.
Okay, so it's your turn. Questions on this session? Just 2 or 3 questions, please. Do we have any questions? Yes, Lionel Silk, number 1. Who else? The gentleman at the back there. David, can you please note number 2? All the questions are from this side. And then Mrs. Ikwagu, number 3.
We have, if you like, 3 generations around. The ones that are coming in, the ones that are at the heart of it, AI, and the old school, for which some of us belong, and we're trying to. So, and I see that the majority that we have here are maybe the first generation, or young ones in the middle group, those who want to have an AI awareness compliance practice. What do you advise in terms of equipment, in terms of disposition, in terms of setup? Thank you.
Thank you. So, sir, who precisely would you want to answer that question?
I'm trying to get his name.
Is it
My learned brother facing me directly.
Okay, and Babaji, can you take notes? Yes, sir, number 2.
Good afternoon.
Good afternoon, sir.
My area of, so for me personally, my core area of research is actually AI, cryptocurrencies, decentralized systems, and their use in commercial transactions. Now, I want to target my good friend Uyi. How do we? I believe that AI is a valuable thing. I personally, one of my core, when I started out, my area was converting legal risk into mathematics. Now, how do we deploy such? You spoke about ChatGPT, but ChatGPT is a language model. It's a large language model. Now, how do we create more risk-based models which can be deployed in AML, CFT, litigation, and other more intense areas of legal enterprise?
Thank you very much, sir. Okay, I'll just squeeze in one more. Yes, please.
Hello, good afternoon. My name is Chizoba Theodora Anyiji, and my question pertains to, this was an insightful session. My question pertains to who bears the responsibility for liability of AI. I know that it has been discussed, but I want to point something. On one hand, we have that lawyers and law firms are merely going to be end users of the artificial intelligence, which means that should we bear the entire liability for its flaws? Or on the other hand, should we consider certain forms of liability on the part of the programmers who create this AI? Thank you.
Thank you. Bukola, you answered that. Please bring it forward to Mrs. Ikwagu.
Basically, I was about to ask something similar. I was only going to phrase it a bit differently.
Yeah, right.
And the question is, my own question would have been that, when a client instructs his solicitor, he pays the solicitor for his expertise, for his experience, for his knowledge. And therefore, can a lawyer truly outsource or delegate such responsibility to AI and expect to get away with it when things go bottoms up, as in that case that was cited in the state of New York?
Yeah, Dr. Ahmed, you answered that. Yes, Bajimi, can we get the ball rolling?
Okay, so I think we'll be doing ourselves a great disservice if we leave this room seeing AI as a threat, and I don't want us to do that. Almost everybody here has a phone that has a camera, right? Some cameras now are more powerful than the big cameras that we were carrying around 10, 15 years ago, right? But I'm sure if any of the young ladies here was going to get married, you wouldn't give your iPhone 13 to your sister and say, okay, cover my wedding for me. You still go for a professional photographer. Why do you do that? It's because he's specialized, right? he's become very, very good at what he does. I mean, your day job is as a lawyer, and this is just a side gig at best. And what that tells us is that we shouldn't be threatened by AI. Rather, right, we should specialize. We should become experts at what we do. Uyi is right. I think the day of the generalist is gone, right? We all need to pick specific areas where we're going to try to excel at. And we'll find that when AI becomes more ubiquitous and it's everywhere, and it starts to take people's jobs, it's going to be the routine, mundane stuff. And if you are specialized, you'll be fine. So number one advice is make sure you're specialized. Now, an advantage that AI brings to the table that a lot of lawyers are not seeing at the moment is that, I think it was Leonard Sick, Mr. Adeshokan, was talking earlier about how, certain foreign clients, when they want to engage a firm, they do their research on you, and they come to a conclusion that you can't handle this brief because of your size or what they've seen. What AI can do is that whilst today I might have a law firm that doesn't have the capacity to deploy 10 teams of lawyers to carry out due diligence in 10 places, with a very good AI product, right, I could have a 3-4-man team and compete with law firms that are able to do those big transactions. Yeah. So one of the advantages that is being touted, especially in the legal profession, is that AI is going to create more of a level playing field. Smaller law firms, mid-sized law firms are going to be able to compete better with bigger law firms. Because now it's not just about, I'm a 100-man firm, I have 150 lawyers. It's about the firepower, the technological firepower that you carry.
Capability.
Yeah.
Capacity. Thank you very much. Bukola? 1 minute.
Yes, so I wanted to also emphasize some of what he was saying, that some of the advantages of AI is that it makes us currently global lawyers, if I can say that. Someone was alluding to the fact that there is nothing like that, but I want to emphasize the fact that, for instance, myself, 3/4 of the teams that I work with are not based in Nigeria. So they're cut across the whole world, but I'm sitting here in Lagos State and functioning from here. So it's an advantage if we can just plug into AI systems or using AI tools and other emerging technologies. Now, speaking to the fact of who needs to be responsible for AI systems, I think I would fall in line with how the EU has structured their own regulation to say that if you are putting out a product, depending on how the level of risk that that product poses to the public, you will be held accountable based on the level of risk that the product brings to the economy or society or to people. And so that's where the level of either penalties, fees, or whatever punishment is being levied out to the organization at that point. So I'll fall in within those lines. Anybody manufacturing AI should be held responsible for it to a certain level. But then, obviously, we can look at the US-based approach as well, which would deal with each case per circumstance. So it depends on the facts of the case, depends on the individuals in the case and exactly what has gone wrong, and then courts at that point to decide who will be held responsible for the misgivings or negligence of the AI in particular.
Very well. So your view is that the manufacturers of the AI should be more held liable rather than the lawyer using it. Dr. Ahmed, is that also your view for that question?
In what space are we talking about?
Depends.
So like the lady said, you have a client that has approached you in your Nigerian law firm. Represent me. I trust your expertise. I trust your specialty.
Right.
And the client onboardings everything that is wrong with them on you, trusting that you will do, justice to what the person has come for. And at the end of the day, you fail or outsource it, and then you want to blame AI for it. What was the contract, what the perimeter of contract? Was it between you and the client? I mean, the client and the lawyer? Or, at that point, the client is possibly not even thinking of the AI aspect. Okay, so maybe a way to come out, we are not putting down the regulation by the EU, but maybe you should have your client sign consent forms.
Okay.
That in the event that I need to go use AI as an assistant, that you will not sue me where AI has done otherwise. And then even that would have its issues, because what about the issue of confidentiality under Rule 19? It says do not divulge. Okay, it doesn't say do not divulge to, it doesn't qualify divulge to a person, just do not divulge. So by the time you begin to feed the AI, the issue of confidentiality will not come up. That's my take on that. Yeah.
Thank you very much, Doc. The last word.
Yeah, so what my good friend and classmates raised is germane, but there's AI for AML, CFT. You have in-data labs that's working on KYC requirements. There's AI for everything. I think it's that simple. We're only talking more about generative AI because that's what relates more to us. But there's AI for everything. In fact, I spoke to a doctor who is developing a product for that helps people age backwards, right? Dealing with AI. AI is data, and all AI is doing is picking all our data, processing it, and churning out information based on the data we have. So there's AI for that, right? But I want to also jump in on the conversation about that Mrs. Ikwagu has raised. Let's not forget the emotional intelligence and human component to the services we provide as lawyers. So it is utterly irresponsible, and if I may use a word, disgusting, that you obtain a document from AI and you send it off immediately. Utterly irresponsible. What's the proper thing to do? You churn out your document from AI and then you use expert knowledge. AI has done a summary for you. You beat it in and out and then produce a document that is fit for purpose. That has got no business with your clients, right? And then we've got to read the fine print. A lot of us sign up to a lot of apps without reading the terms and conditions. That's something we do not read. If you read the fine print, a lot of these tech companies have very, very clear non-disclosure clauses, indemnity clauses that you sign up to the moment you start using their apps. We are in the forefront.
So if I tell the AI to generate, like the example of Baba Jimmy gave, to generate the list of cases that Supreme Court has struck out this application or that application, and it gives me 20 cases.
Yeah.
Are you saying I have to go and read those 20 cases all over again just to confirm? Then what is the usefulness of that AI?
No, so
it has narrowed it down. It has narrowed it down for you.
Yeah, thank you, Baba Jimmy. From 5,000 cases, from 5,000 cases, it's giving you 20. It behoves on you to check the citation for those 20. Now, what happened to the New York case was very simple. If they only did a cross-check with the citation, they'll find that it was false. And what happened was that they were before a diligent judge who decided to double-check the citation, right? And if you go on the internet, there's so much on the internet. The good, the bad, the ugly, the truth, lies, false, fake, so much. And AI is processing all this data.
Very well.
And if I may add, you ought not use general public AI systems for legal work. There are specific AI systems for legal work. So if you were using the specific system, it would be definitely more reliable than a public open system like ChatGPT.
All right. So ladies and gentlemen, thank you very much for your attention during this session. Can we please put our hands together for the speakers once again? Thank you, and thank you. Dr. Hamid, Director Academics, Nigerian Law School. Mr. Babajimi Ayorinde, Senior Advocate in Waiting, if I may say. Mrs. Ogunshaki, what is that? IT legal expert. And Omorui, are you a legalpreneur or entrepreneur or techpreneur?
I'm a lawpreneur. And a tech lawyer.
Thank you very much.
Thank you. A round of applause for our panelists. I think the message today is that better tech is coming, AI is coming, and try and get ahead of it.
AI is not coming, AI has come.
Sorry, AI has come, but better AI is coming. I mean, you look at it from the point of view that at one point in time, you had something called a Sony Discman, where you could play only one tape at a time, and now you have the iPod. Or at the time, you had only the BlackBerry where you could chat, and now WhatsApp has come and has disrupted. So round of applause for our panelists. Thank you so much for the very insightful session. Yes, so we'll take the pictures first before the presentation. After the pictures, Mrs. Odua would help us with the plaque presentation. Thank you, Kola. That was very, very insightful. Thank you, Dr. Hamid. Kola, I think you should be in front. And not for only height reasons, but because you were very instrumental in this. Thank you so much. Omori, I think you should be somewhere more prominent. Omori, are you able to sneak into the middle? It's a tech t-shirt. Thank you so, so much. We'll have the presentation by Mrs. Stella Odua.
Baba Jide Ayorinde, Baba Jimmy Ayorinde. This is from the MBA Lagos branch, saying thank you to you for a wonderful presentation.
Thank you very much. Thank you.
Amoroye. Thank you so much. Yeah, from MBA Lagos branch. You did a very good presentation. Good work. Thank you so much.
Thank you, ma'am. Thank you.
Olubukola Ogushaki. Thank you for coming and for making us better knowledge. Thank you so much.
Thank you so much.
Dr. Titi Hamed, lecturer from the law school. Director Academics. Thank you so very much.
Thank you very much.
Dr. Kolawole Mayomi. Dr. AI, or which of the doctors? Thank you so very much for coming and for anchoring it so very beautifully well. Thank you so much.
Thank you very much, ma'am.
Thank you.
Thank you, Mrs. Joyce Odua. And to our panelists, thank you so much. A round of applause. Let's just have a final picture with just the panelists, please. Do you need the... Can we darken the screen behind, please? Thank you. A round of applause. That indeed was an interesting session. That's how to handle the final plenary session of the day. Kept us all awake and engaged. And we have come to the end of today's session. Times like this present us with an avenue to network with our friends. And please, 9 a.m. sharp tomorrow. Would appreciate that everybody's here on time. Enjoy the rest of your day. Thank you so much.
Keynote.com.
Please, we are starting at 9 tomorrow. Would appreciate that you're here by 8:30, 8:45 at the latest. 9 a.m. sharp tomorrow, please. Thank you.
Please, members of the Law Week Committee, we need to spend 5 minutes together now. Members of the Law Week Committee, thank you.
I'm trying, supposed to do. Skip my Anna. Oh, Electra, your meaning no trenches. Make my money buckle, make my money plenty. Oh, Electra, your meaning no trenches. Make my money buckle, make my money plenty. I don't call my mama, she don't bless me. She don't bless me, no man fi contest me. As I don't call my mama, she don't bless me. She don't bless me, no man fi contest me. Oh yeah, they try to feed the boy. They wanna see the boy. London city, every city got to be the boy. I know them sexy ladies wanna eat the boy. Smart dance boy, oh clever boy, blessings forever. Oh, Electra, your meaning no trenches. Make my money buckle, make my money plenty. Oh, Electra, your meaning no trenches. Make my money buckle, make my money plenty. 'Cause I did, a short day, money day, bongba lori me all day. 'Cause I did, a short day, money day, bongba lori me all day. Oh, Electra, your meaning no trenches. Make my money buckle, make my money plenty. Oh, Electra, your meaning no trenches. Make my money buckle, make my money plenty. Nobody go there, nobody go there. Where money no there. Oh, Bata, Keyon lo ma ku. It's a lie. My people believe me. Joma when I drop my song, phone kept for 20 years. Everybody say I sing past a shade. Spyro, you be the best, you be the chief, you be King Kong. 'Cause that time small, rabade. 2020 came the rainy day. All the time that me and Sakpade. Where the people where they hype me, where they side me, I look around now only Kunle day. Mama told me never trust people, they evil. People got issues, so know them by the way they try to diss you and beef you. Oh no. If you get the money, brother, spend them, live your life. And if you buy today, another man go take your wife. This life where we get too short and you guys realize. Nobody send you, brother, make you live your life. Nobody go there, nobody go there. Where money no there. Oh, brother, Keyon lo ma ku. It's a lie. My people believe me. Oh, my God, Keyon lo ma ku. It's a lie. My people believe me. If you try me, you gon' lose. No, you can't fuck in my crew. You know I don't pay my due. Steady on your TV, breaking them news. Stay, I ain't got nothing to lose. I ain't got nothing to prove. You can never fit in my shoe. Steady getting paper, I got no excuse. When the going go low, all the niggas go cold, and the ladies go low. Only when you spend dough. Let the conversation about what's up. Money plenty me, I must do that shit. Only thing with them, I'm an ass. I know when you give myself a shot. So no. If you getting money, brother, spend and live your life. And if you buy today, another man will take your wife. This life where we get too short and you guys realize. Nobody send you, brother, make you live your life. Nobody go there, nobody go there. Where money no there. Oh my God, Keyon lo ma ku. It's a lie. My people believe me.
When you can't she crow like baby Jeremiah, you can't get out crow like going down.
Them never see nothing, I go see something when I tap at the club, you go down.